Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Proctor and Gildea'a. Ridiculous that insanus. Oy vey, Marcus. Pro said, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, everyone. Hello, my friends. Happy Friday. It's Freaky Friday today. Today's a U.S. federal holiday. Tomorrow is actually the 4th of July, but today is the federal holiday. Many people have off from work. Many people do not. I'm sure my nurses are out there working. Sure. Well, the mail carriers are off today. 18-wheelers probably working today. Tell me if you're working today and where you're working from, and if you're staying cool, because today in New York, it's going to go up to, I think, something like, with the heat index, 112 degrees. It's hot. It's steamy. Stay cool. Hopefully I can keep you company for a little while today while we talk about some of the craziness that's happening in Massachusetts and some of the craziness that has happened in Massachusetts. If you look up in the corner of your screen there, we have a little rubber ducky dressed in a handmaid's outfit that was curated for me by an amazing viewer named Jamie. And I think it is very, very appropriate for some of the stuff that we're going to talk about today. What say you? I love it. Thank you, Jamie, for making that for me and sending it to me. Melanie, also, thank you for your Cash App for coffee today. I'm going to need it. I'm absolutely 110% going to need it. Kyle, I took care of you. You're all good. I fell into a rabbit hole. After Judge Gildea said that the courts should not be a spectacle. And many of you fell into the rabbit hole on his speech the other day. Some of it was pulled from a freshman news article, I think from, I forget where, maybe Brandeis University. It's wild, but he doesn't want the courts to be a spectacle. But what he's forgetting is that mass courts have been a spectacle since 1692, when 200 people in Salem, Massachusetts were accused of witchcraft, leading to the deaths by hanging of 19 of them, both men and women. And what is wild that I found out in my shallow dive, I want to do a much deeper dive into it, maybe do a whole entire show on the Salem Witch Trials, because it is fascinating to me. There are some original notes, like from court reporters at the time, scriveners who actually were writing down everything that happened in court back in 1692. The location of the hangings for those convicted of a witchcraft. You can't make this up. It's called Proctor's Ledge. Proctor's Ledge was the site of the hangings. Are you shocked? People would travel. There was a route that people would take as they would parade the people who were going to be executed to Proctor's Ledge. And now there's a memorial there because in I guess it was 2016, they finally confirmed that this location was the actual site of the hangings. And now they have little plaques for all of the 19 people who were hung. That is what it's called. Proctor's Ledge is the location of the Salem Witch Trial executions. Can you make it up? I don't think so. Let's look at our motivational quote of the day. We have one for yesterday because I was enjoying the weather yesterday. And we have one for today. The motivational quote of the day for Thursday, July 2nd, which was yesterday, is a quote by Balthazar Gracian, who said, "The wise does at once what the fool does at last." What? The wise does at once what the fool does at last. So fitting. Here's the one. That's from yesterday. Let's look at today's. I'll probably butcher this name, but Friday, July 3rd, 2026. Publius Syrus, Syrus, said, "Anyone can hold the helm when the sea is calm." Anyone can hold the helm when the sea is calm. And you know, when they start ramping up and sending out threats, something's about to happen. That's how we always know when something is about to happen. I have been getting more threats than usual because they're trying to intimidate me. They're trying to shut me up. It's not going to work. We'll find out who's doing it and why. But you can always tell. And if you're also getting heavily threatened, let me know. Shoot me an email. Let me know. It's wild. It's insane. But I guess it's part of the, comes with the territory, right? Ms. Mojo Horizon says, "Please remember, today is the day that Jim Morrison died, July 3rd, 1971 in Paris." I did visit Jim Morrison's grave many, many years ago when I went to France. That was one of the things that I absolutely went to see. I am a huge Doors fan too. Love Jim Morrison. Ms. Mojo Horizon is reminding us of that. And he died at the age of 27. 27 years old. Thank you, Elf, for gifting a membership. Candy Cane, happy 4th of July. Well, tomorrow's the real 4th, but yeah, today's the holiday. Happy 4th of July. I'll probably see you tomorrow too. Because, you know, got to beat the heat. Come in for a little while. Thank you, Scott. You know what to do. Oh, please. Thank you, Candy. Babes on 1, thank you for your 10. James Lynch became a member. Welcome, James. You've been here for a long time, though. Laura says, ironically, it's only 100 degrees with 6% humidity in Scottsdale and Phoenix. Come over and get a break from the heat in Arizona. I love Arizona. It's dry heat. It doesn't feel like it feels here. Here on the East Coast, it's very humid and sticky. It was like that when I was in London last week. But Arizona, Colorado, any day. Nevada, it's hot, but it's not humid, so it doesn't feel like it feels here. Sheila says, one of my ancestors was accused of being a witch. Mary Osgood, we have the original petition to free her. That is insane. That's crazy. All right, let's take a look, shall we? It's going to be like choose your own adventure today because I have a couple of ideas and where I want to go. But, you know, this is like my live stream is like a living, breathing thing. And so sometimes we pivot off and go on to like topics that we didn't expect. And then I have to change the thumbnail, which is awesome. I mean, which happens often. Today is the day of the royal wedding of New York. It is the royal wedding of Taylor Swift and Travis Kelce. And I'm so invested. I'm so invested. Fox 5 here in New York, I think, and also the AP have cameras out all day long. It's just, you know, like an all-day cam, just watching the garden, Madison Square Garden. Last night, Madison Square Garden was lit up in lavender, you know, lavender haze. If you know, you know. I'm going to be on with Billy Bush on his channel on Monday to debrief all things Karen Reed and also the Taylor Travis wedding. Hopefully there's going to be some pictures out by then because I just cannot wait. I just cannot wait. I'm so happy for her. I'm so happy that she's happy. And I'm so happy that she found her prints. And I can't wait to see how they transform Madison Square Garden into a castle. And there's going to be, I think, 1,100 guests or something. Last night they did a more intimate dinner for 100 people. And Madison Square Garden is locked down tight. And it is it's tented so that even when like the big SUVs pull in, they're like in a tent. Nobody can see who's coming in or out. In the beginning, I thought, why the hell would they get married at Madison Square Garden or have their reception there? People think they're already married, but it makes total sense. It makes total sense. You can lock that place down. There's a bunch of different entrances. And a really good wedding planner, which I'm sure that she has, I forget the name of the person that she hired to do this, can transform the hockey rink of the Rangers into something completely and totally different. And I'm here for it. I'm here for every minute of it. I saw a video. Megyn Kelly and Maureen Callahan did a video last night. It was so Mean Girl. I mean, I couldn't believe it. I couldn't believe it. Like, this is a trailer park Taylor and Travis this week gave $26 million to charities all over the country. $26 million right before their wedding. I mean, give me a break. It was amazing. No phones, NDAs have been signed. I can't wait to see the pictures. And what I hope they do is I hope they sell the pictures to the highest bidder and then donate the money to charity, because that happens a lot. Didn't that happen with, like, I don't remember if it was baby pictures when Brad and Angelina were together, wedding pictures. I hope they do that. And so I'm so happy for her. She finally found her prints. Why can't people just be happy for people? 20th Century Fox, RIP Jim Morrison. No ruined years, no clocks. 20th Century Fox, thanks for being here 22 months. Charlie Blue became a member. Makazi G became a member. You've always been a member, though, right? Craft Haskell, happy Friday to you, too. I appreciate you for being here for 8 months. Leslie Raymond says at the gym listening, happy 4th, everyone. Could you work out for me, too? Could you do a little workout for me while you're there? Give me 40 minutes on the Stairmaster and call it good. Thank you. Or the elliptical. Do the elliptical. It's better for you, niece. Happy 4th. Peach is gifted a membership. Thank you so much. B May 28 says, do judges have to take continuing ed classes? That's a great question. I don't know how they do it in Massachusetts. I don't know. I mean, lawyers are required to take CLE every 2 years here in New York when you register. You have to have, I forget how many hours, 28 hours at least. I don't remember. You can do it online now and then just fill out the papers. I'd assume so, but I think there's a need for them to be educated on social media, AI, metadata, etc., and not only law-related update. I know that is what is so wild about the conference from the other day. The more I digest it, the more insane I think it is. That the judge was that called in all of these people. I forget what the final count was of attorneys that showed up in court 2 days ago on Wednesday to just be publicly spanked and to hear a little God bless America speech and about how courts shouldn't be a spectacle. It's insane. It's insane. Paul says, hot here in Massachusetts, but vibing and chilling. Melanie makes a great day. Oh, thanks for your 5, Paul. Charlie says, 4th of July is my birthday. Happy birthday. 63 years old. Yay. You're not old. Age is just a number. It's just a number. Thanks, Charlie, for tuning in from Australia, and Susan gifting 5 memberships. I want to take a look, if we can. Let's do it again, because I just want to hear a little bit of his Judge Gildea's speech to set us off on our course. Of course, somebody found the exact quote. It was like a drama queen tantrum. And somebody also pointed it out. Michael Proctor's deposition, the half-day deposition that was done before I don't know if he had a panic attack. I don't know what happened, but it didn't start until something like 12:30 and it ended at 5. That was June 25th. And then the judge found out about Michael, the leak or whatever alleged leak, the very next day. The whole thing is sus to me, and I think it's kind of wild. I saw Ozzy debunk the tweet timing. I don't know about any of that, so I'm not a forensics expert, but I may become one. Here, let's take a look. Courtesy of Trial Channel. Shout out to Trial Channel, as always, for doing the Lord's work. Here's Judge Gildea taking the bench because we need to hear this again because the spectacle that happened in 1692 is the way that Massachusetts courts started. And when we go back and look at the Salem Witch Trials and then look at the things that are happening today, specifically to many of the women whose cases that we've covered, it doesn't seem like much has changed. Does it? Thank you, Child Channel. We love you. All right, let's listen to his little speech again. It was a hearing where no one could be heard. No one was allowed to speak. It's insane. That's why we got the Handmaid's Tale rubber duck over there in the corner. Because that's what this is like. Here we go. Here's when the judge took the bench 48 hours ago. Not even 48 hours ago, because it was the 3 p.m. conference. Here we go.
This court now says, we proceed.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, civil action 2483 CV 0692. This is Paul O'Keefe individually and his.
Oh, look what Child Channel did. They put the Zoom screen on combined into this screen. This is amazing. Okay, so this is why the judge says, Alan Jackson, it looks like you're getting some free publicity because the 3 attorneys from his firm who were on Zoom are sitting behind the big logo in the conference room that has the name of the firm on it. But here's the thing. Those of us who watch this on mainstream media, like me and you guys, were not on the Zoom, so we didn't see that. So when he made that comment, it seemed a little out of pocket. And we were like, what are you talking about? Right? And this whole like taking attendance thing, everything about this was bizarre. Oh, I see Lori Mullins, you're here. She's a Massachusetts attorney. Tell me if you think this is insane too. All right. Now we can see the Zoom screen as well. Let me make myself a little bit smaller so you can see it a little bit bigger. Here we go.
Personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC doing business as CF McCarthy's et al. Your Honor, with your permission at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Daly.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Yes, Your Honor. Present.
Present, Your Honor.
Jackson's getting some free publicity as well. For
Attorney Jackson. Present. Attorney.
That's why he said that about the free publicity. And we were like, what? What?
Hellickson.
Present.
And Attorney Rosenberg.
Present, Your Honor. You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One comment.
I muted myself when I was not muted. Here's when he found out. So this hearing was Wednesday, July 1st. He says he found out on Friday. That was the 26th. Wasn't Proctor's deposition on the 25th? Wasn't it? I think so. It was, right? So he found out about this on the 26th. Well, that's really interesting timing. And I want to point something out too. Do you remember when he says he was advised of last Friday, the 26th? Who advised him? Who advised him? What was he advised? This should be filed with the court and it should become part of the court record. Okay. Do you remember how Kate Peter, the not so confidential informant, AKA Masshole Mafia or Mafia Masshole on Twitter, the one who hates Aidan Kearney more than any person in the entire world, admitted on a podcast that she sent Aidan the email that Colin Albert was a drug dealer and admitted to making it up because she wanted to trick him into reading it on the air? And he did, but he said he didn't know where it came from, and it was like a tip. He didn't know if it was true or not. Do you remember? And then what's interesting is that on June 6th, Aidan did a show and he got another email. And he read another email that he got and said, I don't know who this is. It's a source. Larry Foreman, DUI guy lawyer, apparently got the same email. Both of them. Larry posted it on social. Aidan talked about it on his show, but he said, I don't know if this is true. Like, I'm just telling you what I got as a tip. What are the odds that maybe somebody was behind that to see if they would run with it, publish it, and then they could use it as an excuse so that Proctor wouldn't have to repeat his deposition. Scott, make sure to screenshot everything. And then like the block, but make sure you screenshot everything. You know what to do. What are the odds of that? In an effort to get Proctor, because this is wild. I have never seen a judge threaten that he would preclude all discovery of a witness because of something that was allegedly said on social media that may or may not have been his private information. How did he find out? Who advised him? What was this alleged tweet that he says that he saw? And I'm not going to get into the whole timestamp stuff. I don't care. I don't care about any of that stuff because we don't know for sure what it was until the judge tells us what it was. So people can speculate from here to kingdom come, and it's not going to change my opinion. It could have been deleted. Did some crazy person email the judge with a screenshot of something and say, oh, this is exactly what was in, because people who are close to Proctor's family know where Proctor is, people who are in the inner circle, and whoever sent this email to Larry and to Aidan both said, I don't live in New York City. I never said I did. If you listen to the flipping, these people come in, this is what I'm talking about. Thank God for good PIs is all I can say. Loophole Lawyer is out there. He's got 1 million sock puppet accounts. The guy's a troll. And he's also an attorney, which is wild to me. Let me just sidetrack for 1 second. He's a troll. He's been trolling many other people, not just me. He's a lawyer who handles FINRA arbitrations, if anybody knows what that is. It's like arbitrations with like SEC, stockbrokers, Wall Street people. He's got an active law firm. He's admitted to practice law in New York, and that should frighten the flip out of you. And he's got a whole posse of minions from this Howard Stern Dabbleverse that are out there trying to take us all down. Okay? I know you're listening because you watch everything I do so you can clip it and then use it in your own content. You actually have me narrating many of your own videos. But the threats, the doxing of my personal information and my children's personal information needs to stop. So either you or your minions, there's another one. I know, we know exactly who you are. Thank God for good PIs. 1 second. But Scott, just screenshot everything and then we're going to forward it on. Like, do you think you're funny? Do you think the Bar Association is going to take kindly to your doxing of another lawyer and her children and her home address and pictures of her house? Do you think that's funny? Do you think it's acceptable? I don't know who this guy thinks he is. I can't block chats under $5. It's not a thing. I can't do it. I can't do it. But he's admitted to practice in New York. He's got a New York office. He's got a partner. He's got a law firm. And he's going to be dealt with. I'm not the first person he's done it to. I won't be the last. And it's disgusting what you're doing. It's disgusting. With your $2 super chats, you cheap SOB. I don't know him. Oh, how do I know it's him? Because we've got ways. He's telling everybody where I live. He's telling them my address. He's telling them my children's last name. He's telling everybody everything. Any place that he can put it out there. I don't know where he lives. I don't care. But I'm putting you on notice right now. Guide your actions accordingly. Guide your actions accordingly. I don't live in New York City. Do you have ears? Do you have ears? She lives near New York City. Do you have fucking ears? Go back and listen to the intro again. And get off my channel. Yep. He's coming in here to disrupt my chat, to disrupt my channel, to distract me. Because now I gotta go back and like, it's enough already. It's enough. It's enough. You've been coming after other women on YouTube too, haven't you? Other women. Your disgusting behavior on Samantha Benigno's channel. Samantha Benigno's channel, and your creepy streams with Emily C. And what happened to Judy, the girl that you used to do all of your YouTube stuff with? Where'd Judy go? Did Judy figure you out too? You're a disgusting POS who started out having something to do with Howard Stern. And it figures. I guess that didn't really work out for you. But do you really think that your Wall Street clients would be happy to know what you're doing on the internet? It's wild to me. It's wild. I think I'll turn off super chats. Hold on. Give me a minute, because I'm not dealing with this bullshit again today. Scott, if you're able to be here and you're able to be on it, just screenshot everything. Yep. He's scrambling in and out of accounts right now. What a loser, says Emily C. Judy dumped him. See, and you got to disrupt the whole class. You got to disrupt the whole class to tell everybody how old I am and where I live and my last name of my kids. He's a disgusting pig. A disgusting pig. Yeah, I turned 60 this year. Big whoop. Everyone's going to turn 60. Guess what? Who cares? Nobody cares. Stop putting pictures of my house and my home address on the internet, okay? And pictures of my kids, you disgusting troll. He's disgusting. He's absolutely effing disgusting. Thank you. I have 5 kids. I've earned every year of it. I've been a lawyer since 1992. You can look it up because I know you have. You've looked up everything about me so that you can use it. I know. I see you. And you're a disgusting troll of a human being who is spending way too much time trying to dox me and my children, and it's not going to be tolerated. Age is just a number. He's disgusting. He's horrific. And the things that he has done to other women who don't even speak about it on YouTube, I'm not shutting up anymore. Loophole lawyer Vincent BC, New York barred lawyer. You think the grievance committee is going to look kindly on what you're doing to me? I don't. Doxing another lawyer who's also barred in New York, we're not going to go well for you. So take all your shit down. Take everything down from your sock accounts or face the ramifications. Let the grievance committee deal with you because I'm done. I'm done dealing with you. Vincent Bisi, IMBESI. He's a creep. Why has he been pointing I'm gonna take this down for a minute. Why has he been pointing the finger at Brian Higgins this whole time? Ask yourselves that. Ask yourselves that. Why has he been pointing the finger at Brian Higgins this whole time? Who does he work for? Anyone? Did anybody watch the show that he was on with his friend who went to the Juneteenth fundraiser? That was a creepy show. John Camo of Canton Confidential. Is it Canton Confidential? John Camo's channel gave him a platform. Anybody see that show? That was pretty creepy. Anybody see the way that he speaks to women on shows that he's on? Creepy. He thinks he can use the N-word because he says his father dated a Jamaican woman. Yeah. A lot of people think he's a plant. I wasn't going to go there today, but since he sent his trolls and his sock accounts in here with their $2 super chats, it's pretty obvious that he's not going to shut the fuck up. Clip that, Loopy. Clip that for your next content. Maybe you could be like, I don't know, creative enough to make some of your own content. I'm done with you. I'm done. Thank you, Karen DePasquale, for giving 10 memberships. You're amazing. You're amazing. Print that. I've been a lawyer for over 30 years. It's not hard to do the math. You graduate from law school when you're 25. Do the fucking math. I'm 60. Big whoop. Big whoop. So are you. Somebody said he's a loser. Oh, Lake Winnie. Are you at Lake Winnie right now? I love Lake Winnipesaukee. Somebody said he's the loser that deserves no more of your attention. No, he does. He deserves all of the attention because everybody needs to know what a disgusting pig of a human being this man is. Everyone needs to know it. Everyone needs to know it. Nobody is safe. Print that. Jolene, if you're out there, do a show on Loophole Lawyer and his passive aggressive bullshit and how he's got 200 sock accounts, doxing people, not just me. Find out who he's working for. Because you'll probably be next. He's been getting away with it for way too long. He really needs to get a life. Like, I get it that you're off today, probably, because you're not doing your FINRA arbitrations today. I wonder if your law partner knows what a pig you are. How does she even work with you? Do you hassle her too? He's got a female partner, which is wild to me. So you're all on notice of this guy. I don't even know him. Never met him. Never had a conversation with him. I think he asked me to come on his show once. I watched some of his content. I was like, no. But he uses my content all the time in his YouTube presentations that are just pre-recorded videos that he puts out there. And many of his videos, I'm the one narrating. He uses me reading documents. He uses my face. He uses my voice. Whenever I curse, he clips it and puts it on there. Talks about how classy I am. He's been sued for doing this before. And I'm done with it. I'm not taking it anymore. A lot of you can't stand him. You're not going to rattle me anymore. You're not. Because trust me, you're fucking with the wrong girl. You are. And there's a couple of other girls you're doing it to, too. And there's strength in numbers. I have grave concerns. Stay away from me. Keep my name out of your mouth. Keep my address out of your mouth. Keep my kids' pictures out of your mouth and off the internet. Because you're disgusting. And everyone knows it now. Why don't you make a video defending yourself? Why don't you make a video denying it? Okay? You've got the whole holiday weekend to work on it. Disgusting. Okay? Rant over. Now we can go on with the regular show. Because this is what he's trying to do. No, I'm not going to stop giving him attention. This is it. This is my rant. This is my show. I'm going to do whatever I want. Everyone needs to know about him. He needs to be exposed. Okay? He needs to be exposed for the pig that he is. Thank you, Austin girl. Winners focus on winning. Losers focus on winners. And private investigators find out everything. Let's go. Taking it back. Show is finally starting at 38 minutes. You've been warned. Let's just get to his speech. I mean, are you trying to prevent me from going live ever again? Because you and your trolls come in here with your $2 super chats to dox my address and my kid's last name? Really? Is that's how you operate? Go F yourself. Here's Judge Gildea.
So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function.
Quiet solemnity of the courtroom. Really? Is this a solemn occasion? It's a circus is what it is. You've got, I forget how many lawyers in there now, 20-something lawyers in there, spectators, parties, a camera, a television camera, and you're calling everybody in here so they can have a little church moment? Flying him in from LA? How to get you all in the same room so I could publicly spank you in front of the TV cameras, but I don't want a media spectacle? Okay.
One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order.
All right, so here we go into the 222, which is ironic because that's the exact same time, although it was AM, that Brian Higgins and Brian Albert butt dialed each other while Brian Albert was doing the nasty with his wife Nicole in his bed, as he said. Butt dialed and butt answered each other at 2:22 a.m. So ironic, isn't it? I mean, you can't even make these numbers up. Good thing we have the angel numbers book here. And then he says exactly 30 minutes later, somebody tweeted something.
The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded.
Similar information? Okay, well, thank you for verifying that everything that Aidan Kearney said on his show 2 days before is true. He got a tip or a planted email that Michael Proctor was in Florida in some kind of inpatient mental health treatment and that he and his wife had separated. Thanks for confirming the truth of that, Your Honor. So by having this public spectacle of a hearing, you're actually confirming the truth of it. He says it was a person who is not a party to the case. I don't think he said it was an attorney. Let me hear that again.
The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing.
Similar information. Okay, so you've now confirmed that Michael Proctor is inpatient in Florida somewhere? But it's funny because you didn't believe that when you got those papers, and you did compel him to appear the next day for a deposition. So if that's true, he was going to fly up from Florida same day, like, I don't know.
And marked provisionally impounded was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8th, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the.
Okay, so all the lawyers said that they didn't do it. Okay, but you still called them in anyway, based on what, a rumor? Based on a tweet? Really? Based on a tweet? And you're not going to even tell anybody who tweeted it or where you got it from? This is so improper. This is so improper. Judges, just like all lawyers, are supposed to avoid the appearance of impropriety. So based off a tweet, I mean, you might as well go to Reddit for your legal theories at this point, like they did in the Maya Kowalski case.
Parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded. Orders of the court had been violated either directly or at the very least in spirit. If the
How do you violate an order in spirit? How do you violate an order in spirit? Maybe one of Proctor's family members was gossiping to their friends about where he was and what he was doing. And people talk, Your Honor. You can't control everyone in Canton. Remember that old Herbal Essences commercial? I told two friends and they told two friends and so on and so on and so on. I mean, it's a good thing he's talking about spirits because we're going to talk about the Salem Witch Trials after this. So kind of makes sense, right? Somehow an ex-account holder, somehow. Nobody published the actual filings. People talk. Gossip happens. But now you're proving that what was out there on the internet was actually true by having this hearing.
parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Not a party to this case. Okay? Not a party to this case. The parties to this case are Paul O'Keefe, John O'Keefe Sr., Peggy O'Keefe, and the niece, Karen Reed, the Waterfall, and McCarthy. So not a party to this case. Okay? What is interesting is that this judge is also assigned to the defamation case. Okay? Not this case that they're in court for today, but mysteriously, he was also assigned to the defamation case that was filed in Barnstable County by Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert. They needed Brian Higgins for jurisdiction to file it in Barnstable County because the other three live in Norfolk County. And God knows they did not want to be in Norfolk County because the jury pool knows them in Norfolk County, right? So the defamation case is filed against Karen Reed and Aidan Kearney in Barnstable County, and then it's mysteriously plucked out of Barnstable County by the head judge and assigned to this judge in Plymouth County. Okay? So if the person who actually leaked this, according to you and your source, who you will not name, and the tweet that you will not identify, so the attorneys have no idea what you're talking about. How can they prevent it in the future if they don't know what you're talking about and it had nothing to do with them? But my thoughts are that if it had anything to do with Aidan Kearney, he absolutely would have said it. He absolutely would have put him on blast.
Orders of the court had been violated either directly or at the very least in spirit.
Or gossip. Or a very carefully curated ploy to get Proctor out of appearing for a deposition again. Or a fake email from somebody named Kate Peter to Aidan Kearney and DUI guy Larry Foreman, because this is not her first rodeo, okay? She's the one who started the rumor that Colin Albert was dealing drugs. She laughed about it on some guy's podcast a couple years ago, admitted it, and said she just sent it to Aidan to see if he would run with it and not check his sources. And he did. So Julie and Chris Albert can blame Kate Peter, the not so confidential informant, aka Mafia Masshole, for starting that rumor that Colin Albert was a drug dealer. And yet she's still throwing fundraisers for these people. Okay. She also filed false federal documents in a YouTube dispute with Aidan Kearney. She took a fake federal lawsuit, changed the names, and sent it into YouTube as her evidence that she had started a federal lawsuit against Aidan Kearney for, I forget what, remind me, copyright infringement, I don't know. But in her infinite intelligence, she forgot to scratch off the index number, which showed that it had been filed years before and was fake. Okay? So it's not the first time that people have tried the deep fake on you, Judge. It's certainly, or have in this case, in this particular case, and it's not going to be the last. But imagine calling all these attorneys into court for this public spectacle based on what?
If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rule.
Integrity. It's wild to me that this is a hearing about Michael Proctor and Michael Proctor's personal medical information, and you want to talk about integrity and confidential medical information and Michael Proctor all in the same sentence. Remember Michael Proctor's text messages about Karen Reed and her medical conditions read out in court twice after 2 persecutions of Karen Reed? Remember that? Your Honor, have you read the federal lawsuit? I mean, not the federal lawsuit, but Karen Reed's lawsuit against against the town of Canton and the Massachusetts State Police? And all of the racist, anti-Semitic, misogynistic text messages of Michael Proctor? And you want to talk about integrity when it comes to Michael Proctor? And then you're going to threaten to pull the plug on any further deposition of Michael Proctor? This is insane.
Rules of impoundment procedure imposes a duty on all persons to protect the confidentiality of impounded material.
Right, and each one of these lawyers and parties in the case has filed a sworn statement saying they didn't leak anything and they don't know who did. Okay? It's all been done. It's all been done. It's a great Bare Naked Ladies song. It's all been done before.
Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
He has a written statement. This is like the hostage video from Michael Morrissey. Maybe you should slap a gag order on Michael Proctor's wife. I don't know. And sister. I don't know. Blaming the lawyers with zero proof.
Disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the
under his eye, there's the Handmaid's rubber ducky up there. We have Princess Diana rubber ducky too. She's our classy rubber duck that I got in London last week. Ooh, is she cute? Lady Diana in rubber duck form, because that is the insanity that goes on in Massachusetts. If you didn't watch my show about the rubber duck investigation, little rubber ducks, about this big, the minis, were placed around Canton. Some of them outside D&E Pizza. They had little stickers on the bottom that said Colin did it. Some of the little rubber duckies had stickers on them that said IYKYK. there was also some monopoly money that was stamped with justice for John O'Keefe, and Colin did it. Littered around Canton and other places. The Canton Police Department did a 38-page police report on that. They did more of an investigation into the rubber ducky gate than they did into the murder of a Boston police officer. It's real. It's horrific. It should frighten the hell out of you. Because Chris Albert wanted this person prosecuted. Rich Schiffer. They downloaded his text stream data from his Toyota Tundra. I forget if that was the exact truck that he used. They brought the forensic team from the Norfolk DA's office to his place of work, Canton Fence Company. Buy a fence from Rich Schiffer if you need a fence. They went through his garbage, found some envelopes from a place called makestickers.com. They got warrants for his orders to find out that he was the one who ordered the stickers. When they went into his truck to download his text stream data to find out if he was in the area of where these monopoly money bills were found, they saw open in plain sight a box of little rubber duckies. And did they prosecute him for some felonies of witness intimidation? Oh, yes, they did. Did it get thrown out and maybe he paid a fine for littering? Yes, he did. But they did more of an investigation into these rubber ducks than they did into the Boston police officer murder of John O'Keefe.
Disclosure of and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party.
Right. He doesn't even mention Michael Proctor's name, but it's Michael Proctor. So you have stayed discovery against Michael Proctor. They only got in 4.5 hours of a deposition. I don't know if they took a lunch break. So 4.5 hours. I don't know how many breaks they had to have because of possible panic attacks or, a need to collect himself and get a drink or whatever, put his head between his legs or breathe into a paper bag. But clearly the deposition of Michael Proctor is going to take far longer than 4.5 hours. And so now this judge has stayed discovery of Michael Proctor, even though it's like he did an about face. Even though he got these affidavits in or whatever they were, whatever his proof was that he couldn't come to his deposition and didn't buy it and said, whoever filled out this stuff, doesn't have the proper credentials. So he's got to come tomorrow, right? That was like, I don't know, beginning of June. And then Reed's team was like, yeah, we can't do it tomorrow. And I flipped out about that. I'm like, you got to get this deposition in quick. Got to get it in before something happens. And now this judge has done an about face and he has said, I'm halting any further discovery on Michael Proctor. So whatever date they pick for his future deposition is not going to happen. And listen to what he says about if necessary.
Information. I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30.
Permanent? Oh, really? You're going to call off any further discovery of Michael Proctor? Based on what? Based on a crazy email from a person the day after the first deposition day of his? Accusing someone of leaking his private information all the way back on June 8th? And you get this mysterious email 3 weeks later from God knows who? Did you vet it? People think somebody got to this judge. This hearing makes it appear that I don't know, and I'm not accusing anybody of anything. Something is going on here. Something is rotten in Plymouth County, just like Norfolk County. So you're prepared to make an order against Michael Proctor giving any further deposition or any further discovery permanent? This also makes me think, because, we all have analytical skills. Some of us do anyway. What does Michael Proctor know? What are you afraid of? What is everybody afraid of? Is Michael Proctor, did he have a panic attack? Is he about to flip? Is he about to tell everyone where all the bodies are buried? Does he have a lot of state secrets in his pocket? Because as of right now, Michael Proctor is the fall guy. He's going down. Him and Sean Good are going down. And they might know a lot more about a lot of other things, by the way, not just Karen Reed's case, like things that have been going on for decades in these counties and in this Commonwealth. Are they getting a little too close to the truth? Kind of feels that way, doesn't it? Kind of feels that way. And I can't even tell you how fast that would be overturned on appeal. Well, knowing what the SJC is like, I don't know. I can't really speak to that. But here's the thing too, okay? In order to win this lawsuit, the O'Keefes have to show that there was a car accident. The O'Keefes have to show that Karen Reed hit John O'Keefe with her car, right? It's a wrongful death case. That is what the theory is of the wrongful death. Karen Reed struck and killed John O'Keefe with her car and left him to die in the snow. That's their theory, right? Michael Proctor is the lead investigator who determined that that was true. And so if you're going to preclude any further discovery of Michael Proctor, not only are you screwing Karen Reed's case, her defense, but you're screwing the O'Keefes. Because Michael Proctor is the one who determined that it was a car accident. So they should be pissed too. They shouldn't be celebrating this. They should be pissed too. They need Michael Proctor to say that it was a car accident to win. Tell me I'm wrong. Right? Somebody said, here's a good one. Mrs. Monty says, what happened with the whole prostitution ring involving politicians and higher ups in Massachusetts? Just disappeared, I guess. Yeah, just went away. People think there's theories out there about Sandra Birchmore having been part of some, trafficking ring. And there's probably a lot more to the Sandra Birchmore story. Oh, and it's funny. I was listening to Emily Baker yesterday while I was gardening. Had her on the speaker, the outdoor speaker. I've never seen her do this. She people think I go nuts on the chat like I did earlier because of the trolls that were in here with their $2 super chats. They've seemed to have taken a step back. But she went nuts on the chat for, not really nuts. She went a little harder on the chat than I've ever seen her get about people speculating about this tweet. She's like, we don't know what it is. Stop it. You're distracting me. I was like, she's pulling a Melanie. She's pulling a Melanie. Oh, please. Did you guys see that? Did you see it? And I was like, see how the chat can be, because I thought she didn't even watch the chat. Her chat can be distracting. To her too. Yes, you saw it. I know. And she was like, stop with the UTC. I don't get, I forget exactly what she said, but she was affected the same way I was. I wonder if she's getting threats too. I wonder. Because we all need to team together. But wait, there's more, because he's going to take this a step further.
To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge.
He's going to remind us about how much authority he has. Who does that remind you of? Judge Beverly Cannone used to do that too. I'm the judge. I have wide discretion. I can do whatever I want. And he's got case law to back himself up, telling everybody that whatever I do or say in this courtroom is going to be backed up by the SJC. Try me. In general, discovery matters.
SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge.
Right, so I can do whatever I want. I can order that no further discovery of Michael Proctor will take place because some rumor came out that he was in an inpatient mental health facility in Florida.
In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass App Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial.
Yes, we know. We know about discovery rulings because you know what else I pulled up for us today? God bless America. Judge Beverly Cannone's order on Karen Reed's motion to dismiss for egregious governmental misconduct, because I think it's a really good time for us to review that decision that was made by Judge Cannone in, I think it was March or April of 2025, right before Karen Reed's second persecution. She never held an evidentiary hearing. And it's time to go back and look at that and look at what we know now based on her ruling then. Buckle up, buttercups, because we're not going anywhere today. Hopefully you're floating around in a pool or at a beach somewhere and you can just put me on audio. A fair and orderly trial. Wild.
In the 1987 case of Salem versus B. Gruel, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge.
Yeah, we know.
In Cronin versus Strayer, 392 Mass 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders.
Discovery abuse? Where's the proof that a law firm leaked this? You don't have any. Everyone signed a sworn statement that they didn't leak it. The papers aren't out there. And if they are, you need to tell the lawyers what it is that they're fighting against. This is wild.
With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the
Appropriate control? How about force these people to come in for depositions? They're like throwing out like 2 dates that they're available. The McCabes and the Alberts. Yeah, we're available for these 2 days. We're available for these 2 days. So that's the only time we can come. We can't possibly make it before, until like the end of July or August. We can't make it. Oh, Aunt BB, thank you for gifting 20 memberships. You're amazing.
The 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever
it concerns you, I have grave concerns too. I have grave concerns about this whole entire sham of a proceeding. This is like a kangaroo court. You've now told everyone that what Turtle Boy reported and whatever came out about Michael Proctor is absolutely 100% true, and how it's malicious. The malicious publication about private information. What about the malicious publication of all the things that Michael Proctor said about Karen Reed to all his buddies and to his cohorts at the MSP and the Norfolk DA's office? Oh, and by the way, Fervent put out a really excellent video today about Adam Lally. Go watch that later. If you haven't watched it, I was on the premiere earlier in the chat a little bit while I was getting ready for this. You haven't shown that it's malicious. You haven't shown what that alleged private information is, but it concerns you. This is like Beverly Cannone's grave concerns, where she had to take a time out. She was visibly shaking. She had to take a time out. She went off the bench to make a phone call, and then she came back, and then she pulled the plug on the whole entire proceeding. Who says it's malicious? Are you in someone's head? You're not even telling us who it is.
Process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual.
Nobody's in this courtroom right now that you're preaching to has treated Michael Proctor in any other way other than he needs to be deposed. And the plaintiff should want his deposition just as much as the defendants do. Okay? So even if warranted, so he's saying Michael Proctor is actually a scumbag. He's a racist. He's a virulent bigot. He's an anti-Semite. He's a misogynist. He hates all races equally. And even if that's true, because now he's telling us that he thinks so true, he thinks so too. Listen to this. Whatever opinion that one may have of a non-party.
That one may have of a non-party, even if warranted.
Even if
such
warranted.
an opinion does not allow.
Even if warranted. Your Honor, you can't stop the internet, okay? Trust me. If I could stop the Twitter trolls, I would. I can't stop it. You can't stop it either. You can't stop the idiots on Reddit. You can't stop it. But you also can't blame it on the lawyers that are sitting in front of you. And you also can't use it as an excuse to prejudice the parties in this case. Proctor is a non-party in this case. Yes, he's a non-party witness. He has been sued by Karen Reed. That case has been removed to federal court. But in this case, he is a non-party, yes.
For the disparate treatment of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent.
Tell that to Karen Reed. Tell that to Karen Reed. Maybe you weren't there, Your Honor. Maybe you didn't watch season one. But before season one, before the initial persecution of Karen Reed, in that kangaroo court in Norfolk County, in my opinion, the feds had been investigating the investigation of the murder of John O'Keefe or something. We're not really sure what they were investigating. But Josh Levy, who was the acting U.S. attorney at the time, was so horrified by what they uncovered during that investigation, including this non-party witness's text messages about Karen Reed, that they did something that they never do. They released over 3,000 pages of their discovery material to Adam Lally and Karen Reed's team. Because Josh Levy said to both attorneys, both sides, on a conference call, in good conscience, I cannot allow the Karen Reed case to go to trial. Here, enjoy. Laura McLaughlin, 24 hours later, said in open court that she's reviewed everything. And that it's like 90% of what they have is everything that they already had. And that it is not exculpatory. Meanwhile, what was in there? Proctor's text messages, the RICO reports showing that John O'Keefe was not hit by a car. So all people deserve fair and equal treatment in our system of justice. What about Aidan Kearney, who's being selectively persecuted by the Commonwealth for knocking on doors and asking questions of witnesses, just like old school reporters do? What about that? Because you hurt some feelings? Because your witness intimidation statute is complete and total. Wait, where's my BS button? Because your witness intimidation statute allows for people with hurt feelings to charge. It allows you to charge people with felonies for reporting. This just makes this whole thing explode even more. And look at, there's over 5,500 people watching here on a holiday, okay? That's how interested people are. The day that I did this hearing and we covered the hearing, there was almost 20,000 people watching. The world is watching and you're making it worse.
Regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit.
Pettiness and profit. Are you watching petty streams in your spare time? Are you watching petty streams on YouTube? I don't do them, other than my rant at the beginning, which wasn't petty. That was 100% warranted. And profit. Nobody's profiting. Karen Reed is $5 million in debt and continuing. Okay. Carol pointing out that the YouTubers in Tucson in front of Nancy Guthrie's home just had their charges dismissed in Pima County Court. It's interesting. I haven't been looking into that, but that is very interesting. To weaponize the rule for pettiness and profit, Karen Reed hasn't even written a book. Or do you think that she was paid for that Today Show interview? Because you brought that up another time too. The judge is not supposed to be looking at outside sources, okay? The judge is not supposed to be out there doing research on Reddit and Twitter and watching Karen Reed's interviews, okay? He's supposed to be impartial, and he's not supposed to be swayed by randos who write him crazy emails with allegations. Because unless you can show that the actual court documents were leaked and publicized, you got nothing. You got squeeta. And he says, what I am looking for is for the parties as adequate assurances. Hold on. This is
As abhorrent as some of them may be.
Yeah, Proctor.
What I am looking for is for the parties is adequate assurances that their discovery served justice.
That their discovery served justice? Yeah, the only way there's going to be justice for John O'Keefe is when the real murderers and people who may have covered up that murder are brought to justice. That is what discovery is intended to do. Karen Reed is entitled to defend herself against false allegations that she perpetrated a false narrative that she didn't do it and that she was framed. And that is serving justice, Your Honor, when the lead investigator gives a deposition and is questioned about his bias, his rush to judgment, his failure to actually investigate the murder of John O'Keefe. That is a discovery tool that serves justice. Are you telling everyone that you don't think so? Because that's what it kind of sounds like. Read between the lines here. To get to justice, we have to get to the truth. Thank you, Katie Madison. And if you're John O'Keefe's family, don't you want that too? Don't you want to know what really happened? And you want all the parties to assure you that what? That this isn't frivolous? It seems like you're on the internet all the time. Did you watch the trials? You know, it was wild the other day when we covered the Alec Murdaugh hearing with the new judge. There's a new judge been assigned to try Alec Murdaugh. He's getting a new trial because of Becky Hill. That judge said, listen, don't assume that I know anything about this case because I don't know anything about this case. So you're going to have to, basically, she's like, you're going to have to explain everything to me like I'm 5 because I didn't watch the first trial. I don't know anything about it. We're starting fresh here. Okay. It seems like this judge knows a lot about this case and he really shouldn't be doing outside research. I'm not accusing him of doing that, but it gives the impression that he is.
Is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit.
Again, pettiness and profit. Karen Reed was framed by a corrupt police department. The Massachusetts State Police and the Canton Police. People protecting their friends and brothers. And as a judge, shouldn't you want to get to the truth too? Pettiness and profit? You think they're being petty by wanting to do Michael Proctor's deposition? That's petty? And profit. Oh, when you say profit, are you talking about Karen Reed's lawsuit against everybody? And Karen Reed's lawsuit against MSP and Town of Canton? That she might profit from that because they actually did frame her? And she might bankrupt the Commonwealth. Is that what you're talking about? Oh, I see what you're saying. Uh-huh. No, he's not talking about YouTube creators here. He's talking about the attorneys. Listen, what I'm looking for is for the parties to this lawsuit is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit. It's pettiness and profit for them because Karen Reed might bankrupt the Commonwealth, maybe, right? I originally thought that too, that maybe he's talking about people on the internet. The only thing you're doing is making this case hell a lot more interesting to people who might not have had any interest in it anymore or at all. Okay? Because when I first started covering these civil cases, and I said it, I'm like, this is kind of boring. Like, I'll cover it occasionally, but like, this is like typical, nothing happens at any hearing. And now this is becoming a spectacle because of things like this. And people are watching, the world is watching, and we're not going to shut up about it because we ain't got no quit. Okay? And Karen Reed has every right to sue the Massachusetts State Police and the town of Canton for their BS investigation into the murder of John O'Keefe. And will anybody ever be held responsible for it? I don't know, because the investigation was so piss poor.
If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me.
See, I don't even know what he's saying here. If the parties, okay, meaning all of the attorneys in this room, would agree on what? A voluntary gag order? Here's the thing. Lawyers are bound by the rules of ethics, okay? So this is like what they already do. And they've already sworn that they didn't leak it. So why do you now need them to craft and enter into an agreement that is, if you find it acceptable to you, let's keep going.
I would consider entering it as an order of the court.
I would consider entering it into an order of the court. If you all come to some sort of an agreement and you draft it, and if I agree with it, how about you just issue an order? How about you just sua sponte, issue an order? Because you've got the power to do that too. You know you do. But now we're going to waste more time and have all of the parties in this case try to reach some sort of they can't even reach an agreement about whether Colin Albert should be deposed. Because Conrad Birdie was shipped off to the army without one last kiss. What are we doing here? Hold, please. I just dropped something. Hold on. They can't even agree on that. But now you want them to go back? And in the meantime, you're going to give Michael Proctor a little time out for however long it's going to take you to decide this? What are we doing? If you want to issue an order, just issue an order. You have the authority to do that. You know you do. You're touting your authority all over the place. We love you, Conrad. Well, yes, we do. We've got it here. Hold on. Check this out. There it is. Bye-bye, Colin. Can you guys hear me behind the scenes here? Can you hear me? Check 1, 2. Check 1, 2. I don't know if you could hear me when I just put that over. But that's a little screenshot. Bye-bye, Colin. Colin is Conrad Birdie. And all the women. Oh, you could hear me? Okay, so here, I'm going to, if you can come to your screen, come to your screen. Here's a poster. Little take on Bye-bye Birdie. Greetings from Canton, Massachusetts, it says over here. And then there's a bunch of women, and it's back in the, I guess it was in the 50s when Bye-bye Birdie was a thing. Bye-bye Colin, the musical comedy starring Colin Albert, Ally McCabe, Brian Albert, Brian Higgins, and Chris Albert, and introducing Chloe, the musical comedy phenomenon. We love you, Conrad. Oh, yes, we do. Love you, Conrad. Will be true. And look, we love Colin. Colin forever. There's a basketball hoop. Got all the things. One last kiss. Put on a happy face. Kids. I don't know what's wrong with these kids today. Remember Dick Van Dyke, Paul Lynde, Anne Margaret, one of the greatest musicals of all time. Sometimes we need a little comic relief. Okay. I would consider entering it as an order of the court so that any violation
would be grounds for a contempt finding and appropriate sanction, including.
Right. If anybody violates anything and releases any personal information, I could sanction them, including
dismissal or default.
Oh, dismissal or default. That's something right out of the Chris Matty playbook, isn't it? Didn't Alex Jones get a default entered against him so that they were able to get that $1 billion judgment against Alex Jones for his falsehoods in the Sandy Hook matter? And didn't Alex Jones admit that all the stuff that he said were lies? I don't know. I haven't had the chance to do my deep dive into Alex Jones's case, but including dismissal or default. Well, dismissal could mean a couple things. It could mean dismissal of the O'Keefe's lawsuit if their attorneys or they violated his order. That could be their sanction, that the whole wrongful death case could be dismissed. Could mean that he could dismiss some of Karen Reed's affirmative defenses. Or it could mean that he could just grant a default judgment against Karen Reed and the bars, and the O'Keefe's would automatically win based on his default judgment, and then they could just go to trial on the damages and how much money Karen and the bars would have to pay them. What? So you're already threatening to dismiss the case because somebody tweeted out something about Michael Proctor's private medical information. Oh, my freeze game is on point today. Look at his lips.
Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case.
What? I'm sorry, what? My eye is starting to twitch. Such a stipulation, it would have to include a stipulation that deposition testimony can only be used for the purposes of this case. I'm sorry. A basic rule of civil procedure is that sworn testimony can be used in any case. In fact, the New York State trial lawyers have a database of expert witness testimony so that if you're calling this expert witness in your case, you can look at the way he's testified in any other case, and you can impeach them and use against them any testimony they've ever given in any case. It is testimony under oath, and it is never limited to the exact case that we're talking about here. What is he doing? Absolutely 100% no. So you're telling them that they better agree that Michael Proctor's deposition testimony can only be used in this case? That's insane. Listen. Such an order would need to be more
or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case.
That flies in the face of everything that is holy. And that is the law. No, that's not how it works. I have said from the beginning that I don't think we will ever see the deposition testimony of any of these witnesses because that's typically never made public unless it's part of an exhibit in a motion. It is not public. It's not a public filing. They're not going to file the deposition transcripts with the court. They're not accessible to the public. But he wants them to agree on more than the fact that the deposition testimony can only be used in this case. What? What are we talking about? And then he says,
I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery.
So you better all agree, or I'm just going to make an order. You didn't give them a time limit on when they got to agree on this stuff. They can't agree on anything. They can't agree on the basics of Colin Albert turning over his phone information. He doesn't tell them when they have to reach this agreement by. He ruined everyone's holiday week. How many of these attorneys wanted to be on vacation with their families?
While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking.
Okay. Yes, you've told us there's a hard stop for August 17th. All depositions must be done. Today, as we watch this, it is July 3rd. This hearing was 2 days ago on July 1st, and yet you're not telling them when you want them to reach an agreement by, and you're not allowing them to even ask you any questions about it.
My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding.
Okay. They've already said they didn't do it. So now you're going to threaten them with ethical violations?
The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates.
See, the rule does not apply to legal analysts on the internet like me, okay? So stop threatening me with ethical violations, trolls. I'm not involved in this case. I'm allowed to scream my opinions about it and analyze it as I see fit. Okay? He's talking about the lawyers involved in the case.
As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in.
So he's saying he might exclude some evidence. What are the rules of forensic decorum? What does that even mean, forensic decorum? What is forensic decorum? I don't feel like Googling it.
Is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence.
Is this the same language that Mackenzie Sharilla and her mother used in the jailhouse calls? What is this?
The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily.
Who's churning the waters now? Yacht today, Satan. Come on over to the cupcake yacht. We're getting out there to churn the waters. You have churned the waters with this ridiculous proceeding more than you can imagine. The public was already interested in this. You have now made it look like, number one, everything that was said about Michael Proctor is actually true. And number two, something's rotten in Plymouth County, same as in Norfolk County. And that there's like secrecy behind all of this. Secrecy. and weird tips coming to you. Thank you, Jomar, for gifting 5 memberships. You're awesome. Churning the waters to generate social media. Social media really runs on its own, okay? What is going on here and the outrage about this case and the 2 persecutions of Kearney that preceded it was self-imposed by people out there on the internet who are outraged by this, who did their own due diligence and their own investigation and their own reading of pleadings and watching court hearings. It had nothing to do with these attorneys churning the waters to generate social media what?
Churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings. Read the rule.
It seems to me like somebody sent you something the day after Proctor's deposition that you took as truth, and the attorneys didn't do it, and now you're holding it against everyone. And you won't even tell them what it is. Read the rule. Read the rule.
Especially if you have never done so, adhere to it or be ready to face the consequences for failing to do so.
I wish we could see like some of the attorneys' faces in the courtroom, or be ready to face the consequences. It's like a school principal threatening a bully. Right? You getting those kind of vibes? Oh, thank you, Mama Jace, for your 5 and for your compliment. I appreciate you so much. And Charissa gifted 5 memberships too. Thank you. And then Kyle gifted 10. You guys are so nice to me.
I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial.
Again, social media is already at a fever pitch on this case, and the attorneys have nothing to do with it. Are you threatening Karen Reed from giving any further interviews? Do not succumb to the attraction of seeking to influence this case through
Social media.
They already said none of them did it. What are we doing here?
Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice.
This is some speech. This is get out the pitchforks and torches. Thanks, James, for giving a membership. Thank you, Kelly Ray. I'm so glad you bought the tickets.
But I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all rise.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel
Look at all the attorneys on Zoom also stand up as the judge leaves the bench. He left skid marks. He ran away so fast. He doesn't let anybody ask a question. Like, okay, Your Honor, what is it that you received the day after Michael Proctor's deposition? Who sent it to you? Whose tweet was it? What did it say? When do you want us to reach this agreement by? What are we doing here?
The criminal fourth session.
Court stands in recess.
There's no opportunity to be heard?
There obviously no opportunity to be heard.
I was unaware.
That's, I think, Aaron Rosenberg or Damon Seligson and Alan Jackson, like, there's no opportunity to be heard. We have questions. We have questions. This is a hearing, not a soliloquy, not a monologue, not a TED talk. This is a hearing where we are supposed to be heard. But no, the clerk is like, yeah, no, I'm just covering. I'm just, I don't know nothing about nothing. It wasn't me, Shaggy.
Yeah, I'm just covering for Clark Donovan today.
Yeah, I'm just covering.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
Yeah, can you run after him and tell him that we have things to say? He shut it down. He did not want anybody to be able to say anything.
I absolutely.
And then we got the rainbow bars, like in the old time TVs when we had like 4 channels, and in the middle of the night, some of the channels would actually go off the air and we would get all that really annoying noise and the rainbow bars. And that was it. Wait, was there
This
more?
court now stands. Please be seated.
Your Honor, may I proceed?
Yes.
Your Honor, for the record, civil action 2483 CV 0.
Yeah, I don't know what this is at the end of trial. Oh, no, it just started again. It was on a loop. Some eagle-eyed viewers did some due diligence and they found this. This is an article from the Brandeis University independent student newspaper. This was published on November 4th of 2025 by a freshman at Brandeis. Ashwika Soni published this article, and contained in this article are some of the quotes that the judge graced us with during his presentation. And this student was a freshman at the time that this was written. And so that is what the judge is quoting in the courtroom. Here's the first sentence of this freshman Brandeis newspaper article. Justice has always relied on deliberations, the careful weighing of evidence within the quiet solemnity of the courtroom. Goes on to say, however, in the digital age, that silence has been replaced by the roar of timelines and comment sections. Every high-profile case now unfolds in 2 arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms. What? His speech, he said one commentator said this. Yeah, one commentator who was a freshman at Brandeis. Exactly. Why would he be quoting from a freshman paper? I don't know. That's a great point. He didn't tell us who it was. He didn't quote his source. I said, even when I read you the motivational quotes of the day, I tell you who said them. He did attribute it to someone else, but some mysterious person. Isn't that crazy? I'll link the entire article below if you would like me to, so you can read it in full. And then this article goes on to talk about in 2023, pop star Lizzo faced her own viral trial after her former tour dancer. So, I mean, he didn't. Oh, and then Cardi B talks about Cardi B. This article talks about Cardi B. We love our girl Cardi B. Hold on.
Hello.
Hello. Hello, I'm here.
Wow. And then he goes on to say, these cases show how the digital era has blurred the boundaries between justice and entertainment. Legal proceedings once defined by restraint and decorum now double as mass media events. The courtroom symbols, gavels, oaths, and verdicts are repurposed as online theater. Well, it's not. You know why it's not? Because in order to understand this, we need to go back to 1692, Salem. Courts have always been like this, especially in Massachusetts. And as we sit here celebrating the 250 years of our country and our freedoms, we need to go back to 1692. I mean, I'm it's insane. It's insane. That wasn't his grandchild who wrote that. I don't know. Lily Lime says, we're finally seeing how corrupt our Massachusetts justice system is. That's not entertainment. It's public outrage. Pull up a picture for you. You can't make this up. You just can't. You just can't. Stop this. I'm going to put up something else. You want to hear a story? I know there's a lot of super chats here, but I will get to them, I promise. Many of them are not questions. They're just really nice comments, and I appreciate you guys so much. Paisley Chicken, thanks for your time. My senior paper in high school was about the Salem Witch Trials. If they admitted to being a witch, they lived. The only deaths were for those who denied being a witch. Even back then, it became a whole episode. Yep. Somebody else said in here that they're descended from one of the Salem witches. Let me see if I can find that one. I can't right now. And I don't want to get too distracted because I've already been distracted enough today. But it's wild to me that he pulled some of his comments from a freshman Brandeis newspaper. Are you surprised? All right, one sec. So let's go back to 1692, shall we? Salem Witch Trials, which happened in 1692 through 1693, represent one of colonial America's most notorious cases of mass hysteria. Triggered by a mixture of religious fervor, socio-political lesions, tensions, socio-political tensions, and local rivalries in Salem Village, Massachusetts, more than 200 people were accused of practicing witchcraft. Ultimately, 30 people were convicted, 19 were hanged, and several others died in prison. And then I wanted to know how long it took from the time somebody was convicted until the time that they were executed. The timeline from an official conviction to an execution was typically very short, usually ranging from a few days to a couple of weeks. The court prioritized swift punishment under the belief that purging the community of evil was an urgent spiritual necessity. Oh, I forgot my sage. I was going to bring my sage over here. For example, Bridget Bishop, the first person tried and executed, was convicted on June 2nd of 1692 and hanged just 8 days later on June 10th. John Proctor, interestingly, John Proctor was also accused of being a witch, and he was convicted on August 5th, 1692, and executed 2 weeks later on August 19th. Delays only occurred under exceptional circumstances. For instance, Elizabeth Proctor, John Proctor's wife, was convicted and sentenced to death, but her execution was delayed because she was pregnant. Oh, praise be. They saved her baby, unlike Sandra Birchmore's. Interesting, too, that Michael Proctor's wife's name is Elizabeth. By the time she gave birth, the hysteria had ended and the court was dismantled, saving her life. And yes, the executions were public. They were meant to serve as both a legal resolution and a chilling moral warning to the Puritan community. Convicted individuals were transported from the jail in an open cart, paraded through the town in front of crowds, and taken to the execution site. Ready for it? Proctor's Ledge. Proctor's Ledge was the execution site near Gallows Hill in Salem. Crowds gathered along the path and at the ledge to watch the hangings. I just lost my place. And there's actually a path. They show us the path that was taken. Oh, please. So it's been a spectacle since 1692. That's my point. Proctor's Ledge, you just can't make this up. Crowds gathered along the path and at the ledge to watch the hangings. The victims were forced up a ladder and turned off of it, causing them to slowly strangle to death rather than dying instantly from a broken neck. Afterward, their bodies were denied a Christian burial and were thrown into a shallow crevice on site. Though some families secretly returned to under the cover of darkness to retrieve their loved ones. Here's how it all started. 2 little girls, 11 and 8 or 9. Abigail Williams and Betty Parris, Parris. Started with 2 little girls. At the time of the Salem Witch Trials, little Abigail was living with her uncle, Reverend Samuel Parris, Parris, his daughter, Betty Parris, and Parris's slaves, Tituba and John Indian. It's not known why Abigail was living with the Parris family, but many historians assume her parents had died. This is according to the historyofmassachusetts.org. William's troubles began in the winter of 1691 and 92, when some of the afflicted girls were reportedly experimenting with fortune-telling techniques. specifically a technique known as the Venus glass, during which the girls dropped egg whites into a glass of water and interpreted whatever shapes or symbols appeared in an attempt to learn more about their future husbands. According to the book, A Modest Inquiry into the Nature of Witchcraft by local minister Reverend John Hale, on one of these occasions, the girls became terrified when they saw the shape of a coffin in the glass. Shortly after the incident in January of 1692, Betty Paris and Abigail Williams began having these strange, like, fits, like, I can't think of the word right now. Convulsions, screaming out in pain and complaining that invisible spirits were pinching them. Ann Putnam Jr. and other girls afflicted soon started experiencing the same symptoms. At the end of February, Reverend Samuel Paris called for a doctor who's believed to be Dr. William Griggs, but he couldn't find anything wrong with the girls, and he determined that they must be bewitched. According to Samuel Page Fowler in his book, Account of the Life and Character of Reverend Samuel Paris of Salem Village. And then, this is a direct quote from the book. Mr. Paris appears to have been much astonished when the physicians informed him that his daughter and niece were no doubt under an evil hand. There's evidence that Mr. Paris endeavored to keep the opinion of the physicians a secret, at least till he could determine what course to pursue. At this time, Mary Sibley, a member of his church, gave directions to John Indian how to find out who bewitched Betsy Paris and Nabby Williams. I guess they called Abigail Williams Nabby. Wait a second. And remind me, the Delphi girls, was one of them named Abigail Williams? Because that's kind of freaking me out right now. Libby German and Abigail Williams, right? Oh my God, everything is connected. This was done without the knowledge of Paris. The means used to make the discovery was to make a cake of rye meal with the urine of the children and bake it in the ashes and give it to a dog to eat. Similar disgusting practices appear to have been used to discover and kill witches during the whole period of the delusion. Just a few days after the witch cake incident, the afflicted girls named 3 women that they believed were bewitching them. Tituba, which was the slave, the female slave that lived with the family, Sarah Good and Sarah Osborne. You know what's interesting to me too? The main character in The Handmaid's Tale, June Osborne, Gilead, which if you rearrange the letters of Gildea'a, you get Gilead. Gilead in The Handmaid's Tale also was headquartered in Boston, for those of you who did watch the series. And you just can't make it up. So Tituba Sarah Good and Sarah Osborne were arrested and examined on March 1st of 1692. And during Tituba's examination, she confessed that she was a witch, and she warned the court that there were other witches in Salem. This confession confirmed the colonists' greatest fears that the devil had invaded the colony and sparked a mass hysteria and a massive witch hunt in Salem. After news of the witch hunt spread throughout the colony, Reverend Deodat Lawson, the previous Salem minister, returned to Salem in mid-March to find out more about the suspicious activity in the village. Lawson witnessed and published a firsthand account of one of Abigail Williams' fits in his book. Like they were having like convulsions, like seizures, or they were faking it. Maybe they were poisoned by something. And this is the firsthand account of one of Abigail Williams' fits coming from the book of Lawson, called A Brief and True Narrative of Some Remarkable Passages Relating to Sundry Persons Afflicted by Witchcraft at Salem Village. Like a seizure, yeah, that's the word I was looking for. I just couldn't think of it. On the 19th day of March last, I went to Salem Village and lodged at Nathaniel Ingersoll's near to the minister, Mr. P's house, Reverend Samuel Parrott. I'm hearing something in my headphones, but I don't know where it's coming from on my computer. Hold on. What? Can you hear that? It was like a White Castle ad. I'm like, where's that coming from? Stop. Stop. In the beginning of the evening, I went to give Mr. P a visit. When I was there, his kinswoman, Abigail Williams, about 12 years of age, had a grievous fit. She was at first hurried with violence to and fro in the room, though Mrs. Ingersoll endeavored to hold her, sometimes making as if she would fly, stretching up her arms as high as she could and crying, wish, 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 several times. Presently after, she said there was good WN and said, do you not see her? Why, there she's, it's not like she's hallucinating, like she's tripping. Why, there she stands, and said, good W.N offered her the book, but she was resolved she would not take it, saying often, I won't take it. I do not know what that book is. I am sure it is none of God's book. It is the devil's book, for aught I know. And after that, she ran to the fire and began to throw firebrands about the house and run against the back as if she would run up chimney. And as they said, she had attempted to go into the fire in other fits. The following day, Sunday, March 20th, Abigail Williams disrupted services in the Salem Village Meeting House several times due to the presence of accused witch Martha Corey, Corey. Corey had been accused of witchcraft the previous week, and a warrant had been issued for her arrest on Saturday, March 19th. Since there wasn't enough time in the day to arrest Corey and warrants weren't served on Sundays, Corey was free until Monday and decided to attend services, which upset the afflicted girls. According to Reverend Deodat Lawson. Also, according to Lawson's account, on March 31st, the colonists held a public fast due to the suspicious activities in the village, during which Abigail Williams claimed she saw witches having a sacrament that day at a house in the village. Abigail said she saw the witches eating and drinking flesh and blood, which appeared as red bread and a red drink. This claim came up again during Elizabeth Proctor and Sarah Cloyce's examination on April 11th, 1692. When Judge Danforth asked Abigail Williams about it, according to court records. And then there's actually some testimony because they had court scriveners in court in 1692 writing down what everyone was saying. Question, Abigail Williams, did you see a company at Mr. Parris's house eat and drink? Answer, yes, sir. That was their sacrament. Question, how many were there? Answer, about 40. And Goody Cloyce and Goody Good. Sergeant Sean Good. This is getting weird. But it's G-O-O-D without an E at the end. Were there deacons? Question, what was it? Answer, they said it was our blood and that they had it twice that day. It was during this examination that Abigail Williams and the other afflicted girls turned on John Proctor and accused him of witchcraft as well. It is not known exactly why the girls accused John Proctor, but it is suspected that it was because Proctor was an outspoken critic of the girls, often calling them liars and reportedly stating they should be whipped for lying. And then Arthur Miller wrote a play in 1953, The Crucible, which was a, fictitious Goody Good gets a mention, yeah, along with the Proctors. This is like, you can't make this up. So in Arthur Miller's play, The Crucible, Abigail Williams was a major character, and she's portrayed in the play, The Crucible, as having an affair with John Proctor. And she accuses Elizabeth Proctor of witchcraft so she can marry John herself after Elizabeth is executed. But then they go on to say in this article of historyofmassachusetts.org, it is unlikely that this actually happened due to the age difference between the 11-year-old Abigail Williams and the 60-year-old John Proctor at the time. There's also no proof that Williams and Proctor even knew each other before the witch trials began. But Miller was convinced, and he wrote an article for the New Yorker in 1996. And here are the rest of the people that Abigail Williams accused of witchcraft. She accused about 57 people of witchcraft, according to court records. And there's a whole list of them. Including John Proctor and Elizabeth Proctor. Even though Abigail Williams accused many victims at the beginning of the trials, especially in March, April, and May of 1692, she only testified against 8 of them. Mary Easty, George Jacobs Sr., Susanna Martin, Rebecca Nurse, John Proctor, Elizabeth Proctor, Mary Witheridge, and John Willard, and gave her last testimony on June 3rd, 1692. And there's actual writings of this. Check this out. These are actual writings from the Salem Witch Trials. I would love to do a deeper dive into this. Many of you probably have already. Obviously, there were no cameras all the way back in 1692, but there are some historical drawings of these girls. It's a historical drawing of Abby Williams and Betty Paris. A lot of people in here saying my ancestors were in the Salem Witch Trials. Cotton Mather was also involved in the Salem Witch Trials. He was the influential Puritan minister whose writings validated spectral evidence and fueled the initial hysteria. It's interesting stuff, right? Here's Cotton Mather. He wrote extensively on many subjects, including the Salem Witch Trials. There was also a judge, one of the key decision makers. His name, William Stoughton. Interesting, right? William Stoughton was a judge, New England magistrate, and colonial administrator in the province of Massachusetts Bay from 1631 until 1701. And he was the Chief Justice of the Court of Oyer, O-Y-E-R, which heard the Salem witch cases in 1692. Harvard grad with a degree in theology. Oh, please. Oh, please. Over 200 were accused. 19 were hanged. 1 was pressed to death. And I think, well, I'm not sure on those exact numbers. 19 were executed. I think maybe 18 were hanged. 1 was pressed to death. And then a couple died, chained up in prison. Some of the places are still standing. You can go visit them if you like. And there's a witch house in Salem. I mean, imagine how haunted these places are. There's the witch house in Salem. But what is it? Hold on. Whose house is it? Oh, it never had any accused witches living in it, but it offers a fascinating glimpse into the daily what? Life of a person of means in 17th century New England. Most of the women who were accused were poors. They were poors. I did learn that. A lot of these landmarks are located in modern day Salem and Danvers. And let me show you if I can find it. Proctor's Ledge. First, let's look at the path. So some of you may live in Salem, you may know this path. This is the path that they would walk the convicted witches along before they hung them, when the spectacle of the public hanging was really a thing. This is from Salem witchmuseum.com. Path from jail to execution. In 1692, convicted witches would be picked up at the jail, loaded into a cart, and escorted to the execution site by High Sheriff George Corwin, who would sign their death warrants. The path led south on Prison Lane. Today, it's St. Peter Street. Right on Main Street. Today is Essex Street. Heading west to the edge of town. The cart would have passed within view of the meeting house where some of the examinations took place, and the townhouse where the trials took place, and past the homes of Judge John Haythorne, Cork Street, Court Clerk Stephen Sewell, and Judge Jonathan Corwin. The witch house. That's the witch house we just looked at. Boston Chris says John Proctor was my 8 ex-great-grandfather. At Boston Street, the procession would head north, turning right on Bridge Street, today is Boston Street, and over the town bridge that spanned the North River. Shortly after the bridge crossing, the cart would turn left to the execution site at Proctor's Ledge. It's right there, Proctor's Ledge. Can't make this up. Crowds would gather for the executions both along the way and at Proctor's Ledge. Executed on June 10th was Bridget Bishop. Executed on July 19th were Sarah Good, Elizabeth Howe, Susanna Martin, Rebecca Nurse, and Sarah Wilds. One of the biggest crowds to witness the hangings was reportedly on August 19th when Cotton Mather arrived from Boston to witness the execution of Reverend George Burroughs, who he considered to be the king of the witches. Martha Carrier, thought to be the queen of the witches, and George Jacobs, John Proctor, and John Willard. The last execution day was September 22nd. Hanged were Martha Corey. Her husband, Giles Corey, was pressed to death 3 days earlier. Pressed to death. Mary Eastie, Alice Parker, Mary Parker, Anne Pudiator, Pudiator, I don't know. Wilmot Read, Margaret Scott, and Samuel Wardwell. Reverend Nicholas Noyes was quoted, quote, "What a sad thing it is to see 8 firebrands of hell hanging there." The executed were not afforded proper burials, but were instead cut down after death and placed into a nearby crevice, which acted as a shallow grave. It is speculated that family members, particularly those of George Jacobs, Rebecca Nurse, and John Proctor, came to the site under cover of darkness to retrieve the bodies of their loved ones and bury them on family property. According to historian Emerson Baker, there are no human remains in the very shallow soils of Proctor's Ledge. And here it is, Proctor's Ledge. Here's Proctor's Ledge Memorial. It's at Pope Street and Boston Street in Salem, Mass. For many years, it was believed that the 19 innocent people who were executed in Salem 1692 were hanged at the summit of Gallows Hill on the edge of town to the west. The exact site was not memorialized. After all, this was a shameful event that Salem residents wanted to leave in the past. Maps of 1700 Salem show Gallows Hill, but no marker for the execution site. In 1921, local historian believed he had located the spot near the executions, but in 2016, the real execution spot was confirmed as Proctor's Ledge in January 2016. This is the season of the witch. It is. Speaking of which, Stevie Nicks is said to be performing at Taylor Swift's wedding, just as a side note. They should offer this on pay-per-view because I would totally watch Taylor Swift's wedding. Let me know if you would too. And so that is that. And here's the memorial. Has anybody ever been there? And then if you zoom in on this memorial, you can see placards with every single person who was hanged there and their dates of death. I thought I had a closer up picture of this, but I don't think I do. So 200 were accused, 30 were convicted, 19 were hanged, several others died in prison. Started with 2 little girls having convulsions. The executions were public, and so Massachusetts court proceedings have been a spectacle since at least 1692. Let me know if you would like a deeper dive into this, because I find it fascinating and I find it quite ironic that there's a guy named Proctor involved in this case. And that Proctor's Ledge is where all of the accused witches were hanged back in 1692 and 93. Wild. I think today is a good day to go back and read Judge Beverly Cannone's decision. On the motion to dismiss for egregious governmental misconduct. Let me know if you want to do that. But before we do that, let's go to the chat because you guys are going crazy with your questions. And who could blame you? Wouldn't that be crazy? I've always wanted to go to Salem and go on like a tour, some kind of haunted tour. I've done haunted tours in other places like Savannah, which is also really cool and very haunted. Savannah is one of the most haunted cities in the country because during, I think it was the Yellow Plague or the Yellow Death, all of the bodies were buried in mass graves underneath the cobblestones. And so a lot of the cobblestone sidewalks and cobblestone streets are rising up, and they say it's because of all the bodies that are underneath. And there's a lot of haunted sites in Savannah, Georgia. Let me close all these windows that I have open on my computer because it's getting drafty. But the courtroom scenes of these Salem Witch Trials are wild. And the public spectacle has been going on there for hundreds of years. This is nothing new, Judge Gildea, nothing new. Scotty, thank you for tuning in from Canada. Oh, you're talking about, no, the Gaudreau brothers. Have I seen the latest? No. Yeah, well, I knew that. I knew they were fighting over the BAC plasma. Yeah, I did know that, but I haven't covered it yet. Or I did in another case. I don't know. I mean, another show. Sean Higgins is the one who's going to stand trial for the murders of Johnny and Maddie Gaudreau. Johnny Hockey and his brother, Holtby's in New Jersey. So Raven, thanks for your super chat, says, I bet the hospitality defendants settle out shortly just to avoid a default judgment. I don't think so. I don't think they're ever going to pay. It won't look good for them if they pay. Because if to settle, that would mean that they're kind of admitting that they overserved Karen and she wasn't drunk and she didn't hit John with her car. So I don't think so. Charlie says, you were born with she was born with cerebral palsy and I'm well past my use by date. Oh, stop. Thanks for tuning in from Australia. Shirley Carter says, oh, thank you for your very nice compliment, Slancha. Slancha, thanks for your 10. Thank you, wrestlers. Mom, I'm not pulling up any $2 super chats today. Sorry, I'm just not, because they're all trolls and I don't even want to put one up by accident. Kyle says, wait, what? Oh, thank you very much. Yeah, thank you so much. I appreciate your 5. Not creepy. Very sweet. So if you did put in a $2 super chat, just know that I'm thanking you blanketly, because the trolls are too cheap to pay more than $2. Not that you guys are cheap for sending in $2 super chats, but I'm not doing it. Desiderata says, listening all week, but while doing home renos. Thank you so much. I bring you comfort. Oh, that's sweet. Thank you, Karen, for your 10. Someone has receipts and wants Something Off's podcast to dox him. Looking forward to a real roast soon. They're all for it. Well, his name is Vincent Imbesi, IMBESI, and he's a lawyer in New York City. So it's not hard. It's all public, as he would say about my home address and other things that he's trying to dox me about. But, you know, whatevs. Moron's going to moron. What are you going to do, right? Holly Johnson says, seriously, has Loophole Lawyer lost his mind? I'll never watch anything of his again. I don't know. Maybe that is his mind. Maybe he hasn't lost it. Maybe that's just who he is. Yeah, the N-word. He's not just attacking me. He's attacking a lot of other women who won't speak about it. Thank you for your 20. Thank you, Wrestler's Mom. I love you too. You're sweet pea. Thank you, SF in Texas, for your 5. Aunt BB, let's go, Cupcake. Let's unite. Show the loser who we are. Give what you can. Who's first? Thanks, Aunt BB. Gigi's here. She's engraving the silver clinks. And she put her dog Mila up. Thank you for your 5, Gigi. Kyle said, if I thought to mess with the girl who took down the Catholic Church scandal, I'd be like, no, don't think so. Thank you for your 5. Music to my soul says, thanks. I knew I didn't like him, but I couldn't put my finger on why. Lady Wags, I can't quit you. I've been here since Maya, and I mistakenly canceled one too many membies. I'm back. I love you with all my heart. I love you with my heart, too. Green Bay Packer fan says, I'm not a Swiftie. In fact, I only like her old songs, but seeing her sing Love Story live made me cry. Oh, I love that song, too. She deserves the happiness and a perfect wedding. I agree. Music in My Soul said, Loophole Lawyer even made fun of Betterow rescheduling the hearing when his dog Winnie died by referring to her as his goldfish. I think he was alive with Turtle Boy for his fundraiser when he did that. It was disgusting. Aidan told him to stop. Thank you for your 20. T-Dubba says I'm 12 minutes behind, but I'm loving the Spicy Melanie dropping the F on him here. It's going to get clipped and it's going to be all over the cesspool of Twitter before the day is out, if it's not already. Emily C. said he made that joke over text first. Corey left the group chat and Sam told him it was inappropriate and he went ahead and said it publicly anyways. Yeah, well, this is what we're dealing with. This is what people are dealing with. On Top says, I'll leave now. If you want me there, I'll be in touch. You're always safe. Oh, thank you, On Top, for your 10. Kyle says, oop, I'm mad again. I'll soothe my spirit by sending super chats to Melanie. Seems a lot of people have had this guy figured out way before I did. And in fact, he gives jump and shout the skeeves. Definitely a plant. Glad you're calling him out. He's a loser. Elf said this may have been a carefully crafted ploy by the non-lawyers that may benefit. Yeah, the releasing of Proctor's private information. A lot of people think that. And now that it's been, confirmed that that's all that needs to happen to get Proctor out of doing a deposition, I mean, what's going to happen next? New Jersey Kathy says, I think the judge was set up by Proctor's attorney in his never-ending quest to get out of the deposition. If you go through the public filings, it does not take much to figure it out. 2 + 2 is 4. Thanks for your 20. Sonia says, I wonder if his change of tune, the judge, is because of being pressured by someone in Canton or some people in Canton. Bev, now in civil, couldn't take over. And if he's thrown off, could she? I don't know anything about that. I can't speculate. Thank you for being here from Australia. Brass said, if it was Aidan, then isn't it discoverable in the defamation case which judge withholding it becomes a problem? I don't know. If I were one of these attorneys, I might make a motion to find out what it is that the judge is referring to, because unless they know what the judge is referring to, they can't tailor their actions accordingly, right? The whole thing is bizarre. And it should become discoverable. All of those things. I feel like I'm in the Twilight Zone. That's why we have Twilight Zone emojis. Karen says, this sounds like the hostage video. Was Gildea'a on the email list that came from Michael Morrissey's personal email? Oh, interesting thought, Karen. Love you and this passion. Happy to stay. I'm inside and I'll watch you. Yeah, I hope you guys are staying cool today. It's hot. Titan Uranus says 3 a.m. in Oz, laying in bed and loving this. Oh, thank you. Thank you. Kyle's back. Pray Deitch gets in or the feds knock on Proctor's door. I bet that sniveling mess would squeal like a pig. Well, we'll see. Alling Dog Design. Melanie, if the judge actually drops the case, is there any favor to the defendant versus the plaintiff? Well, if the case is dismissed, that does favor Karen Reed and Aidan Kearney. And so I don't know what you mean. Who would it favor? If the judge throws the case out, it favors the plaintiffs. If the judge grants a default against Karen, I mean, if the judge throws a case out against the plaintiff's case, it favors the defense. If he grants a default against Karen, it favors the plaintiffs. So the whole thing is bizarre. I don't know why he would make threats like that publicly, but Charlie's getting Brubaker vibes. Thank you, Blessed in Texas. I love you too. I love you too. Thank you. Happy birthday. Happy 60th. 60 is the new 40. Thank you for your 10. Thank you, MF, for your 5. Ona, thank you for your 5. Don't know anything about Judge Cannone and what she's doing. Aunt BB said, Boozy Beauty said right after Judge Gildea left, Diller was laughing. She asked him, what's funny? No response. Very interesting, in my opinion. Oh, that's interesting. Love Boozy Beauty. Go get her take on it. I think she did a live stream about it. She has a YouTube channel now. Ms. Bouquet says not a troll, just a bore. Tara saying everything about this hurts the O'Keefes too. Thank you, Tara. I see that you're not a troll, so you're safe. Emily C., thank you for your 10. If the calls to Proctor had been threatening, he'd ask the cops to trace the call, and we don't know who it was. If they weren't, how does Proctor even know the calls were about this case? Right. JoJo's grave concern. Thanks for your 10. Says everybody hit the like button. Love you too. D. Critchlow says, interesting, Proctor's lawyer at the June 8th meeting said 30 minutes after filing, the family got harassing phone calls, and then the judge says the X message was 30 minutes after filing. Right. Interesting. So, but he said it was that he was notified by somebody not a party to this case. I don't know if it was a lawyer. I don't know if it was a rando. I just don't know. Chris Cardell says, we're witnessing a sham. Gildea'a is Cannone in different clothing. He appears to be operating from fear and setting all up for failure. Thin skin of a toddler, corruption and cowardice. Your thoughts? I think I'll keep my thoughts to myself on this judge. I find it outrageous. I think I've given a lot of thoughts today. Is he looking for an excuse for a gag order? Is he looking for the parties to reach some sort of agreement on their own that he will then sign into an order, but he doesn't give him any timeline or anything? The whole thing is bizarre. I've given a lot of thoughts today, so that probably crossed. Happy 58th birthday to Lil Mama's BFF's husband, Chris, who's recovering from a major heart attack, sending him all the healing vibes and all the birthday vibes. Thank you for your 5. Dove's House, similar information to what was in the exhibits and the filings. Similar, are you kidding me? How did he come by this info? Ex parte, somebody sent him, somebody notified him. Somebody notified him the day after Proctor's half deposition, or 10% deposition, or whatever you want to call it. Thanks for your 5. Lena says his speech reminds me of Bev's grave concern speech. I said that too. He says, I think someone else wrote it. Also, the hostage video, as you say. Fix is in, is your opinion, Lena. So-called leak did not happen, says Lil Mama. No way. It would have been all over the internet. Content creators would have been discussed, even if up for a few minutes. Thank you. I'm the problem. It's me. Thank you for your 5, says he's pale. Amber says, do you think that the statement relating to the rule, quote, who are or have been involved and their associates, could that be former lawyers at Karen Reed and their associates or clients? I don't know. Speculation is a wild thing because we can speculate about a lot of things. And so as we went through, I gave you my thoughts on what I had thoughts on. Ian Runkle said he wasn't even going to make a video about this hearing until he watched it. Good job, Judge. I did watch Runkle's stream, I think. I go back and after I do my own commentary, sometimes I go back and watch other people. Like I watched Emily, I watched Peter Tragos, I watched Runkle on like double speed so I can make sure that I was not gaslit and that I'm not totally crazy and everyone had the same opinion. So it was interesting to watch. Thank Toby's mom. Thank you, Resilience Speaks, for your 5. Your husband's at the World Cup watching Messi. Have fun, babe, she says. I'm watching Melanie. Fuzzy Duck Puppet says that was the classiest big mad rant. Oh, it's going to be everywhere. It's going to be everywhere. I don't care. I don't care. Thanks for being here for 23 months. Charge plagiarism, failure to properly cite sources. Thank you for borderline being here for 22 months. Sonia says in 30 years, we will find out that the impounded document was actually the speech Proctor wrote for him to read out in the hearing. Thanks for your 5. Leo from Cape Town, thanks for being here. From South Africa, pointing out that Loophole already is down 1,000 subscribers. I don't know. I don't even care enough to look, but I guess you did. So thank you so much for your super chat. Funny, Karen's lawyers were the only ones brave enough to ask to be heard, says Georgia Cat Mom. Thanks for your 5. Since he's okay with using other people's work, he's probably not going to care that a lawyer used ChatGPT. 100%, he says nothing. Thank you, Lynn Justice, because we did find out that Tully's attorney actually filed another filing after that in which he admitted that the case that he cited does not exist. It doesn't exist. Is he going to be spanked for that? Probably not. Thank you, Shirley. Oh, Shuri. I'm not a member, but I love your channel. I myself, I'm a huge Harry Styles fan and One Direction fan, and I'm 59. My daughter made me love them. I know, me too. I always let my kids play their music that they like in the car. So I learned to like these bands too, because I think music is an important part of life and growing up. And I love that they are all into music now, my kids. Thank you for your 10. Beth Allen said, Bill O'Reilly wrote a book, Killing the Witches, which goes through this history in great detail. Thank you, Beth, for your 5. Fuzzy Duck Puppet says, oh, here is the Fuzzy Duck Puppet. I love how you guys change your usernames. Pass long till the first motion on this not so much a hearing. Thanks for all you do, Mel. You're amazing. Oh, well, the courts are closed today, so nothing's going to drop today. Maybe early next week. Thank you for your 20. Kyle says, seeing this all play out in real life makes The Departed look like a Massachusetts tourist ad. Gildea didn't seem insane, so this has to be someone getting to him. I don't know. I think that what is going on here is so much deeper than we know, and I think it's all being exposed. And I think that there's a lot of people very afraid. Maybe it was ergot. Wait, does Massachusetts still have that? Yeah, people say that it was some kind of poisoning. I don't know what ERGOT is, but people are saying that. Helena, says, I live in a small town in northern Sweden where witches used to be burned at the stake. I wrote a paper about it in school. So interesting, but tragic. Jezebel writes, the irony that many of these women were also considered outcasts and weird or loud by others is very poignant. Yes, I forgot to did I even mention that? That most of the people who were accused were either poor outcasts weird or loud by others. That is exactly. They were outsiders. Interesting. So, real question, no jokes. How hard is it to become a judge and what does it entail? They're appointed in Massachusetts. They're appointed. They don't have to take a test or anything. It's just like they get appointed. Music to my soul. In honor of Taylor Swift's wedding weekend, she has fitting lyrics for this. They're burning all the witches, even if you aren't one. They got their pitchforks and proof, their receipts and reasons, right? And also, who's afraid of little old me? So I leap from the gallows. Right? So I leap from the gallows. Who's afraid of little old me? Thanks for your 10. Jessica says, is it possible my main got accidentally blocked during a loophole lawyer raid and error? I tried to gift it and no go. I don't know. You can email me, fanbase@mlittlelaw. You can email me with your link to your channel and I can check on it. A lot of people are getting blocked. I don't know. YouTube is doing some weird stuff, sua sponte, and a lot of people are getting blocked. So I can't tell you. I don't know. I'm not doing it. My mods are doing it. Thank you for your 20. ARW D4H. 18-wheelers here. He says the frothing season raises the trolls. The frothing season raised the trolls. 23 months feels like 23 days. Oh, thank you. Big Dog says, why would we pay to watch Taylor Swift wedding? It's on the yacht. Wink. So free front view seating for the cupcakes and friends. Yes. Brenda, validating to hear you speak about loophole. He's made more than one downright creepy comment than the psychiatrist who continues to partner with him. How about, do you remember when he stole Ian Runkle's interview with someone and then made it look like he was the one who did the interview? Remember? Who was it that he did the interview with? It was one of Karen Reed's attorneys, I think. It was Becky Hill that told Judge G, right, about that weird Facebook post involving egg lady jurors. Oh, it was Becky Hill that told. Oh, I see what you're doing. You're making a joke here. Got it. Carolia, seems like the judge wants an excuse to make extreme orders barring those depots from being used in other proceedings, which is unheard of. No, yeah, it's unheard of. It is unheard of. Love is a four-letter word. Thanks for your 10. Indeed, no words could ever spin a story such as you. So I say to God above, do my bend the knee, go on and rule your afterward, for heaven is here. Melanie, with Melanie. Love you, lady. Happy 4th, chat. Thank you. Thanks, Jessica, for becoming a new member. Male lady. I love you, Melanie. Not fade away. Not fade away. Love's real, not fade away. Laura said, the Insider has worked out the timeline. Aidan is not the problem. I saw that. Larry says, just thanks for a July 3rd session to help you get through the loophole. Well done. Holly, why is Proctor having panic attacks? He's already lost everything. What's he in fear of? Proctor clearly has benefited the most from the supposed leaking of his medical info. I mean, it's rumored that he had a panic attack, so I don't even know if it's true, but I wouldn't be surprised. Wouldn't you be having a panic attack? Thanks, Dancing Quinn, for being here for 11 months. Jessa, will do. Okay, cool. I do. I get slammed by them, but put blocked in your subject line so at least I can pick them out. Oh, please. Yes, this is true too. I love sarcasm pointing out that the 2 arenas comment is also referenced on Jackson's law group website, which I found interesting. Yes, it is. It's on Alan Jackson's law firm's website. That is true. That is true. All right. Put a 1 in the chat if you want to go over Judge Cannone's decision regarding the motion to dismiss made prior to Karen Reed's second trial for egregious governmental misconduct, because I would love to read that to you again. Let me know. Because I think it is a fine time to look at it once again. And many of you were not here, and maybe you've never heard Judge Cannone's decision. And after everything that we are learning now about Michael Proctor, I think it's going to be interesting to read it again. Good. Okay, you guys want to read it, so let's read it. Thank you, Jill, for your Cash App. I appreciate you so much. As we celebrate Independence Day, we are also celebrating the independence of Karen Reed. Right? Thanks, Kyle. Hang on one second. Let me just take a look at this. This is a long letter from Matt McCabe. Wow. Proctor's ledge in modern times. Hold on. You guys are some of the best creators also on the internet. So hold on a second. Thank you for sending this to me because I always need a good laugh. Hold on. Thank you, Allie, for making this so quickly. This is Proctor's ledge in modern times. Are you ready for it? Here's Allie. What do you think? You can't make it up, folks. You can't make it up. Well done, Allie. Well done. Betsy, thank you for your Venmo. I love your face even more. I love your face so much. Anne says, thanks, Melanie. This judge seems angry, really angry about something. Either someone reminded him of past indiscretions or he misunderstood something that was posted. He doesn't understand that we all want to know the truth and that Karen was framed. Yeah. Anonymous says, here's my question. Do you think that the Haas defendants are not showing up for depositions because the first question will be, are there any texts or phone calls to you and Michael Proctor? I mean, there's a lot of questions they don't want to answer. And listen, now that Michael Proctor is getting this kind of treatment, which is so interesting too, because we went over a filing where the judge demanded that Karen Reed's team explain themselves with the facts of why, they think that certain deponents or potential deponents, third-party witnesses are getting special treatment. And isn't it so interesting that now he goes on a worldwide audience and calls everybody in and does exactly that, gives Michael Proctor special treatment, right? Doesn't that prove their case even more? Oh, thank you. Thank you, Emily C., for also doing the Lord's work. And let's read, Emily C., we were introduced to Emily C., I think during trial number 2. And we read Hank's diary. Do you remember? We read Hank's diary. Hold on a second. And she has done a Judge Gildea's diary for us today that we need a laugh. And so I bring to you Judge Gildea's diary by Emily C. Thank you, Emily, for giving us something to laugh about today. Hold on one second. If you can come to your screen just to see how Emily does this, if you're not familiar with Emily's work, it's fantastic. Let's stop that one and share another one. And it says, from the desk of Judge Gildea. Happy Dear Diary. Happy 250th birthday, America. Yay, democracy. Yeah, I know we're a constitutional republic, but I'm the judge and I can say what I want. So shut up, social media. Unfortunately, after I spent last year's July 4th barbecue pointing out over and over how many people were in attendance, no one invited me back this year, angry emoji face. So I decided to use my judicial discretion to ruin everyone else's holiday weekend. I got to scroll this from a different window. I made every attorney come to court today, devil emoji, but I wanted them to think I had fun plans to get to, so I performed the soliloquy I had practiced in the mirror. Then I raced out like Judge Cannone on a regular Tuesday. Here's the thing. Ever since I got this case, my inbox is a mess. Every day I get these emails. Turtle did this. Turtle did that. Who knew turtles could be so evil? I finally decided to make those ladies happy. So sue me. Ha, you can't. I'm the judge. Plus, all these influencers want content for their social media, so I gave them content. I made an impossible brain teaser. I mixed up the time of one tweet, the content of another, some details from the turtle haters, and bam, that should keep them busy for at least a few days. No fourth fun for anyone. XOXO, Mark. So many talented cupcakes, like you have no idea. You have no idea. The Godfather. We're going to make the Godfather art into shirts. It's going to be fabulous. It's going to be fabulous. Thank you, Emily C. Please go follow Emily C. Emily SEEE on all things social, including her YouTube channel. Because if we don't laugh sometimes, we're just going to cry. All right, buckle up, buttercups, because we're going to do a reading of Judge Cannone's I got to close some windows first. Oh, but before we do that, let's look at one more picture that was really, really fun. Remind me. I'm sorry, because I forget this person's name, but she's super, super, super talented. She made the prom pictures for Jimmy's class. And we'll just look at them one more time because they're so amazing that I want to look at them again. So this is courtroom, classroom 203, senior prom. And here's Billy Bush and I at the senior prom of class 203. Pretty Cookie Jamie. It's Pretty Cookie Jamie. Pretty Cookie Jamie made these. She made a whole bunch of prom pictures for Jimmy, Auntie Deb's senior class. And here's classroom 203, senior prom. Billy Bush and I sent it to him. He thinks it's hilarious. Thank you, Pretty Cookie Jamie. I will be going on Billy Bush's show on Monday to debrief the Taylor Swift wedding and everything relating thereto. Pretty Cookie Jamie. Do you love it? I love it. Here's something else fun. Oh, that's the order. A viewer named Brendan is an amazing designer, and look what he did. He made an illustration of the Clemenza's meatball scene from The Godfather. And there's Michael. And remember, somebody says to Michael, Michael, tell the pretty girl you love her. And then in the thought bubble, Michael's thought bubble is a picture of me where he sketched one of my headshots. And it says, I love you with all of my heart. If I don't see you soon, I'm going to die. I think this deserves a t-shirt. What do you think? And stickers. I mean, we have to, right? Pretty Cookie Jamie is amazing. This is Brendan, not to be confused with the Brendan who forgot to mute himself on the Zoom. There's Grant Smith Ellis wearing his merch. I went to Cancun with attorney Melanie Little because I sent it to him because he's the reason we have the merch. I love it. I sent him a hoodie too, but it's too hot for the hoodie. And Brendan also did this. Look at this, Melanie Little as the Godfather. He shaved decades off my real age, but I love it. I love it, and I think we need it also. I think we need this on the merch too. What do you think? Melanie Little with the marionette strings. All right. Let's get to the papers because, you know, it wouldn't be a holiday unless we read some papers. And this is like a deep cut. This is like going all the way back. Pre-Karen Reed trial number 2. And the defense made a motion to dismiss Karen Reed's case because of egregious governmental misconduct. Judge Cannone did not hold an evidentiary hearing like she should have done, the way that Judge Krupp did. It's funny if you say that really fast, it sounds like corrupted. Like Judge Krupp did in the Miles King case, where he made Adam Lally get on the stand, and then poof, Adam Lally never went back on the stand again. Remember? I do. But let me close all these windows because it's very drafty in here. All right, where did I put that motion? Here it is. Okay. Yeah, the judge was hung up on a Today Show appearance by AJ and Karen. Hope you guys are staying cool today because it's wicked hot here on the East Coast. Are they still having the heat wave in the UK that was happening when I was there last week? Let me just take a spoonful of honey. Hold on one second, because I'm already getting vocal fry and I don't want to annoy you too much. Talk amongst yourselves for 1 second. Okay. Are you ready for it? I remember ranting the first time I read this decision when it first came out. This is the paper number 628 in the Commonwealth versus Karen Reed action. Just move this to the other side. Okay, and this was filed. I'm going to skip over the case law and stuff. We're just going to read like the pertinent facts. It's 27 pages long, but I forget. I just want to give you the correct date when this was filed. March 25th, 2025. March 25th, 2025, right before Karen Reed's second persecution began. Okay, here we go. This is drafted by Judge Cannone in the Commonwealth versus Karen Reed. This is the memorandum of decision and order on defendant's motion to dismiss for extraordinary governmental misconduct. On June 9th of 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th of 2022. The Commonwealth's theory of the case is that the defendant, while intoxicated, struck and killed O'Keefe while operating her vehicle in reverse and left the scene. Trial on the matter began in April of 2024 and concluded on July 1st of 2024 with a mistrial. The matter is set for retrial April 2025. Yes, for those of you who don't know, Karen Reed was originally charged with, remind me what her initial charges were, February of 2022, with, I think, manslaughter, and then it was upgraded to murder, second-degree murder, after the convening of a grand jury and indictment on June 9th of 2022, because as they said in their text messages to each other, thank you. Oh, Kyle. Oh, my name is in that email. Okay, hold on a second. I'm going to have to hold on a second. Hold on a second. Thank you, Scott. I was on DND, so I wasn't getting my texts. Okay, hold on. Matt McCabe mentioned my name. We may have to hold, please, for 1 minute. Oh, what? Where did this come from? Kyle? Oh, I knew it. I knew I was going to wind up. I knew I was going to wind up. No, it's an email from Michael Morrissey to Tully. Okay, this is so interesting. Hold on a second. Hold on. Kyle, I saw the first one that you sent about Matt McCabe's email, but this is something different. Wow. Okay, chills. This is an email from Michael Morrissey through his Norfolk County email sent November 2nd, 2024 at 9:06 a.m. to BRIAN Tully and Hank Brennan. Subject, forward, Karen Reed, attorney Melanie Little live. Michael Morrissey forwarded this to Tully and Brennan on November 2nd of 2024. That's before Karen Reed's second trial. That is after Karen Reed's mistrial. And it's from someone named Carol Jacques, Jacques, dated November 2nd of 24. This is just one of the crazy emails that are being sent to the defense team. And she sent it to Michael Morrissey. Subject, Karen Reed, attorney Melanie Little live. No wonder I've been getting trolled. Is the call coming from inside the house? Was this in a FOIA request? Here's the all caps email sent by somebody allegedly named Carol Jacques. Emily said, this is what I meant in Gildea's diary when I said his inbox has been a mess. Here it is, all in caps. Scott is saying, Melanie made it. She was on DA Michael Morrissey's goon squad of state police detectives radar. The call is coming from inside the house. The call is coming from inside the DA's office. All the threats that I've been getting. I've been getting threats since January of 2024, since I started talking about this. This is already November, but listen to this. Today is Friday, November 1, 2024. Melanie Little was paid by donations to her channel. The FKR cult arrived. Melanie chat consists of approximately 1,800 most days. The paid subscribers arrived. Melanie and the cult lied. The cult goes to different channels. Example, the Glarer, LTL, going through the motions. This, a criminal conspiracy. They have nothing good to say about the troopers. I think it's a criminal conspiracy, maybe RICO. Your Rhode Island friend. No punctuation, all caps. You guys, if you have the email, I don't know where this came from. Kyle Sharkey sent it to me. $1,800, 1,800 people in my live chat around that time. Today it was over 5,000. Yesterday it was, or 2 days ago, it was like almost 20,000. Have I been a target of Michael Morrissey's office, Hank Brennan, Tully, since at least November of 2024? Wow. Wow. Michael Morrissey sent this email about me to BRIAN Tully and Hank Brennan on a Saturday morning. Saturday morning, November 2nd, 2024 at 9:06 a.m. Well, there's no punctuation here. That's why punctuation is important. I don't think that this person thinks that I'm Karen Reed's attorney. Just Karen Reed, attorney Melanie Little, live. Wow. We're all in on the same joke. We're all in on the same joke. Says the person's name is Carol Jacques, Jacques. How long have I been saying? I wonder if my name appears anywhere in the Michael Morrissey email dump. Emily, is that the same thing you just sent me? Yeah, Kyle sent me that also. Wow. It's disturbing on many levels, but it makes a lot of sense. Makes a lot of sense. I just sure hope they weren't involved in any crimes involving me, sharing my personal information, etc. Oh, this is going to be fun, isn't it? This is going to be fun. Like, did this just come out today? Who else? What other YouTubers did they talk about? They were trying to shut me up, but they know they can't. They've been trying since, I mean, who knows if there was something before this? Because it started with Coffindoffer in January of 2024 when I went on Court TV. Came out today. I just said yes out loud instead of typing it. Love from Tejas says, at first I thought it said your friend from Block Island. Scott McGinnis said, one would think that Michael Morrissey would be more concerned about the feds and the FBI chasing him around. Darlene says, I suspected that they knew who you were and had their eyes on you all along. This is a big deal for you, Melanie. Grave concerns for you. Oh, it's going to be a whole new episode, Pat Ray. Norfolk Tyranny says, probably the same person ex parte to Gildea'a. Interesting, there's a conversation and communications with Matt McCabe. Yep. They're all connected. Dobie Mom says, now I think loophole lawyer is an insider. It makes sense. I think I need to go. Maybe I need to hire Corey Hopkins. Please. Oh, please. No, they didn't get me confused with Liza Little. This person just doesn't know anything about punctuation. Because it says Melanie Little was paid by no donations to her channel. They know exactly who I am. They think it's a criminal conspiracy, maybe RICO. Corey is on vacation, staying in a house with the number 227. You can't make this up. You can't make this up. Jane says, your concern about going to Massachusetts has been proven legitimate. All right, now that we're here, we're going to have to pull up Matt McCabe's email too, right? Because I don't know what that says. but let me find out. Hold, please. Kyle Sharkey's out there doing the Lord's work along with Emily, Corey Hopkins, and Boozy Beauty, and so many others. This stuff, this Matt McCabe stuff is Kyle Sharkey says it's part of discovery regarding Aidan. I don't know. This must have came from a FOIA request. Hold on. See, I don't live in Massachusetts, so they couldn't come and arrest me. Hang on a second. I'm not paranoid. I'm just right. I mean, you know the FBI is still watching, right? They have to be. Who do I call? Mass Dad said earlier he emailed you the discovery that came out from. Hold on a second. Oh, this is going to be a whole nother episode. Sometimes we get sidetracked. And with good reason. All right, just give me 1 second while I look that up. I have too many screens and too many windows open. Hold, please. I can close all this stuff about the Salem Witches, right? We're done with that for today. Nothing was sent to me today, Mass Dad, but maybe you sent it to me a while ago and I just never looked through it or noticed. Thanks, Fairy Raven, for buying 3 matcha lattes. You're amazing. I really need it today. All right, let's read Matt McCabe's email. Keeps getting stranger and stranger. So let's get on with the show. Let's go. I have this in JPEG form, so I'm gonna have to flip through screens a bit. So we're just gonna have to be patient. The problem is because these are all like JPEGs, I think in the FOIA discovery that you can't really search by keywords and names and stuff, right? You'd have to read through thousands and thousands of pages of emails to find something like this. All right, here's an email from Matthew McCabe. This is from Michael Morrissey's email. Here's an email from Matt McCabe. Thursday, October 31st, Halloween 2024, 4:39 p.m. Matt McCabe is emailing Michael Morrissey, Josh Levy, Andrea Campbell, Maura Healy, Kristen Collins, James Hendry, Eleanor Rafferty, and Jeffrey Noble, and Michael Tully. Urgent request. Witness intimidation by Aidan Kearney. Oh, this is going to be good. Don't dox this Carol person, please. Because I don't know if that's really her. And so if she works for the Rhode Island State Police, that would be wild. That would be wild, Sue, but let's not dox that person. Hold on. Because you can't make it up. This is from Matthew McCabe. Thursday, again, Halloween. A couple days before they started sending crazy emails about me. Dear Special Prosecutor Robert Cosgrove, Norfolk DA Michael Morrissey, and Acting U.S. Attorney Josh Levy. I currently don't have the email of Special Prosecutor Cosgrove or ADA Adam Lally. Please share. Last week, myself and my wife, Jen, had the opportunity to sit down with Special Prosecutor Robert Cosgrove. It was great to discuss with him the current situation and to talk about things moving forward. Upon reflection, I feel that as witnesses, especially my wife, we are being placed in a no-win situation. Our friend John O'Keefe tragically lost his life. Oh, now he's your friend. And as part of a disturbing defense strategy, we are being falsely accused of causing his death by thousands of people. We are targets of a despicable campaign of criminal witness intimidation and harassment. Due to many issues that are outside of our control, the current case against Aidan Kearney has not proceeded forward, and we anticipate and expect more delays. While this is going on, his targeted harassment, along with others on social media, has amplified. Each day, we are subjected to thousands of defamatory and libelous comments directed at my wife, family, and friends. This is ongoing online harassment, or more accurately, cyber crimes that are specifically targeting key witnesses in the Karen Reed case. The damage that has been inflicted on my family is irreparable. My children, my wife, and I live in constant fear and uncertainty as to what is coming next from this Free Karen Reed mob. Okay, so this is between the first and second trials. This is after the mistrial, Halloween 2024. Aidan Kearney was arrested almost exactly 1 year prior to this and charged with the witness intimidation charges. And Aidan Kearney spent time in Norfolk County Jail between December and February. December, when was it? It was December of 2023 into February of 2024. 60 days. Aidan Kearney has been operating as a mouthpiece for the defendant, who has only been emboldened by the Department of Justice's involvement. The involvement by the DOJ has only empowered him and others to continue these reprehensible acts as more individuals feel justified in joining this campaign of cyber harassment and witness intimidation with no accountability. The full extent of the psychological harm we have suffered has yet to be realized. As to why the DOJ is involved in this case, I don't know that answer. At the time, I welcomed it, as I know that myself, my wife, my family, and my friends were not involved in the tragic death of our friend John. In the end, I expected the DOJ to show the public that the accusations against the witnesses have been unfounded and that there is no conspiracy. The DOJ knows that the witnesses are not involved, but instead of our names being cleared, all we have received is continued harassment by the FKR mob, which, period, and then new sentence, which has only been fueled by this open investigation from the DOJ that has compromised the state's case against Karen Reed, has swayed public opinion and tainted the jury pool. You know who tainted the jury pool? Michael Morrissey, when he made that hostage video. Hold on, because now I got to find page number 2. Could you make this up? No, you couldn't. Our friend John. I don't know. I've been speechless a lot lately. Hang on here. Let's go to page 2 of Matt McCabe's email. The state is currently prosecuting Aidan Kearney for witness intimidation, but that has done nothing to stop the continued harassment. We have provided you with ample evidence of his continued intimidation/harassment. As stated in a recent Vanity Fair story on Karen Reed, Kearney has turned this situation into making himself $50,000 per month. He has built this income around spreading a conspiratorial narrative of lies, harassment, and criminal witness intimidation. Via use of the internet, Kearney has engaged in cyber criminal activities using digital platforms to propagate false information and manipulate public opinion. This orchestrated campaign of deception directed by the defendant, Karen Reed, not only distorts the truth, but also breaks the law, highlighting the broader issue of how the internet is being weaponized to facilitate such illicit operations. Well, he's never been charged with cyber crimes, but you know who works in cyber security? Matt McCabe. After reviewing some of the more recent events that we have shared to show this behavior, I strongly disagree with the assertion that we need more material. Assertion? Do you mean to say assertion? Is assertion a word? So were they being told that they need more to charge him? That they need more, that they don't have enough? Sounds like it, because he said he had the pleasure of meeting with Cosgrove, the opportunity to sit down with Prosecutor Cosgrove. What was Cosgrove saying? You need more. You don't have enough. Sounds like on September 19th, my wife, an innocent woman, was publicly branded a murderer on the steps of the Massachusetts State House. And then in all caps, the Massachusetts State House. That incident alone constitutes witness intimidation. On October 19th, Kearney publicly states on his YouTube show, talking about Jen and my daughter Allie, here are some quotes from Aidan Kearney. Quote, and this is now italicized. I'm going to enjoy that family getting separated. I'm going to enjoy the F out of that. Quote, with Jenny McCabe, it's going to be great because her kid is Allie McCabe and she sucks too. Allie McCabe is the getaway driver to a murder. She's an accomplice to a murder. And then she lied about where she was that night. He did misspell Massachusetts. He did. Look. He spelled it with an ES at the end. Quote, watching that family get split up is going to make me hard as S. On October 23rd, Kearney publicly states on his YouTube show, directly stating Jen's name and that he's talking to her. He makes the following statements. I will never stop, no matter what happens. This is forever, and you will only be able to hide between the witness label for so long. No matter where you go, people are always going to look at you. That is the bitch that Googled Haas long to die in the cold. You are a murdering POS. We are not going anywhere, all caps. Oops. On October 25th, Kearney publicly states, when talking about Jen at a fundraiser, quote, she's going to jail. And Jen, I'm going to be there when your ass gets sentenced, and this is the last face you're ever going to see. On October 30th, Kearney publicly posted a photo of myself and my wife, along with other parents, at our children's high school soccer game to his 100,000 followers, stating, oh, wait, now I got to find page 3. Stating, we're like on the edge of our seats here. Imagine sitting next to a cold-blooded killer like this at your kid's soccer game. We all know what you did. This must be stopped. As witnesses of the state and a federal investigation, we are only being subjected to more intimidation and harassment. Every day we live with the uncertainty of what is coming next, who is showing up to our house, our kids' events, and what they will do. Why would anyone want to be a witness under these circumstances? Knowing John O'Keefe, if he could walk through that door, did Matt McCabe even know John O'Keefe at all? Somebody remind me. Did he? This must be stopped. As witnesses of the state and a federal investigation, we are only being subjected to more intimidation and harassment. Every day we live with the uncertainty of what is coming next, who is showing up to our house, our kids' events, and what they will do. Isn't it ironic, don't you think? A little too ironic that they named their organization under which they collect donations Testify when they really don't want to testify at all and they're trying to get out of their depositions. Do you think it's ironic? Borderline. Excellent comment. So the voodoo dolls weren't working. Why would anyone want to be a witness under these circumstances? That's in bold. Knowing John O'Keefe, if he could walk through the door, he would tell my wife to walk away. He would tell her this is not worth it. What has happened to us is a disgrace to our judicial system, a disgrace to our state, and has set the wrong precedent for future witnesses. Oh, wow. While this case has made the state of Massachusetts, well, it's a Commonwealth, sir, out to be a complete embarrassment in the eyes of the public. Well, that's true. You're right about one thing. Our leaders have stood idle. The DOJ has made a mockery of the state police investigation and refused to stand up to clear the witnesses' names. The Massachusetts Attorney General has sat back while the governor and leaders of the state police thought the best option was to punish the state police officers at the forefront of this investigation. The punishment of those dedicated officers is a mistake. Every decision or non-action that has been made by the people who should be leading this state has only fueled the FKR mob. Your mob. I mean, there's a mob involved here, but it's like the Canton Mafia. It's not the free Karen Reed mob, it's the Canton Mafia. We all should be ashamed and should work together to make sure what has happened to my family never, ever happens to anyone else again. Thank you for your time and effort. And to those who are trying to help, but enough is enough. Capital E, capital E. It's time to bring forth additional charges now. As we have expressed in person and have mentioned previously, we live in constant fear and uncertainty for my family's safety. This defines witness intimidation. I look forward to your response and the next steps. Best regards, XOXO, Matthew McCabe. Ann M says, FOIA request by Kyle Sharkey came with all of Morrissey's emails. Oh my God, my inbox is going to be overflowing. Right. He knew him as the guy who never went in the house. Right. There's a man passed out in the snow. There's a guy. He's unresponsive. Send somebody. Send somebody, please, quickly. Sorry. Tell him the guy never went in the house. Right? You're in a mob, a cult, cupcake posse. I don't know what you want to call it. So the timing of this email was sent by Matthew McCabe to everybody on Halloween 2024. Wow. You can't make it up. Kyle Sharkey has all of Michael Morrissey's emails. I don't know how many thousands of pages it is or how many terabytes. But it's all coming out now, including me, including my name is in there. What's up? What's up, meatball? What's up, Tully? Wonder how many stock accounts they have. Oh, this is going to be explosive. It's going to be explosive. It is. Are you ready for season 4? You ready for season 4? Dancing Quinn, I just emailed a few pics from my trip to Salem. I hope you can open them. Awesome. I'll check later, but I'm very busy at the moment. But thank you, Dancing Quinn, for your 5 to tell me that. It's not loophole, it's a-hole. Thank you. Thank you very much for your compliment. Allegedly 5 and your super chat. Toby's mama said I sent a definition of forensic decorum on a super chat. I mean, I've put up a lot, but except for the $2 ones, because I can't be trolled right now. So thank you for that. I'll have to go back and look for it later. Oh, here it is. Thank you, Toby's mama. Forensic decorum refers to the formal rules of behavior for legal and crime lab professionals. It requires scientists and lawyers to act in a polite, honest, and neutral way. This ensures fairness and something else. Thank you for your 10. You got cut off. But yeah, okay. So forensic decorum. Well, I don't know. I wonder where he pulled that from. Because there were 2 different articles that he pulled his quotes from. That was one of them. The one that we read from the freshman at Brandeis. And yes, Gildea'a is an anagram of Gilead. We covered that earlier. That's why we have this rubber duck that Jamie made with the Handmaid's Tale outfit on it, because it's so fitting. The absurdity of all of it. Thank you, Technical Out, for supporting me and appreciating me, and I love you with all my heart. Thank you very much. FYI, I'm very good at getting TROs. Oh, shoot me an email. There's some other plans in the works, but I have your email. You've emailed me before. Thank you for your super chat. Sarah Fitz, Dublin, Ireland, Sláinte. Loving you from across the pond. Happy 4th of July, all. Thank you, Sarah. If LL is a plant, this would put him against you, says Jessa. Susan, Melanie, you want to FOIA your name? Yikes, scary. I'd hire Corey Hopkins to do it and then file a lawsuit, and then, you know. Coco says, 60 is the new 40. I'm 63 and a proud my wife, mother, and grandmother. Happy 4th. Oh, happy 4th to you too, Sweet Pea. Thank you for your 20, Coco. Aunt BB says, call Bettero, brother counselor Tom Kokanowski, since Corey's on vacation. Oh, it's okay. It's not an emergency or anything. It's still going to be here on Monday. Thank you, though. BC says, wasn't Maddie the one that texted telling the guy never went in the house? Yes, he was. Thank you, Angel. Thank you, CC. It's been a while for a live, says Lisa. Happy 4th. Happy 4th. Can you make it up? Can you make it up? No, you just can't. No, you just can't. So now let's get back to our regularly scheduled program. It's kind of hot outside, and, you know, I don't need to get out today because it's a little too hot to sit out there. It's only Friday, and there's a lot of you guys still here that want to go back over. Call George Clooney. Let's go back and look at Judge Cannone's order on defendant's motion to dismiss for extraordinary governmental misconduct, because I said I would, and I don't like to write a check I can't cash and or promise you something that I don't deliver and have to put this over to another day. We're going to start again. On June 9th, 2022 is Judge Cannone's decision that was filed in, did we say it was filed March of 2025? Hold on. Let's get it right. Because a lot of people, including Fervent, who did a whole entire very long video today on Adam Lally, I think that Adam Lally is deeper in this than anyone knows. And if we go back to the proceedings with Miles King, March 25th, so 5/25/25, this was issued by Cannone. We've looked at some recent papers in the Miles King case that also help us use our context clues about what Adam Lally knew, did, didn't do, didn't turn over, etc. But Matt McCabe is a victim, everyone. Tell him the guy never went in the house. Why would you have to tell anybody to say that if it's the truth? Why would you have to remind people what to say? Why would you have to tell Chris Albert what to say when the media was inside D&E Pizza that day? If she pleads, it's all over. If not, it's a whole other episode. Matt McCabe said that too. I use JLab earbuds. I can link them to the stream later when I'm finished, but thank you for asking. Those are the ones I like because they're like 20 or 30 bucks and they, I can't keep checking my email every 5 minutes. I just can't. Oops. Hold please. All right. Yeah, I know that you guys are sending me stuff on this Carol Jacques, but I'm not going to publish any of that. So thank you. I will check my emails later, etc. Thank you, though. I appreciate you and all of your help and support because you guys are amazing. All right. I got to finish reading this mishigas of an order, and I have to stop getting sidetracked, which is hard for a person with ADHD, self-diagnosed by Instagram. Okay, here we go. On June 9th of 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th of 2022. The Commonwealth theory of the case is that the defendant, while intoxicated, struck and killed O'Keefe while operating her vehicle in reverse and left the scene. Trial on the matter began in April 2024 and concluded on July 1, 2024 with a mistrial. The matter is set for retrial April 2025. Ahead of the retrial, defendant has filed a motion to dismiss for extraordinary governmental misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon. Because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. Yes, if you never heard this the first time, this is a reminder that the judge said, no big whoop, no biggie. She's getting a new trial, no prejudice. She's getting a new trial. It doesn't matter that they didn't turn over any evidence or that they hid stuff in a drawer like she's going to tell us Michael Proctor did. So I'm not going to toss the case out because it's all good. She's getting a new trial. Here's the discussion of the case law and all of the reasons why Judge Cannone decided that she was right. But what's most interesting about this decision, I don't know how long it is, 20-something pages, is her spinning and her interpretation of the facts as she sees them. And all of the reasons why the case shouldn't be dismissed. And she doesn't even need to hold an evidentiary hearing. Yep, no tampering, LOL. Thanks, Tiff, for all the things you've been sending me. Thank you. And then she goes on and on to talk about some more case law. And it's not really a big deal that the prosecutor failed to disclose evidence. And here's something pertinent. First, here's the two parallel legal principles that govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Alternatively, in rare circumstances, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. Well, do you not think that this entire investigation was poisoned? Based on what we know now, and even the things that she's going to go through that she even considered in her determination and decision here. This is old. This is from March of 2025. We're looking at it now with hindsight, because hindsight's always 2020. The defendant here argues that the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. Right, that was Fanning, remember? As discussed below, the defendant has not demonstrated that she suffered any prejudice as a result of discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. Section 1, Judge Cannone talks about the Commonwealth's discovery violations. And she says that remember also, just before I forget, because that's why I interrupt myself sometimes, Aaron Spencer's new judge in Arkansas dismissed the charges, the murder charges against Aaron Spencer, because he found an egregious discovery violation by the sheriff's office and prosecutor in the case, because they did not turn over or lost the dash cam and or the SIM card, or whatever the hell they call that thing, the chip, the SD card inside the dash cam of Michael Fossler, and it was never logged into evidence. There was a lot of problems with the chain of custody, and then it was lost, and the judge outright dismissed Aaron Spencer's murder charges. The judge held an evidentiary hearing, which is something that Judge Cannone did not do. She's just denying this on papers alone. Same thing with Rust. Same thing with Alec Baldwin's case. Yep. Both of those cases, right, had evidentiary hearings. Cannone never allowed it. This is just based on papers. Okay? She talks about the discovery obligations of a prosecutor, and that the due process clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. See Brady v. Maryland, 1963, which stands for the proposition that prosecutor may not withhold evidence that would tend to exculpate a defendant or reduce the penalty. Yeah, they lost the dash cam, yeah. Evidence is exculpatory if it provides some significant aid to the defendant's case, whether it furnishes corroboration of the defendant's story, calls into question a material, although not indispensable. A material, although not indispensable, element of the prosecutor's version of the events, or challenges the credibility of a key prosecution witness. Exculpatory material is subject to automatic disclosure under Graham. Remember, she loved that case, Graham. She would always cite that. The Commonwealth's duty to disclose exculpatory evidence to criminal defendants is further reflected in the Massachusetts Rule of Criminal Procedure and the Rules of Professional Conduct. She goes on to cite the rules. And Rule 14, which interestingly enough, Rule 14 of the Massachusetts Rules of Criminal Procedure was rewritten after Karen Reed's first trial And guess who spearheaded that and who was the head of the committee to rewrite Rule 14? That's right, Judge Beverly Cannone was. And that's why she says the rule in effect at the time of the discovery here, right? Discovery issues here, right? Because it was changed specifically, I think, because of Karen Reed's case. Provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. This includes any facts of an exculpatory nature, material, and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person, or of scientific tests or experiments, and statements of persons the party intends to call as a witness. Rule 14 further provides that when a party has provided all the discovery required by Rule 14 or a court order, it shall file with the court a certificate of compliance stating to the best of its knowledge, and after reasonable inquiry, the party has disclosed and made available all items subject to discovery. And there she's citing the Massachusetts Rule of Civil Procedure, interestingly enough. And then footnote 1, which says the Standing Advisory Committee on the Rules of Criminal Procedure recently proposed revisions of Rule 14 in response to the SJC's requests in a case for clarification on the definition of exculpatory evidence. And she is the one who spearheaded or was the head of this committee. And it was to take effect when, does it say here? March 1st, 2025. I mean, tell me that wasn't redrafted specifically because of what happened in the Karen Reed case. Okay, so she's like, that was the old rule. Now we have the new rule. And here's what she says about Section B, the Canton Police Department surveillance footage. Facts. On January 29th, 2022, after O'Keefe was found dead in the snow outside the Albert residence in Canton, Mass., police towed the defendant's vehicle to the Canton Police Department. There were multiple surveillance cameras in use at the Canton PD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sally Port at approximately 5:30 p.m. There were also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Remember that? They said it overwrites every 30 days. She never held a discovery, an evidentiary hearing on this. And this is insane because now we find out differently. All of a sudden, after this decision, other videos started popping up. Video from before, video from January 1st of 2022. She says, footage from the night in question was not lost. However, because Canton PD Sergeant DGM Pietro followed his customary practice of downloading the recording to a hard drive in 6-hour segments. Remember, he was retired and the hard drive was somewhere like at his house. On February 2nd of 2022, 2/2/22. Numbers, people. The defendant, Karen Reed, was charged with manslaughter, motor vehicle homicide, and leaving the scene of personal injury and death in Stoughton District Court. Remember, there was a Stoughton in the Salem Witch Trials? That day, the defendant filed an emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. Preservation order, that's right. That was David Yannetti. King David filed that motion. The preservation sought to preserve, among other things, all physical evidence, including anything present or near the decedent at the time his body was discovered, anything found at the alleged crime scene. The lead investigator in this matter, Massachusetts State Police Trooper Michael Proctor, oh, she's calling him the lead investigator, notice, not customer service rep, took possession of the requested Canton PD video of the Sallyport in February of 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. I'm sorry, what? I'm sorry, Your Honor, where is this information coming from if you didn't hold an evidentiary hearing? Where's it coming from? The call's coming from inside the house. Where did you get this information that Michael Proctor took possession in February 2022 of the Canton PD video of Sallyport, but he didn't turn it over to the prosecutors? Instead, for reasons unclear on the record, so make the record clear. Hold a hearing. That's what hearings are for. Did Michael Proctor ever testify to this? I don't think so. I don't think so. So she's just making up shit in her order and doesn't have an evidentiary hearing? This is wild. On June 9th of 2022, right? Because she didn't take a plea. So they upgraded the charges to murder in the second degree. And the other charge is manslaughter and leaving the scene. That was June 9th, 2022. On October 5th of 2022, this court issued an order directing the Commonwealth to provide the defense with, among other things, inter alia means among other things. There's your Latin lesson of the day. All crime scene photographs and or videos taken in connection with this case, including, but not limited to, photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29th, 2022, and February 4th of 2022, including the metadata associated with these photographs and videos. Oh, so the court issued an order demanding the preservation of metadata? That's so interesting because there's no metadata for anything. Several months later, in June of 2023, Proctor asked the Canton PD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck on January 29th of 2022. How do you know? Proctor asked them in June of 2023. I don't know. Let's look and see what the footnote says. It is unclear to the court why Trooper Proctor requested the footage at this time. Are you kidding me? That's why you need a hearing. You know what else we know about Michael Proctor? And what we've learned through our one of our queens, Rosemary Scabiccio, is that he failed to turn over exculpatory evidence and other evidence in the Miles King case that he also investigated. And the reason we have all of Michael Proctor's racist messages is because Rosemary Scapiccio got him. But where is Judge Cannone getting this information from? Is she having ex parte communications with Adam Lally? Where did it come from? If all of Michael Morrissey's emails were released today, I hope somebody can track that down. Was it ever testified to that Proctor asked Canton PD whether it had in its possession exterior Sallyport video in June of 2023? In response, Canton PD gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Again, the judge is now throwing Michael Proctor under the bus. She says, instead, he placed it in his case file. Okay, says who? Who told you that? All the more reason that Michael Proctor should have been dragged and put under oath and questioned by the attorneys. Exactly. Caroline says, wow, so glad you're going back over this. Sometimes we have to go back to understand what happened then and what's happening now. Right. This was before trial, right before trial number 2. Instead, he put it in his case file and didn't turn it over to the prosecutor. Says who? This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the Canton PD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side of taillight, a significant issue and dispute in this case, cannot be discerned. Oh, Colleen Crawford. Remember when we went over some recent invoices? Some recent invoices for all the software that Colleen Crawford ordered, $20,000 of it. Video editing software, Photoshop type software. That's exactly why they needed an evidentiary hearing. On February 1st of 2024, that was in trial number one, at the federal grand jury, Proctor testified before a federal grand jury investigating the investigation into O'Keefe's death. This is the original copy that I downloaded when it first came out in 2025. And so there is a redacted portion. I wonder if the unredacted portion was ever released to the public, because I want to see that, because then everything that he testified in front of the federal grand jury here is redacted from the court's order. Remember also that when Proctor testified in front of the federal grand jury in February of 2024, all of his text messages came out. And remember also that the same day that Michael Proctor testified, he must have called Fanning and Tully and told them about it, because they went to his house to do a wellness check. And then what had happened was Tully said the reason he couldn't discipline Proctor for the things that he'd said in those text messages was because he had to sign an NDA. And so he wasn't allowed to talk about those text messages. And that's why he gave Michael Proctor at his QBR a glowing 5-star review, because he wasn't allowed to talk about the text messages. Remember that? I do. Josie Lowe says the Fund LLC, which was a company owned by Fanning and Colleen Crawford, just one of the video companies that they owned together throughout the years, was dissolved on 2/2 of 22. Thank you, Josie Lowe. I know that's true because I remember looking it up myself, because corporate records are public. Because you can't make it up. They had grave concerns, and so they had to do a house visit. They did a drop-in on Proctor to make sure that he was okay, right? A wellness check. And Emily says the NDA wasn't in effect on that day. He's such a liar. JoJo's grave concern says, Queen Corey, Emily C., and Kyle Sharkey, please, for all of you, to request the communications to and from regarding Colleen Crawford, please and thank you. I think it's been done. It's all been done before. That's another Bare Naked Ladies song. "2222" says Sherilyn, once they'd corrected all the video. But wait, there's more. 3 months later, on April 4th of 2024, ADA Adam Lally received Proctor's federal grand jury testimony. Oh. Okay. After reading Proctor's testimony, Lally asked the trooper if he was in possession of the video footage referenced therein. Again, where is all this coming from? Why wasn't Lally examined under oath about this? Why wasn't Proctor examined at an evidentiary hearing? I mean, Judge Krupp ordered it in Miles King. He pulled the plug on it, but still he ordered it. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 2022, but not the main driveway side exterior Sallyport footage provided to Proctor in June of 2023. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the Canton PD main driveway showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. Again, where is the judge getting this information? Why is she protecting Lally? And why is she throwing Proctor under the bus? Footnote 4. See what that says. It is unclear to the court where the Canton PD main driveway footage came from. The Canton PD main driveway camera appears to show a different view than the main driveway side exterior camera. The recording from that camera remained in Trooper Proctor's file. She is once again making conclusions of fact without a hearing. How do you know what was in Trooper Proctor's file? This has befuddled me since this decision came out. I remember screaming about it then. I'm going to continue to scream about it now. On April 10th of 2024, Lally filed a certificate of compliance indicating that to the best of the Commonwealth's knowledge and after reasonable inquiry, it had disclosed and made available all items subject to discovery pursuant to Criminal Rule 14. Or court order. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12th of 2024, days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. So many lies, so little time. A lot of this ties into the Fervent video that was released today. So after we read this, if you haven't watched it yet, go back and watch it. And you're going to see, I think, Alan Jackson and Adam Lally arguing about a lot of this stuff before the first trial. Trial began on April 16th, 2024, with the first day of evidence on April 29th, 2024. On April 17th, 2024, of course, Lally received footage of the Sallyport interior back wall camera from the Canton PD, which had been looking for continuous camera footage of the Sallyport on the relevant date. Right. The Canton PD was looking for it. How do you know they were looking for it? On April 23rd, 2024, Lally provided the Sallyport interior back wall footage to the defense. The images contained in this footage were inverted. That's right, they were. Crazy, isn't it? State Police Sergeant Buchanan testified on June 5th and 6th, 2024. What a pompous ass he was. Oh, did anybody see the video of him? He's like on a cruise right now doing karaoke and singing at the top of his lungs. Proud to be an American where at least I know I'm free. And he's out there like singing. And remember when he was on the stand and he said that English is his third language? Can you pull out a dictionary and tell me the meaning of the word theory? But he's real proud to be an American now when it suits him. It's cringe. Emily C says, fun friend, unpopular opinion. I bet Yuri is actually a fun friend. Well, he went to Dave Matthews because people had pictures of him at Dave Matthews in Mansfield, and I'm so glad I didn't go. Maybe he is a fun friend. But he appeared as a pompous ass when he was on the stand trying to protect his friends. Oh, he was also singing Sweet Caroline, of course. I mean, he's free for now. How can the footage be intermittent? It's a police precinct. Yeah, it's motion activated, whatever. Whatever. To all of you who sent me emails, thank you. I do read them all. I do not respond to them all. There's a lot of funny jokes I can make about that, but right now I'm not going to. Also, I don't like hanging around with people who are just really drunk all the time. It's not my thing. I don't like it. State Police Sergeant Buchanan testified on June 5th and 6th, 2024. During his direct examination, Lally showed the inverted Sally Port interior back wall footage in open court. Because the video was inverted, what appeared on the screen as the right side of the vehicle was in fact, the left side, and vice versa. The direct testimony did not alert the jury that the video was inverted. On cross-examination, however, defense counsel questioned Buchanan extensively about the inverted image. Right. You're a good trial lawyer, Mr. Jackson. You can make your points. You're a good trial lawyer. The Canton PD began a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. As part of this process, Canton PD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot at the Canton PD in the early morning hours of January 29th, 2022, prior to O'Keefe being discovered in the snow. The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m., holding a phone near his face. That's true. Remember, she also put a little sticky note on there or something. LOL, no tampering. This is how the camera records. It records inverted. LOL, no tampering. She retired too, but I heard she's still working. Mm-hmm. In September of 2024, Special Prosecutor Brennan joined the prosecution team. Oh, I know. Michael Morrissey was sending him emails about me, him and Tully. By November. We looked at those before. If you're late, you can rewind and you can see what just exploded out of Michael Morrissey's email today about me. On October 10th, 2024, he provided the rear lot cruiser footage along with other surveillance videos. The Canton PD interior hallway, the church side exterior Sally Port, the rear lot main side to the defense. Right after the first trial. She wasn't convicted. Do you think if she was acquitted, that would ever seen the light of day? Marta, please no all caps. It's very distracting to me. And it's not going to make me pull up your messages. It's just going to make me annoyed. Please don't do it. I already did it once. Okay, so Brennan came in but I thought everything overwrites itself within 30 days. Why was it still available? Why did it still exist? Hold, please. On November 8th of 2024, the defense emailed Special Prosecutor Brennan requesting all raw video footage from the Canton PD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and or exterior of the CPD, including all parking areas, entrances, exits, and garages between January 29th, 2022 at 12 a.m. and January 29th, 2022 at 11:59 p.m. Special Prosecutor Brennan responded that he would request the Canton PD collect and produce all footage responsive to the request. Thereafter, Brennan asked all associated law enforcement to go through all files and databases to facilitate a review of any footage. During this process, Brennan came into possession of the main driveway side exterior Sally Port footage, originally obtained by Proctor in June of 2023 and not previously turned over to the defense. How do you know that's when it was obtained by Proctor? Again, none of this is under oath. I don't know where she's getting this information from. Do you? Because if I'm wrong and it's out there somewhere in sworn testimony, please let me know. And to be clear, when we watched the Lucy Medina trial, Hank Brennan was her defense attorney, and I had a whole new impression of Hank Brennan after watching him try that case. And I don't think that he was involved in the shenanigans, tomfoolery, and ballyhoo in this case. And I think that he was used as a pawn and paid very highly to do it. I don't think he wants anything to do with this. That's why he sentenced Karen Reed, or he agreed to sentence her on the same day as her acquittal. Well, she was convicted on the drunk driving charge that never even existed by itself in the first place. And I think, you know, at the end of the day, he's a good guy and he wouldn't have done this himself. And that's why they had to hire a special prosecutor, because they were all in too deep. But that's not what they told the constituents. They told the constituents that, you know, I don't even know what they told them. They didn't have a conflict or anything. Greg Conner didn't want to touch it. I don't know. On January 28th, 2025, the Commonwealth turned over the main driveway side exterior Sallyport video to the defense. As noted above, the footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the garage, but the quality of the recording is, as noted, poor. Right. Or altered. Or proctored, doctored, Crawford. Defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain Canton PD surveillance video in violation of Rule 14, Brady, and the court's preservation order, and October 5th, 2022 order on motion to compel discovery. She further contends that the timing and quality of the video footage that has been produced demonstrates that the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. According to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. We saw it in Aaron Spencer before he was even tried. His case was dismissed because of egregious governmental misconduct and the loss of that dash cam of Michael Fossler. We saw it in Alec Baldwin's trial in New Mexico when the judge threw that case out while the trial was ongoing because of Carrie Morrissey. This is weird too. Her name is Carrie Morrissey. She too was a special prosecutor in the Alec Baldwin Rust trial. And she failed to turn over evidence. Judge dismissed the case. It was wild. We should go back and watch that one day. Carrie Morrissey putting herself on the stand. Feel free to put in the chat or in the comments other cases that you recall where judges did throw out cases based on failures by prosecutors to turn over discovery timely. But this judge says, this is Judge Cannone, May 25th, 2025. This argument is flawed in several respects. First, contrary to the defendant's arguments, there was no court order requiring the Commonwealth to preserve or produce Canton PD surveillance video before the first trial. I mean, she's kidding me, right? The murder weapon. According to the Commonwealth, well, I'm breaking from this for a second. According to the Commonwealth, Karen Reed's Lexus was the murder weapon. Right? But the judge is going to say that because it didn't specifically say you have to preserve the Canton PD surveillance video, it doesn't matter that they didn't turn it over? And then she goes into the wording of the order, and we read that earlier. And she says, this order did not extend to the surveillance footage from the Canton PD. Trying to give herself a good out here. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. Again, video surveillance footage of the Massachusetts State Police taking the murder weapon into their possession into the Canton PD Sallyport garage when the Canton PD had already been recused from this case. Okay? It never should have been there to begin with. Remember, when it was found out, and it was known right away, quite honestly, that 34 Fairview was the home of Brian Albert, whose brother Kevin was a detective at Canton PD. They were recused from this case immediately. Massachusetts State Police takes jurisdiction when there's a homicide. That car never should have been brought back to the Canton PD at all. There were many Massachusetts State Police barracks along the way from Dighton to Canton where it could have been housed. Right? And she goes on to cite some more cases to say that to prove her point here. Moreover, where the physical evidence described in the preservation order was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene, the order cannot reasonably be interpreted to include surveillance footage from the police station. Right. Because her car wasn't found at the murder scene. Mm-hmm. Cool. Because he wasn't hit by a car. Oh, please. The order cannot reasonably be interpreted as including surveillance footage from the police station. Oh, really? Okay. Keystone Cops. The October 5th, 2022 order on the motion to compel discovery also did not require the Commonwealth to produce any Canton PD surveillance video to the defense. That order required the prosecution to produce evidence of all crime scene photographs and or videos taken in connection with this case. The Canton PD was not part of the crime scene, and therefore the order did compel production of the Canton PD videos. Well, I think there's a typo there. I think she meant to say did not compel production, because I made a red arrow there for some reason. Also, probably to remind myself that the Sally Port actually was a crime scene if somebody tampered with that taillight. Remember all the ghostly, the amount of paranormal activity that took place in and around Canton on January 29th of 2022 is wild. I mean, the ghosts coming in and out of the video, exploding taillights, magically appearing pieces of evidence. I mean, it's wild. There was a lot of paranormal activity going on in Canton that day. Please read the anonymous letter. I don't know what you're talking about. This is not the end of the inquiry, however. The absence of a court order requiring production of the Canton PD surveillance does not foreclose the possibility that production may still have been required under Brady or Rule 14. Right, exactly. The defendant contends that the prosecution should have inquired of the Canton PD if any footage existed and then produced all the footage because she maintains that it contains exculpatory evidence. Right. Taillight tampering. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence. Assuming, without deciding, that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. Don't worry. This is Massachusetts. Okay? We've been trying witches since 1692. We're certainly not going to stop now. No prejudice to her. I mean, we might hang her at Proctor's Ledge after all this is over, but she's getting a new trial. So why are quit complaining? In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose to the defense as investigative materials, video and audio recordings in the possession, custody, or control of any member of the prosecuting team, and that's the new rule from 2025. The Rule 14, in effect, at the relevant time, had no such requirement. Let me just explain to you. Prosecutors are held to a much higher level than defense attorneys are. And this is wild that she's putting this in writing. No requirement to turn over any of this stuff. Nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. Oh, Lally had no obligation to find out if this stuff was there. And then footnote 5 goes on to talk about the new revision to Rule 14 and how they've, strengthened the prosecutor's duties to inform and inquire, collect and disclose, preserve and notify defense. Because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. I'm sorry, what? How long were they screaming that Higgins should have been considered a suspect? And then the video has Higgins inside the Sally Port, outside the Sally Port, moving bags around from car to car, talking on the phone when he swore he never made any phone calls in those early morning hours. Taillight tampering was a huge part of this case, and there's no way the prosecution should have known that. Until the Commonwealth knew, for example, that the defense theory included that law enforcement tampered with the taillight while it was at the Sally Port, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to when any relevant video footage existed. Again, she's doing all of this without a hearing. Footnote 6. Defendant also argues that the rear lot cruiser side camera footage should have been turned over because it was an exculpatory impeachment evidence that the defense could have used to show Higgins perjured himself before a federal grand jury when he testified that he did not call anyone on the night in question. Defendant's memorandum at page 20. That argument fails for several reasons. First, it's not at all clear how, within the bounds of admissible evidence, the defendant could introduce evidence of this alleged perjury at her criminal trial. Right, but don't you think it makes a good argument for tossing the case? Like, I can't even believe this woman. And remember, Higgins wasn't even called to testify in trial number 2. It was much more streamlined by Hank Brennan. He didn't call every single person that was at or drove by 34 Fairview that night in early morning hours and was in the house. Hi, Mazza. Mazza's prepping his griddle for tomorrow. Second, even a cursory review of Higgins' grand jury testimony reveals that he said that, and then it's all redacted. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face, does not clearly show, as the defendant represents, the witness speaking to some unidentified individuals on the phone. Well, we would know that if we had his phone records, but you denied that Rule 17 motion also. The clip does not reveal how Higgins is utilizing the device, and it in no way establishes that he perjured himself before a federal grand jury, says she without a hearing. Oh, this Handmaid's Tale Ducky is so appropriate. Finally, in this regard, the remedy for non-production of this video clip is not dismissal because the defendant's rights are fully protected by her ability to use it for all it's worth at the retrial, right? Except Higgins didn't take the stand. And he was never considered a suspect when he should have been. When he cherry-picked all of his text messages with Karen Reed and John O'Keefe and printed them up after illegally using an FBI kiosk that his bestie Matt Kelch allowed him to use, and then printed them all up on copy paper and brought them in. I wonder if he binder clipped them for them and said, here's all my messages. Yeah, I was trying to bang O'Keefe's girl, but no big whoop. Don't consider me a suspect. She thought I was hot after all. And I wanted to know after this 2-week textationship where our relationship was going, what she was looking for, what she wanted from me. I had grave concerns about whether she was using me. In footnote 7, that says, with respect to the main driveway side exterior Sallyport camera, even if Proctor should have turned it over to Lally prior to trial, again, why is she throwing Proctor under the bus? The quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. Exactly. Exactly. And there's ghosts appearing and disappearing, apparitions, figures moving in and out. You didn't care about the metadata, so you let it into evidence. To the extent that the defendant contends the footage would have been used to impeach Buchanan's testimony, she will have that opportunity at the retrial. No big whoop. You're getting a second bite at the apple, girly. Reminds me of like Snow White and like the evil queen and the bite of the apple. So it's like a fairy tale nightmare. It's like a nightmare fairy tale. This is not to say that the Commonwealth had no duty to turn over the Sallyport interior back wall footage before the first trial. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence, and because she has advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown that she was prejudiced as a result of the delayed disclosure. Footnote 8. Moreover, during cross-examination, Jackson questioned Buchanan extensively about the video being inverted and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the Sallyport. Right. So she's like, I don't have to punish the prosecution because Alan Jackson's a great trial lawyer. But again, there was a mistrial because of a hung jury. Because of these shenanigans, maybe. We don't know, because we don't know exactly what happened in that jury room. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. Citation omitted. As I recall, the way it happened, the way that it played out, the defense did not realize that it was inverted until they showed it in court. Right? That's the way I remember it. The way that you authenticate a video is like this. Sergeant Buchanan, is this a fair and accurate representation of the way the Sallyport looked on January 29th of 2022? Buchanan said, yes, it is. And then he played the video. And then his direct examination ended. And I seem to remember Alan Jackson, David Nelly, Liza Little, and Craig, the man of the tiny desk, Craig Bates, who was the AV squad during trial number 1. And I say that in the fondest of ways because Craig came on our channel. We love Craig Bates so much. He's a very, very tall man, and he was forced to sit at like a TV tray table in the courtroom because the judge would not allow him to sit at defense table. And his knees were practically in his chin, and he had a little tiny table that he had to have all his equipment on. Yep. AJ and Karen noticed it in court when they realized the numbers and letters on the wall were backwards, right? And on the antique cruiser. And you guys in the chat noticed it too. And I don't remember if they had like a day in between, like court ended, and I think they had some time to go back and like invert it to its proper orientation, and then question Buchanan about it again. And when questioned by Alan Jackson, Alan said, but this isn't, you said this was a fair and accurate representation of the way the Sallyport was on the 29th of January. Oh yeah, I said that. But don't you see that I'm summarizing now, that it's actually inverted? It's backwards, so that the right rear passenger taillight looks like the driver's side taillight and vice versa. And all the people that are gathered around the taillight, it appears that it's the wrong taillight. And he's like, well, yeah, it's like It's like a mirror, you know, like everything is there when you look in the mirror. It's just, you know, just like backwards. No big whoop. Right. Back to the papers. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with the metadata. There is no merit to this argument, right? Because we don't believe in metadata in Massachusetts. The defendant did not make any specific request for the original footage with metadata before the first trial, before it was overwritten. I'm sorry. But if anything was original, it would have metadata. I mean, I'm not a forensic expert, right? I'm not a forensic expert at all. If you put the dirty nickname for Buchanan in the chat, it's going to be deleted, and just guide your actions accordingly. If it was original footage, it would have metadata. The metadata wouldn't be deleted, I think. But if it was overwritten, Judge Cannone, how does it still exist? I don't think both things can be true. And then she goes back to old Rule 14. There's nothing in the version of Rule 14 then in effect, or the current version, that entitles the defendant to the metadata or log files underpinning the surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. I don't know. I just think that now, right, since AI is becoming so prevalent and deep fakes are becoming so prevalent, to even like utter this sentence in a court order is laughable. It's laughable. Yes, agreed, Olivia. The defense actually did make a blanket request for metadata corresponding to all crime scene photographs, digital evidence, etc. Yes, of course they did, because that's what they do in every single case. And they're under an obligation as a prosecutor to preserve anything that could be considered evidence. Nor has the defendant demonstrated that the metadata would have been exculpatory evidence. How can you prove that which you don't have? Similar to Aaron Spencer's case. Aaron Spencer doesn't have to prove that what would have been on Michael Fossler's camera would have been exculpatory when the mere evidence that it is now missing and or lost and or never turned over by the prosecutor with no chain of custody is enough in the case in Arkansas for that judge to just outright dismiss all of Aaron Spencer's murder charges, because that's the way a judge with cojones operates. Even in Arkansas, which we have found is very, very, very corrupt. I'm squeezing the hell out of this stress ball. It's shaped like an ice cube. She offers no evidentiary support for her argument that the metadata would confirm her theory that members of the Canton PD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from seeing Proctor damage the taillight. Quote, a defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the evidence would have produced evidence favorable to his cause. Well, go talk to Judge, and I'm sorry, I'm forgetting his name right now, in Arkansas. Judge Wilson? Judge Wilson. That is, the defendant must establish a reasonable possibility that the lost or destroyed evidence was in fact exculpatory. I'm sorry. What part do you not understand? Lastly, as to this claim, to the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the retrial. Don't worry, you get another bite at the apple. Don't worry. You can expend another couple $1 million in attorney's fees to prove yourself innocent when the defendant doesn't have to prove anything in a criminal trial. It is the state's burden to prove beyond a reasonable doubt that you want to keep us at back. Thank you, Decline. Feels so special being a part of the cupcake mob and the yacht club. I love you too. Thank you so much for your 10. Mama She, I love you. Thank you for your super sticker. I don't know. I have no idea. I don't know if you're a troll or if you're a real person, but at least you put $5 in instead of the usual 2 by the trolls. QC, GG. Happy 4th to you too. XO. Jamie. Oh, Jamie's the one who Jamie's the one who made the Handmaid's Tale ducky. Thank you, Jamie. I love it. I love it. Strange credulity. FYI, Judge Krupp has scheduled a Zoom scheduling hearing for July 13th. Okay, hold please. July 13th, 26 to officially set the timeline to continue taking live evidence for the defense's first motion to dismiss. Okay. All right. That's great. Krupp. And that's in Miles King, right? Praise be. Under his eye. Can't wait. I'll put it in the calendar. Ms. Mojo Horizon says they're all criminals. Thank you. No, 3 gifted 5 memberships. She's awesome. Welcome, Karen Moore. Strange Credulity gifted a membership. Phil DeCaesar coming in with a hot 10. Thanks for your invaluable contributions to truth and justice. I know you didn't sneeze, but you're so good looking. Oh, you're sweet. Thank you. VMCYK says had a law teacher who related a narcotics case he defended that was dismissed because the RCMP blew the chain of custody. Yep. Got the client cash back, but declined judge's offer to take the scales. Thank you very much. Pebbles Love, thanks for being here for 23 months. And Christy, a painter's daughter, has been here for 26 months. She loves it here with the cupcakes. I mean, what's not to love, right? What's not to love? All right, as we get to the Section C, which is withholding of an exculpatory statement by Jennifer McCabe. On May 7th of 2024, during the first trial, the defense produced reciprocal discovery to the Commonwealth regarding the location information of witness Jennifer McCabe's cell phone. Oh, yes, they did. Yes, they did. The location data showed that on January 30th of 2022, okay, the day after the murder of John O'Keefe, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of January 29th of 2022. That's right. Michael Lank, for those of you who don't know, is the Ray Donovan of the Albert family. Michael Lank has been the fixer since at least, I don't know, maybe the 90s. Michael Lank bit a man. He bit a man when, who was it? Was it Chris Albert who called him down to help him with a bar fight somewhere? I think the place is now the Waterfall. There was a bar fight between the Lopolito brothers and I think Chris Albert called Lank. Lank bit one of them. Town of Canton got sued pretty good by the Lopolito brothers or Lopolito. I always pronounce the name wrong. And, had to pay a whole bunch of money because of the shenanigans of Michael Lank in that case. Oh, and then there was something else that happened. Tim Albert, one of the Albert boys, I think there's 6 Albert brothers and 1 sister. It was Chris Albert, right? I love Ray Donovan. I love that show. It's one of the best shows I think that ever existed on television. Lopalato, maybe Lopalato. Tim Albert smashed into a woman, rear-ended her at a traffic light, fled the scene, and he drove to 34 Fairview. Lank couldn't fix that one so well because the trail of oil from the crash led back like Hansel and Gretel's breadcrumbs to the driveway of 34 Fairview, to which Tim Albert had fled. And so they did wind up charging him with something. But he was the friendly referred to by Alan Jackson, who arrived on scene, first one they let in the house. And the weird thing also about this case, which is so bizarre, is that Judge Cannone forced the defense to turn over all impeachment evidence to the prosecution. Not the way we do things here in New York, but whatever. Charges got dropped against Tim Albert. Oh, also, what I forgot to tell you guys who may not know this is that I forget what year it was in the 90s. Chris Albert killed a man in a car accident. Chris Albert, Colin Albert's father, killed a man in a hit and run motor vehicle accident. The man's name was Peter Berger. He was an exchange student. Not only did Chris Albert flee the scene, I wonder if he had stopped to help, if maybe Peter Berger wouldn't have died. I don't know. But he didn't turn himself in until 30 hours after this fatal car accident, which gave him plenty of time to sober up if he was drunk, because that's never been proven. And what happened after that was he showed up with his attorney. I guess he surrendered himself. His attorney was a man by the name of, I think, John Prescott, who happens to be the brother of Judge Beverly Cannone. Because you can't make that up either. So when Aidan Kearney was doing that window intimidation and looking into the pizzeria at DNA and said, which was illegally wiretapped, maybe, by the way, because there was cameras inside, with the video, cameras outside with the audio, D&E, but it doesn't matter. Chris Albert is above the law. I mean, that's why he became a Canton Select Board member. When he said, Chris, why did you kill a guy? Why did you kill a guy? That's what he was referring to, Peter Berger. He wasn't referring to John O'Keefe. He was referring to Peter Berger. Okay? In anticipation of her trial testimony, the Jennifer McCabe, the Commonwealth met with McCabe. Lally, ADA McLaughlin, and Massachusetts State Police Lieutenant BRIAN TULLY were present. Okay, lawyers in the chat. When in the history of ever have you prepped a client, not a client, have you prepped a witness for trial and had a state trooper in on the witness prep? When, if ever, have you done that? Tully's fingers are all over this. No wonder he doesn't want to. No wonder he filed a motion to quash. 30 minutes until Taylor's wedding starts. Oh my God. Oh my God. People think she's already married. Do you think she's already married? I think she probably did a small ceremony with friends and family, because there is some website that tracks her private jet. And I forget when it was, maybe a week ago, 2 weeks ago, Jessica. They tracked the private jet to go pick up somebody's dad in Tampa and then Kansas City. And then it went to a couple of different places where perhaps they gathered all the family members to come together for the ceremony. I don't know, but we're going to find out a lot more. And I can't wait. Tully asked McCabe why her cell phone would have been in the area of Lank's house on January 30th of 2024. Right, because they had to turn over. They couldn't impeach Jennifer McCabe. They took away all the smoking guns of the defense, and they got to prep Jennifer McCabe on this, which is wild to me. If you practice law in a different state, tell me if you're required to turn over your impeachment evidence to the other side. So they got to manufacture an excuse for why Jennifer McCabe was at Lank's house, okay? And here's what she said. McCabe said she was with Kerry Roberts, who was picking up her daughter at the residence. This is the judge's decision, okay? We're reading the judge's order from May 25th of 2025, denying the motion to dismiss. This is in the judge's order. After Jen McCabe was prepped by Tully, McLaughlin, and Adam Lally. McCabe said she was with Kerry Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Again, another violation. Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29th, 2024. That was after Jennifer McCabe was already off the stand. Okay? Why? I saw something interesting here. Somebody said that they're behind, but their 12th great grandmother was one of the witches who was hung I'll go back to that later when I was scan the chat after the stream is over. So that's very, very interesting. They didn't turn it over until Jennifer McCabe had already testified. On May 21st, 2024, Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on January 30th of 2022, and she explained that she went to Lank's house with Roberts to drop off Roberts' daughter. Okay, so notice in these two different paragraphs. In the first paragraph, when she was prepping, she said Carrie Roberts was picking up her daughter. And when she testified, she said she was dropping off Carrie Roberts' daughter. So Jen McCabe on the stand said she explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house to talk to them. Really? The day after John O'Keefe's murder? Lank, the fixer? You went to his house with Carrie Roberts, who now all of a sudden you're besties with? Remember, before the murder of John O'Keefe, Jennifer McCabe and Carrie Roberts had met one time. I think it was like 8 years before when John O'Keefe used to get a discount at some sneaker store. I forget the brand. And he took them both to get discount sneakers. That's the only time they had ever met before. But now they're traveling around together the day after John O'Keefe's murder. You know, keep your friends close and your enemies closer. Maybe. Jackson questioned McCabe as to why she did not report the fact that she had met with one of the first responding officers on the case working for the Canton PD, which is conflicted off the case. He further questioned her on the length of the conversation, who else she talked to at the house, where she was during the conversation, and if she went in the house. Well, here's the thing. What else do we know now? Carrie Roberts' daughter was friends with the Lank's daughter. Everyone's related. It's all incestuous. What was the sum and substance of Jennifer McCabe's conversation with Lank's wife? How improper is this? But we know that Carrie Roberts' daughter is friends with Lank's kids. During cross-examination, Jackson also questioned McCabe about the details of her discussions with Lally, McLaughlin, and Tully about her trip to Lank's house. She testified that when Tully asked her if she went to Lank's house on January 30th of 2022, quote, "At first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there." And that was the extent of the conversation. Really? That was the extent of the conversation? First of all, why is Tully questioning you during witness prep instead of Lally, who's going to be the one actually examining you? Second of all, this is hilarious because Matt McCabe's email about how they're victims, all they did was testify. That was before this order came out. People have eyes, brains, ears. They can watch testimony. They can watch trials. They can read witness statements, police reports, every single court filing that they can get their hands on, and make their determination about the extent of your family's involvement in this based on their own observations and your own behaviors and text messages and testimonies and changing witness statements. Matt McCabe white knighting for his wife in that email. Oh, I've never been to his house. Then I thought about it when I was confronted with my location data of my phone, and I said, oh my gosh, yes, they did go there. And that was the extent. Lally didn't ask any follow-up questions, or Tully didn't ask any follow-up questions because he's the worst cop ever. Why do you think he doesn't want to give a deposition? I don't think it was New Balance sneakers. I thought it was like Reebok or something. On June 18th, 2024, after the defense had received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. Quote, during the trial, the Commonwealth interviewed Jen McCabe apparently and had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. It was Reebok, right? Oh, see, I have a memory sometimes. Yeah, I know. We've been here for almost 5 hours, 4 hours and 45 minutes because it's hot today and people needed a little distraction. Some people are working, some people are off work today. And I haven't filled up my iced coffee once. Please. Here's the trial transcript of June 18th, 2024. The court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, stating, no, Your Honor, that's not my, and I think the court understands that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you've what? Jackson replied, I've done the damage that needs to be done on Jennifer McCabe, and stated, I don't need to call her back. Why should he have to call her back to the stand so she can maybe make up another story or another timeline? She's already fully prepared for the impeachment evidence because she's been prepped on the impeachment evidence. Little did she know that the forensic expert of the defense was going to get her location data. Defendant's argument. The defendant argues that in violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given by McCabe to Tully regarding her visit to Lank's house, which the defendant claims she could have used to impeach McCabe. The version of Rule 14 then in effect required that the statements of persons the party intends to call as witnesses are subject to automatic discovery. The Commonwealth, therefore, should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having McCabe's statement. On cross-examination, Jackson questioned McCabe extensively about what she had told Tully about her visit to Lank's house, why she had not disclosed such events before, and the details of her visit to the house. Moreover, Jackson expressed satisfaction with the damage she believed he inflicted on McCabe's credibility. Oh, no punishment for the prosecution. Because again, Mr. Jackson, you're a really good trial lawyer. And again, she's going to get another trial. It is curiouser and curiouser, Alice. It sure is. Curiouser and curiouser. When he declined the court's invitation to recall McCabe to the witness stand in this manner, Jackson undermined any newfound claim of prejudice based on the late disclosure. And once again, the remedy for a violation such as this is not dismissal, especially whereas here, the defendant's rights can be fully protected at the retrial. Oh, thanks for asking. Vince's last name is Imbesi, Imbesi. That's Loophole Lawyer. Judge Cannone goes on to say in her May 25th, 2025 decision, remedy for discovery violations. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. However, even if the defendant were able to show prejudice, the appropriate remedy would not be dismissal of the charges. Again, tell that to the judge in Arkansas who did the right thing, and the judge in New Mexico who did the right thing. Dismissal with prejudice is a remedy of last resort, not according to other judges who are very highly regarded. Under the circumstances of this case, where there was a mistrial and the defendant now has the evidence at issue prior to the second trial, she cannot show that she suffered irremediable harm to her opportunity to obtain a fair trial. It's so crazy how this decision came out May 25th of 2025. What was the first day of testimony? Like, they didn't even have time to appeal this because the judge said, no adjournments. We're pushing this ahead. Indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. Okay. Oh, so you're saying that even if she gets convicted, no big whoop, she can just, appeal? Put a 2 in the chat if you have never heard this order of Judge Cannone from May 25th of 2025, denying Karen Reed's motion to dismiss for egregious governmental misconduct. Put a 2 in the chat if you've never heard this order before. I'm just curious. A lot of you haven't heard this, so you don't know. This is the lore. This is the lore behind Judge Cannone's rulings and all of the evidence that Karen Reed had trying to get this case dismissed. And how big of a check do you think they're going to be able to write to Karen Reed when all of this is proven that they violated her civil rights? How much more in attorney's fees did she incur for trial number 2? Remember, Bob Alessi worked for free. He did it pro bono because his huge white shoe firm based out of New York City, they have many, many offices. Bob Alessi, by the way, at the time was billing over $2,000 an hour because he's a genius and he deserves every penny. He did it for free because he found this to be such an egregious violation of civil rights. And he knew Yannetti from another case, David Yannetti. King David talked about it on Aidan's fundraiser or somewhere else. A lot of people have never seen this before. And if you haven't seen it before, $227 billion. Nor has the defendant shown the Commonwealth's conduct was so egregious, deliberate, intentional that prejudice should be presumed. Well, based on everything that's now coming out about Michael Proctor, and even based on what they knew back then, it was my opinion and remains my opinion that the cumulative effect of all of these failures to turn over evidence, the Sally Port video, the interior Canton PD video, the parking lot video, Jennifer McCabe's statement, the cumulative effect of all of that would have had any other judge toss in this case. But for some reason, they really, really, really wanted to pin it on the girl. Such a theory. Oh, she used the word theory. Isn't that the word that Yuri Buchanan wanted a dictionary for? Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation. Oh, yes. Have you read about what just happened to Sean Good and the stuff that was found in Michael Proctor's phone extraction that Sean Good wrote about people, including women? And a stronger deterrent is warranted to prevent repetition of such misconduct. Yeah. Because until these people face ramifications for their behavior, it's going to continue. Yeah, they fired Proctor. They let Sean Good retire right before the IA investigation came out, the independent investigation showing that he should have been fired. He got to retire. Isn't that nice? And the Post Commission took away his certification to ever serve as a police officer again in this Commonwealth of Massachusetts. Yes. Seriously, Blackheart, wait. Didn't Tully just attest in his papers to get out of his deposition that he didn't do any interviews, that he was just a supervisor, that is in direct opposition to this order of Cannone's? Yes. You know what else he said? I think in his papers, remind me. He said he didn't go to 34 Fairview on the date of the accident. I mean, on the date of the alleged car accident, January 29th, 2022. But then somebody pulled up some testimony of him testifying that he did indeed go there in the evening while the CERT team was collecting their scavenger list of things that he provided them with. Find some pieces of taillight and a sneaker. And he absolutely was there. But I think he did say in his papers that he was not there, right? It was just docketed, Kyle. Decision and order on plaintiff's motion to compel responses to supplemental keeper of records subpoena from Aidan Kearney was docketed. And wait, you just said something about Tully. Decision and order on non-party Lieutenant Tully's motion to quash was just docketed. Like, was it scanned? Scott says, Kyle, use the, we're almost done with this, so I'll look at my email after this to see if it came up. Tully was absolutely at 34 Fairview on January 29th because he was supervising the CERT team. So that too was a lie. I don't know if Karen Reed's team picked up on that because I don't think they did. I don't think they put that in their papers. But he cited a fake case too, so there's that. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendants of discovery, which would have aided her case. What? The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery, which would have aided her case. Well, you know who's also considered part of the prosecution team? Tully, Proctor, Buchanan, because the MSP, those guys, their squad was assigned to the Norfolk DA's office. They are also considered part of the prosecution team, those guys. But Judge Cannone said, without a hearing, remember, without a hearing, none of these people were put under oath to prove any of the assertions that she throws into her order about Michael Proctor having stuff and just putting it in a drawer. Even if the defendant were able to show that the conduct at issue here on the part of the members of the prosecution team was intentional, the remedy would be a new trial with a timely disclosure of evidence, not dismissal. Yeah, if she was convicted, I would agree with you. But she wasn't convicted. There was a mistrial. And you still had the opportunity to do the right thing. And the number of the dollar amount of Karen Reed's damages just went up. In this case, defendants' rights to the disclosure of evidence pursuant to Brady and the Rule of Criminal Procedure are fully protected because no verdict was returned at the conclusion of the first trial and a retrial is about to start. I mean, I laughed then. I'm laughing now. This is wild. If this can happen to Karen Reed, this can happen to anybody. And to think that it took an outsider like Karen Reed and a tenacious reporter by the name of Aidan Kearney to expose the pervasive decades-long corruption in the Commonwealth of Massachusetts is ironic. She has suffered no irremediable loss of any constitutional right, and her motion for dismissal on these grounds must be denied. And then she goes on to talk about Massachusetts State Police interference with the jury. And this is something that also she did not have an evidentiary hearing on at all. At all. But you may have forgotten about this. And if you weren't here for this part, buckle up, buttercups. During trial, two issues arose with jurors. The first occurred on June 14th, 2024, when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant. This is crazy because that was Flag Day. That was the day that Mark Betterow and I went to the court. We went to court that day. The only time I ever went to court on either of the Karen Reed trials, and we were there when this happened. And what had happened was they called the jurors up to sidebar. And whoever was the pool camera that day forgot to shut off the camera. And one of the jurors was caught on camera. And the court pulled the cameras for the rest of the morning. And I remember getting frantic text messages from people. Of course, I couldn't look at them in court because they were like super like tight about not using your phones in court, and they should be. Crazy messages from other YouTubers, from people like, why is there no cameras? What happened? What happened? And we didn't know what happened. We didn't know. But they did call in a lot of jurors one by one. And they talked to them at sidebar. Footnote 9, which says, the court has omitted identifying information about the jurors, and you should. Such information is not necessary for purposes of this decision. And of course, the full record is available for appellate review. Right. Kearney wasn't convicted. This has been done to afford the citizens who served as jurors in this case as much privacy and peace of mind as allowed by our law. Yeah, some of them did come out though. Paula, I think Paula Prado, wasn't she a juror in trial number 1? Sometimes we got to put our hero up in the corner here. Charlie Deloach, foreman of the jury in trial number 2. There he is up there. We watched an interview with him recently. That was at Fisher College. He's the one who didn't take any notes, that people were so afraid because he didn't take any notes. You know what he said? You didn't watch that with me? He said, after the first witness was called to the stand, he said, I was like, oh, really? Oh, really? This is how it's going to go. And he said, and I took my pen, I put my pen down, and I didn't take another note. But he remembered everything about the trial. He has like a photographic memory. But back to what happened on June 14th, 2024. The court called Juror B to sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concern that the comments had been one-sided and against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during the trial. The court then questioned 2 other jurors whom Juror A said were sitting close by when Juror B made the comments. Both jurors stated they had not heard what Juror B said directly, but that Juror A had mentioned it to them. The court then called back Juror B, who denied making any negative comments about the defendant. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also strike Juror A. The defense disagreed as to Juror A. The court ultimately decided to dismiss just Juror B from the jury. On June 25th of 2024, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving Juror A. Oh, this is interesting. This is interesting. Because we were talking about before about Judge Gildea receiving this mystery information from somebody that he wouldn't name. But in this case, Judge Cannone received information from court security about Juror A. Put a pin in that. A member of the Massachusetts State Police had contacted court security and said that he received information that a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case and that there may be a recording of her doing so. Oh, interesting. Were the jurors being followed by the MSP? At roll call for the Dedham police on the morning of June 25th, 2024, a number of officers confirmed that they had heard similar things about the juror. Oh, interesting. Interesting also, there was no evidentiary hearing about this. Nobody was ever called in to testify to this. Do you think the jurors were being followed, surveilled, recorded? Is that an illegal recording? Guess who didn't care? Judge Cannone. The court called a sidebar to discuss this new information with attorneys. Defense counsel asked for the name of the Massachusetts State Police officer who had received the information, and a court officer stated that it was Lieutenant Fanning. Remember Lieutenant Fanning? He's the one who quickly cleared Matthew Farwell for the murder of Sandra Birchmore and then ruled it a suicide. Fanning is the supervisor in the Norfolk County Detective Unit. He was also on Michael Proctor's text chains that have come out. During the investigation into O'Keefe's death, he was Proctor's supervisor. Oh. He was also one of the recipients of a group text circulated by Proctor that included references to looking for nudes on the defendant's cell phone, as well as references to defense counsel's retarded client's phone. Sorry, I had to say that because I didn't redact it and it just popped out. Defense counsel represents, and for purposes of this motion, the court accepts that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness at the trial. After explaining to the attorneys the situation, the court called juror A to sidebar. So the only person they talked to was a court officer who stated it was Fanning. They never called Fanning in. Juror A was also very pro Karen Reed, I think we found out. After explaining to the attorneys the situation, the court called juror A to the sidebar. The following exchange occurred. The court. It has been brought to my attention that you might have been out recently at an American Legion or a Knights of Columbus or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about the case. That's the information I received. What can you tell me about any of that? The juror said, I don't know. Cannone said, have you been at an American Legion Hall? The juror said, like a month ago. Cannone said, okay, at the time, were you at all talking about? The juror said, not that I remember, no. Cannone said, do you remember if people there mentioned to you anything about this case? The juror said, I was drinking, I don't remember. The court said, okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. The juror said, okay. Cannone said, all right, could it have happened? The juror said, I don't know. The court said, okay. And the juror said, I really don't know. The court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in the previous issue and requested that the juror be excused. The defense objected, arguing that the previous incident was unrelated. Focusing on the incident, the court conveyed a concern that the juror did not deny the incident, but instead stated that she had been drinking. Okay, so what? She's not allowed to drink? The defense responded that the court should consider that no other juror had been affected and that the source of the information was a Massachusetts state police officer. Right. And I'm asking you, do you think there might have been a concerted effort to get anybody who was pro Karen Reed off that jury? Toot sweet. Again, a judge relying on unsourced information to prejudice a defendant. Like Gildea'a. Thereafter, a discussion about Lieutenant Fanning ensued, with defense counsel suggesting that Fanning and the MSP may be targeting potential jurors for the purpose of trying to get them excluded from the jury. Well, the court allowed defense counsel to make its argument about why the court should not dismiss the juror. ADA McLaughlin then explained to the court and defense counsel that Lieutenant Fanning's role, ADA McLaughlin, she's involved too, deeper than anybody knows. Lieutenant Fanning is the commander of the extensive security operations that this case has required. Really? Why would Lieutenant Fanning be in charge of the security for the buffer zone and all that other bullshit when he was a potential witness and worked on the investigation of this case and was Proctor's supervisor? Does anybody else see a problem with that? This is what McLaughlin told her. What occurred is he received the information. He did not investigate. He had no evidence of any crime. If he did investigate or reached out to anyone, that could have been considered an improper influence on a juror. What he did is reported it to the chief of the trial court security to make sure the trial court is aware and to simply correct a trial court issue. Wow. Wow. The Commonwealth then made its argument regarding why the court should dismiss juror A. I mean, the court then conveyed its decision. And this is what the judge said about dismissing juror A. I believe there is credible evidence that this juror has had conversations about this case. She did not deny it. Okay, but what was her conversation about the case? It doesn't matter. It doesn't matter what the substance was. This is insane. I find that there has been a violation of the court order for failure to report it on a reported basis. Juror A had no problem reporting the other juror, but then at the time, also, she did not tell us that she had spoken to 2 other jurors I inquired of. She told us they may have overheard, and then it was another juror identified by seat number who ultimately told us that this juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror if we did hear this from somebody who was at the VFW night that night after all of this. What? So for all those reasons, I'm going to excuse her from sitting on this jury. Yep. That's what happened. I don't know if juror A ever came out and spoke about this. Victoria George Wright, she was an alternate. Trial 1. They really, really, really wanted a conviction. They really, really wanted it. They didn't get it. DK says that juror was stalked. At this point, the sidebar conversation continued about Lieutenant Fanning. The following exchange occurred. McLaughlin. What I said was that Lieutenant Fanning is the unit commander of the security operations, which I know from the past 3.5 months, that's his role. And then Attorney Little, that's not me. Eliza Little said for the jury. And then the judge said, hold on. McLaughlin said, not for the jury, for the trial support and security. Yeah, the court said, hold on, because she didn't want any more of this on the record. I think that the defense had information, or somebody had said that Fanning was in charge of the jury, but he wasn't. He was just in charge of all the trial support and security. The defendant's argument. She goes on to wax poetic about a criminal defendant being entitled to a fair trial and the Sixth Amendment. Defendant here argues that her Sixth Amendment rights have been violated by the dismissal of juror A. Specifically, the defendant contends juror A appeared sympathetic to the defense, and therefore the MSP, who have interest in the defendant being convicted, targeted the juror to get her dismissed before deliberations. The defendant also argues that the court failed to employ the proper process before dismissing the juror. These arguments have no basis in fact or law. Again, no evidentiary hearing about any of this stuff at all. She's like the great Oz, and she can do whatever the hell she wants with her wide judicial discretion. The defendant's first argument relies on a significant claim to clairvoyance about juror A's sympathies at the time of the sidebar conference. And it is, again, with the clairvoyance and all of the paranormal activity going on in Norfolk County. Tell me I'm wrong about that. We need an exorcism. They need an exorcism. And it is premised on unsubstantiated claims regarding Fanning's involvement in the jury. Good. Call him in for an evidentiary hearing. Put him on the stand. Put Fanning on the stand. Find out who surveilled the jurors. Despite being specifically informed at sidebar that Fanning was not in charge of security for the jury. Okay, so Laura McLaughlin is telling the truth and we should just believe her and she's not under oath? Okay, cool. And without providing any evidence that Fanning ever interacted with any members of the jury, defense counsel repeatedly claims without any evidentiary support throughout the memorandum in support of the present motion that Fanning was commander of jury security. or in charge of jury security. Okay, so we're just going to take Laura McLaughlin's word for it, and nobody's going to have to come in and testify about anything because that's the way she does it. And had access to and control over the jury at the first trial. In fact, and as made clear to defense counsel at sidebar, right, because Laura McLaughlin always tells the truth 100%. On June 25th, 2024, Fanning was the commander of security operations during the trial and not in charge of the jury. Again, was Laura McLaughlin under oath when she said that? We're just going to, it's like, trust me, bro. Footnote 11, which says, and omitting the part where ADA McLaughlin, what had happened? No, cancel. States in no uncertain terms that Lieutenant Fanning was the commander of security operations, not for the jury, but for trial support and security. Again, do you see that the fix was in from jump and how it became a whole other episode? And also that we're going into season 4 coming soon to a theater near you. Footnote 10 reads, the defense argued at the hearing on this motion that it's reasonable to assume that Fanning had access to the jury because he apparently knew or became aware that the person involved in the incident at the American Legion post was a juror in the Reed trial. In fact, this is the very opposite of a reasonable assumption. Again, I'm going to scream it more. No evidentiary hearing. The trial court is responsible for jurors. Court officers employed by the trial court, and only those officers are in charge of the jury. The only people with access to the jury at the courthouse are the court officers of the trial court. The court officers have a sworn duty to watch over the jury. The responsibility was not and cannot be transferred to the MSP. Listen, the MSP do a lot of stuff that they shouldn't be doing. Have you read the text messages? Thus, counsel's claim that Fanning was in charge of the jury and was directly involved in efforts to have one of the jurors dismissed is simply false. Yep, according to her, under her eye. It is, of course, required that lawyers present only good faith arguments to the court under all circumstances, but the failure of counsel to take care with the truth of assertions in this regard has particularly damaging consequences. God forbid anybody's damaged who touched this case. Fanning, Tully, all of them, they're all falling. The dominoes are falling. The walls are crumbling down, and that's why the trolls are ramping up. This case has generated substantial public interest locally and nationally. Oh, yes, it has, and it's not going to stop anytime soon. To suggest without factual support that a Massachusetts state police officer had influence over the court and the jury in the first trial is to invite unwarranted public speculation and distrust about the integrity of the Massachusetts judicial system. Well, it's been 1.5 years since this decision, and it's only ramped up, and everything else that has happened has made it a whole other season. Judge Cannone. The public speculation and distrust about the integrity of the Massachusetts judicial system and the Massachusetts State Police has exploded based on everything that's happened since then. It can also be seen as an improper attempt to influence potential jurors in advance of the retrial. Okay. Thus, the court takes this opportunity to make it clear that neither Fanning nor anyone else from the MSP interacted with members of the jury or influenced the court's decision to dismiss juror A in any way. Oh, wow. This is the court order, remember. Public record. When Fanning became aware of information regarding juror A, he turned it over to the court officer assigned to the case because it was a matter to be dealt with solely by the trial court, and also because he was trying to distance himself from it. And then she goes on and on to talk about why it was proper for her to dismiss that juror. And too bad, so sad, I'm the judge. I can do whatever I want. Juror A was questioned at sidebar. No need for hearing. She was drinking. She was not entirely forthcoming about her communication with other jurors. Therefore, I dismissed her, and we don't need a hearing because what I say goes. Ipsy Dixit, because I said so. She goes on to say that the defendant cited cases that said, if she so determines, talking about the potential misconduct of jurors, she must then hold a hearing to inquire further into the alleged misconduct. Based on the cited cases, the defendant argues the court's questioning of juror A was insufficient, and the defendant, however, misunderstands the law. And that because the jury had not started deliberating yet, everything I did was fine, cool, okay, praise be, all me. I'm just going to get to the end of this decision because apparently some other stuff has popped off in the meantime. But the court made its discretionary decision. See, I have the discretion, just like Judge Gildea is reminding us of his wide discretion and everything, right? For the foregoing reasons, the defendant's motion, I'm sorry, I kept saying May. It was March 25th of 2025. I got to go back and correct the record. March 25th, 25. I wrote it down wrong. I wrote 5/25/25. It was 3/25/25. Prior to trial number 2. For the foregoing reasons, the defendant's motion to dismiss for extraordinary governmental misconduct is denied. The defendant's alternative request for evidentiary hearing on the matter is also denied. XOXO. Judge Beverly Cannone, Justice of the Superior Court, Supreme Ruler. Wow. Just wow. It's so triggering to go back and read that decision, isn't it? Is it just me? So for those of you who did not see that in season number 1, welcome to the machine that is the Norfolk County and the Commonwealth Judiciary, where the judges are appointed, and they feel free to let everyone know that they do whatever they want. Thank you, Piney Woods, for your Venmo. Appreciate you so much. Love Unk. Oh, please. Thank you, Jen, for 5 matcha lattes. Says, thanks for fighting for justice. I didn't know Aquarius was the justice fighter of the Zodiac. Oh, and you're an Aquarius too. It absolutely makes sense. Thank you for your 5 matcha lattes. I'm going to need them all. Every single one of them. If you're just tuning in, for all of you who are sending me the Michael Morrissey email about me, that was sent to Tully and Brennan. We covered that already. We covered it already. Just rewind and you'll see it. Interesting stuff. Interesting stuff, to say the least. You guys are armchair detectives and you're all over it. All right, let's go into the court docket and pull up some things that apparently have just been dropped, even though today's a federal holiday. I thought courts were closed today, but this is the day off that a lot of people get. Unfortunately, I think mail carriers and garbage men are working today. Please. Let's see. I got to close some of these windows. Let's walk amongst yourselves for a second. Okay, thank you, Scott. Not enough hours in this Friday to cover all the things that we want to cover, but I think a lot of YouTubers are on vacation, so I'm happy that I can provide some interesting information for you and a place to hang out. Hold on. There is a decision and order on non-party on Tully's motion to quash. Let's take a look. It's going to be cold read for me, so give me a second. Let me just see what else dropped. There's an order on Aidan Kearney having to supply records. I gotta get all of this together for you. Talk amongst yourselves. It's hard to talk. I can't do like, you remember the old rub your tummy and pat your head thing? I can't talk to you at the same time that I'm trying to pull up documents. So forgive me. I know you don't like dead air, but I'm gonna have to have dead air for a minute. All right. So there's 2 orders as far as I can tell. And another thing, hold on. Here's the thing. So when people like put like when you tell me in the chat that you sent me an email and then your email comes from a different address that has nothing to do with your YouTube username, and I got like 300 emails during the course of this stream, it's impossible for me to find your email. So let me just go somewhere else. Hold on. So like telling me in the chat that you sent me an email when your email address is totally different from your username is like, it's just crazy because I can't find it and I'm not going to be able to find it. Something about why it was in the small courtroom. I don't know. I don't know anything about that. I can't find that right now. Why the trial was in the small court? Well, I don't know. But let me get to the court filings from today because are you guys getting bored yet? We've been here a long time. Are you getting bored yet? Right. You know, when you write me emails, please put your username in there, like in the subject title or, you know, whatevs. In the subject RE line. That'd be great. Make my life easier, not harder. Like if you're sending me stuff and then I have to do extra work to find it, I'm just not gonna find it. I'm just gonna quit. I'm gonna rage quit and not find it. Let's take a look at the decision and order on Tully's motion to quash. Cold read. But you know, we're here for breaking news on a holiday. I thought are the courts not closed today? I mean, I guess they're not. So Raven. So this is too enraging to be boring. Too enraging to be boring. Here we go. This is docket number 150150, filed today, 7/3/2026. Maybe the court's not closed today. I don't know. Like every lawyer in the world is on vacation. Not the court clerks, though. They're scanning stuff in. July 3rd, 2026. This was scanned in. Doesn't say what time. Decision. And we know the judge is working this week because he told everybody, can't you do something on July 3rd? I'm working. He's working. Twerking. Judge Gildea. Judge Gildea's decision and order on non-party Lieutenant BRIAN Tully's motion. Retired. He puts retired right in the caption. Tully wasn't rehomed. He got to retire. Protect his pension. Protect his pension. If anybody can find stuff out, it's you guys. You guys are the best armchair detectives in the world. Fall into the rabbit hole just like me. Call me Alice. Decision and order on non-party Lieutenant Tully retired, motion to quash subpoena and or for protective order, paper number 132. Upon review of the non-party's motion to quash and or for protective order, the opposition and the reply, the motion is allowed as to narrowing the document requests as set forth in paragraphs 17 to 20 on page 13 of the motion, but denied as to quashing the subpoena. Okay. Remember, Tully's reasoning was that he's a defendant in the federal court action and the judge has a motion to dismiss his case in front of her and it's going to be argued on July 14th. So I shouldn't have to appear for a deposition before that. And it's unduly burdensome and overly broad for me to have to provide any of this stuff. Oh, please. I agree with counsel for the non-party. That means Tully's attorney, the one who cited the fake case, that objections should have been filed and a Rule 9C conference should have been held. However, Ms. Reed's counsel continues with the practice of issuing facially overbroad subpoenas and not fulfilling the obligation under Rule 45 to, quote, take reasonable steps to avoid imposing undue burden or expense on the subject of a subpoena. Well, there's a public spanking in a court order. Wow. Let me read that again for those of you who, please, if you're driving, maybe you want to pull over for this. I'm going to read that again. It's a public shot at Karen Reed's attorneys. However, Ms. Reed's counsel continues with the practice of issuing facially overbroad subpoenas and not fulfilling the obligation under Rule 45 to take reasonable steps to avoid imposing undue burden or expense on the subject of a subpoena. Faced with an apparent lack of communication by both sides and the choice between what may be considered two extremes, I choose the one that I find to be more reasonable. Oh, he's going to tell us how it is. There may be a reasonable inference in favor of the non-party's argument that the sequence of events shows the improper purpose of the discovery. However, the timing set forth in the motion and opposition is not determinative for either side. The motion to dismiss in the federal case was filed on April 3rd, 2026, and Ms. Reed issued a subpoena in this case on May 19th, 2026 for June 11, 2026. There was no objection, but rather a rescheduling to an agreed upon date of July 8th, 2026. I repeat myself that attorneys' agreements need to mean something. There's a blank page in between there. Is it supposed to be blank? Is this a 2-page order? No, it's a 2-page order because that's page 2. With respect to the argument that the subpoena circumvents federal discovery limitations, the cases cited in the motion tells us what is indisputed. A judge has the power to manage discovery, but do not stand for the proposition that the state court proceedings should be stayed as a result of the federal proceedings. Even if I were inclined to do so, the impending discovery deadline in this matter would dissipate any such inclination. XOXO, Mark C. Gildea'a, dated today, July 3rd, 2026. He didn't mention that one of the cases cited was actually not even a case. It was fake. And he got to correct it. He mentioned that. He doesn't even address that. Do you know how many attorneys have been publicly censured and excoriated for using ChatGPT or AI to draft their motions for citing fake cases? He doesn't even look over there. It's like, look over here. But again, it doesn't say, he's not narrowing the subpoena. Listen, Your Honor, we just read Judge Cannone's order failing to dismiss Karen Reed's case in between trial 1 and 2 for governmental misconduct, egregious governmental misconduct. Did you hear about Tully prepping Jen McCabe for trial and then writing a report on his prep of Jen McCabe that she went to Lank's house the day after the murder? Lank, the head investigator from Canton PD, and that she just forgot. And then he failed to turn over the report of Jennifer McCabe's testimony until after she had testified. Everything that Tully has done or said since January 29th, 2022 involving this case until the present should 100% be discoverable. I don't care how overly broad or unduly burdensome it is. So the order really doesn't say anything. It doesn't say when Tully has to appear for deposition, although it just says he has to appear. It does say Ms. Reed's counsel continues with the practice of issuing facially overbroad subpoenas and not fulfilling the obligation under Rule 45 to take reasonable steps to avoid imposing undue burden or expense on the subject of a subpoena. Let me tell you what I think is happening here. Okay. In my opinion, and my opinion only, with more than 30 years experience as a trial lawyer in civil court, this judge is building a record. He is building a record, domino by domino by domino, to enact some completely unfair sanction against Karen Reed and her attorneys. Okay? You see? Do you see what's happening here? Let's take a look now, because there's another order that just dropped. It doesn't narrow down the subpoena. It doesn't say what he has to produce. I mean, if you're going to come to an order, if you're going to issue an order, how about an order that has some guidance? And again, reminding us that he's got the power to manage discovery. And if he says so, Proctor's not even going to have to be deposed again. Let's take a look at the other order that he issued today, July 3rd, 2026, regarding Aidan Kearney. Docket number 151. Decision and order on plaintiff's motion to compel responses to supplemental keeper of records subpoena from Aidan Kearney. Judge says the motion and attachments show plaintiff's counsel caused the non-party to be served a subpoena for production of records at his home address. Okay. This again, the plaintiffs here are the O'Keefes. Plaintiff's counsel would be Diller in this case. I don't even know that Aidan's attorney opposed this motion, because we know Aidan's presentations that he has recently moved to a new house. So I don't know where they served him, and I don't know if it was the right place, and I don't know if he got it, and I don't know if he's talked about it. 2, acknowledgement of receipt by the non-party of such subpoena was made by him on a live stream broadcast. Okay, so he said that he got it. Again, Judge, why are you watching social media? Are you a turtle rider? Plaintiff's counsel has yet to receive any objections, responses, or any requests for an extension. Oh, okay. So they haven't responded, and you're going to rule on it anyway. Okay. 4, plaintiffs caused the non-party to be served a copy of the motion to compel at his home address. As of June 30th, 2026, no opposition to the motion was received by the plaintiff's counsel from the non-party. And so he's granting on default the motion to compel, paper number 145, which he says it's allowed I'm granting it on default. The non-party shall comply with the supplemental keeper of record subpoena on or before July 13th, 2026. He's not like trying to screw Karen Reed, he's trying to screw Aidan Kearney too. It doesn't, notice how it does not say in this order when he was served with the subpoena, when he acknowledged this on his YouTube presentation. When he was served with a copy of the motion to compel. At his home address. And so he's granting it on default. And this is what he means when he says, I'm going to grant it on a default. And it is so weird that none of Aidan's attorneys responded to this. I agree. I agree. Why is he being served at his house when he has several attorneys that would have accepted service from him? Another great point. Undue expense. Yeah, okay, but get all the lawyers to come in for a hearing. Dated July 3rd, 2026, XOXO, Mark Gildea'a. So Aidan Kearney has 10 days from today to comply with all the stuff that they asked him to provide. He's got 10 days. Hold on, because there's more, I think, and I want to see what it is. So there's an endorsement. So the judge just hand wrote on the motion to quash on the side, which is why I got to flip my head around. Oh, you know what? I can just flip the paper around. Duh. Duh, duh, duh. So it was handwritten on the side of the motion to quash Tully, 7/3/26, Gildea'a, judge, allowed in part and denied in part. See decision and order, paper 150. Attested. Lorraine, something that I can't read, session clerk, okay? But it's not really very specific. There's also an endorsement on the Aidan Kearney motion, 7/3/26, Judge Gildea, allowed, see decision and order, paper number 151, attested by the clerk. Let me go back to the docket. Because I don't think we ever had time to go over the motion to compel Kearney. That was number 145. Let me find it here. This can't be real. This can't be real. Okay, here it is. Here it is. No, this is real. Okay, this motion was just filed by the O'Keefe team on June 30th of 2026. Okay. Today again, for posterity, is July 3rd. So 3 days ago, this was filed. And look at it. Look at it. You can't make this up. This is what comes up when you pull it up on the court docket. Look, it's gobbledygook. This was filed June 30th, 2026 at 2:13 p.m. And it is a bunch of random numbers, letters, characters. Do we need it? Like, what do you call that when you have to like decode something? Do we need a special decoder to decode this motion? What in the ever-loving hell is going on here? This is a whole new fresh hell. A cipher. We need a cipher. Okay. The only thing I can make out here is Mark Diller's signature. The rest of it is just random characters encrypted. We need a key. Yes, Emily Baker did pull this up yesterday, and she too was puzzled. Is it in word perfect? It actually says up here, Microsoft Word, motion to compel. What happens when you file something in Microsoft Word and then they try and scan it into the, did they e-file this? So they filed this. And what did we say June 30th was? Was that the same day as the, I can't even keep track of the days anymore. That was Tuesday. Public spanking, Wednesday. Friday, the judge is ruling on this motion and compelling Aidan to do all of these things. We don't know if there was even proper service. Okay, so that is docket number 145, which purports to be, again, Mackenzie Sharilla and her mother's secret language. That's purports to be the motion to compel responses to plaintiff supplemental keeper of records on Aidan Kearney. That's docket number 145. Let's see if, oh, and then, and then when you go to, what is 145.1, that is unavailable. That docket is, unavailable. And then the affidavit of compliance with Superior Court Rule 9A. Okay, that does come up. So let's read that. Here's where they talk about their dates and stuff. But the court doesn't adopt any of these dates in its order, interestingly enough. So this is what is called docket number 145.2, the affidavit of compliance. Superior Court Rule 9A. I, Mark Diller, am licensed to practice law in the Commonwealth of Massachusetts, and I represent the plaintiffs in this matter. Oops. On or about April 21, 2026. I don't know when Aidan moved, but that could come into play here. Plaintiff served a keeper of record subpoena upon Aidan Kearney at his home address. A copy of the subpoena was served on all counsel of record on April 21, 2026. On or about April 21, 2026, Aidan Kearney acknowledged receipt of the subpoena by reading it aloud during a live stream broadcast on his channel. So the judge is like taking his word for it. Did you hyperlink the stream? As of the date of this affidavit, Aidan Kearney has failed to respond to the keeper of record subpoena or produce any responsive documents. On or about June 3rd, we served the motion to compel and the memorandum upon Aidan at his home address. On June 3rd, plaintiff served a copy of the motion to compel upon all counsel of record in this action. Right. So even though attorneys have appeared in the other action, the defamation action, they didn't serve it on his attorneys, even though they know who they are, or it's easily findable by a, social media search. As of this date, June 30th, no opposition or response of any kind has been received from Aidan Kearney. Plaintiffs have complied with everything, and so therefore, please grant our motion, XOXO Mark Diller. And in fact, the judge did grant it on default. It has been granted. Aidan Kearney has 10 days to provide everything that they were looking for. Carrie P. wonders, isn't everything supposed to be stayed until his criminal case is concluded? Yeah, but they have to make a motion. They have to make a motion asking for that. And that hasn't been done. Apparently, does it give you grave concerns? I don't know. It might have glitched, but we'll refresh it and see if it'll come up. 145.1 is what I couldn't get before. It says no document image available. 145.1 is not coming up for me. So I don't know. That is supposed to be. The memorandum in support of plaintiff's motion to compel, but it doesn't matter because the judge just granted it on default anyway. That is what he means when he says that he has the right and the power to grant a default. That's exactly what he means. Anybody have grave concerns yet? Are we at the grave concern level? Oh, hold on. I got to plug my phone in. Hold on one second. No, I didn't left swipe. I said, hold on. I got to plug my phone in. I had to go get the charger. Usually I have it right over here by my computer, but it's not here. VR Aviator said, sorry, just joining. Can the tweet information the judge relied on be subject to a freedom of information request? Only if it's part of the court record. If it's part of the court record, all of the civil filings, unless they're impounded, are publicly available. The judge didn't even tell anybody what it is. So you can't serve a FOIA request on Twitter because it's a private company. See what I'm saying? Could it be part of the judge's emails? Maybe. Maybe somebody could publicly request the judge's emails. They got them. I don't know. I don't know. Connie became a new member. Welcome. Division Bell said, watch the Larry Foreman video showing where Judge Gildea plagiarized the college student in the first minutes of the Wednesday hearing. We went over that exact article a little bit earlier in the stream. Thank you for your 5. I pulled up the exact article. It was written by a freshman at Brandeis. Tortoise interference, thanks for your 5. I didn't mean to. It didn't work for Mackenzie Shirilla, but it looks like it did for the MSP in the Commonwealth. Yep. 3 courts, 3 judges equals all protect Proctor. Thank you, allegedly. Michelle, thanks for becoming a member. Kat Gary is just saying this is terrifying on many levels. It is. It's terrifying. Legally Mine said he said in his show he was served with a subpoena for a deposition, not a document subpoena. Often they're one and the same. Often they're included. Like you have to appear to give a deposition on this date and bring with you all of this stuff. So I don't know. Mark said, remember when Brennan stated during the trial that we do not know what happened to Officer John O'Keefe and the defense was stunned? Brennan wanted no part of this mess. Thank you. Thank you, Mark. I know attorneys in Massachusetts who know Hank Brennan and who have dealt with Hank Brennan, and they all, by all accounts, and based on his zealous defense of Lucy Medina, and she was acquitted. I do think that he's probably a decent guy when push comes to shove. At the end of the day, it is what it is. I will. Yeah, we've been at this for, 6 hours almost. Because everything kept popping off and we're still here. Hi from Sister's Pool. Hello, Jackie Beningo is here. Oh, have you watched the whole thing? Jackie Beningo's here. That's Sam's sister. And I don't even know if this is really her because the trolls that have been out in full force, led by Loophole Lawyer, are also putting in $2 super chats. So Jackie Beningo, if they're impersonating you, you should be on notice. Thank you all very much. Thank you for that. She says, we ride with Melanie. So much love to you all. I don't know why I could be thinking this is somebody impersonating Jackie. Says this is a serious problem in Norfolk County. JPS, thanks for your 10. Says driving to Reno From Reno to Fairfield, California, listening to you since you started. It's so obvious of the corruption. Gildea'a or Gilead has flipped. Thank you. I love you with all of my heart. Oh, it is her. Sam has popped in twice. What did she say? I can't. I have been trying not to watch the chat because I was trying to fuck us. Fantastic Fish Fitz said, it opened for me. Fine. Maybe your click glitched. I don't know. I tried refreshing it and 145.1 is still not opening. All right, children, what did we learn today? What did we learn today? Tell me the most important thing or your favorite thing that you learned today during the past 6 hours. Was it the Salem Witch Trials? Should we go back and cover more of the Salem Witch Trials? Did you learn what a sleazebag loophole lawyer is? Melanie, says, just because I love you, you're amazing. Thank you so much. We learned that I am in the Michael Morrissey's emails, that he was warning Tully about me all the way back in November of 2024. Sounds like a damn commencement speech, said Gigi. I know. Every time I watch that Judge Gildea hearing, I notice something new to get annoyed about. All right. Somebody's talking about there was some, Tara said earlier, he wants illegal sanctions that will be weaponized, that there was some anonymous email talking about how Judge Cannone should move Karen Reed's trial into a smaller courtroom. But I don't know where that is or where I can find it. And I have like 600 emails since we started six hours ago, like 100 emails an hour. Just can't make it up. You just can't. Well, let's go back to my inbox. So Tully has to appear for a deposition. Who knows when? Michael Proctor's deposition is still stayed. And there's no hard stop for when these attorneys have to agree on some sort of a voluntary gag order. Thank you, Stephanie, for becoming a member. And Nicole says, it sounds like Marcy's focusing on winners. Thank you. Thank you. You're 5. I mean, you can't make it up. Marco says, I never knew that you got so mad. Well, you've never watched Melanie After Dark, I guess. And also, when people come for me and my family and try to like put my public address out there, my kid's last name and pictures of them and pictures of my house with my home address, they're effing with the wrong girl. They're effing with the wrong girl. Have you met me, Marco? Welcome. Welcome. Linda said, it's so hard to choose, which is my favorite today, but I hope you definitely go over more of the Salem Witch Trials. Thank you. Oh, we learned that in Lemonine says we learned that Yuri likes Dave Matthews Band and is well loved by his smug friends. He also loves karaoke. Michael says plaintiff's side will never agree to anything, therefore Proctor will never be deposed. I see what you're saying. Thank you, Mrs. Goodman, for your Venmo. Shout out to Mama G. Shout out to Mama G. Thank you very much, D, for hanging out today on this Friday, July 3rd, 2026. Lisa says, thanks for the excellent content. Thank you, Lisa, for your Venmo. I'm not going to be rage baited into talking about that a-hole any more than I already have today. Scott says, I learned a few things today, some names, an address, a floor. If you know, you know. Yeah. Oh, we learned that I turned 60 in February. I did. I turned 60 in February. The loophole and his minions are posting it all over the internet, so I might as well come clean on my age, which really isn't hard to figure out if you know how long I've been a lawyer. So there's that. That's cool. It's just a number. Age is just a number. We learned that today. And I bet you Nettie is spitting out his spaghetti at this BS, says Caroline K. Stella Blue. Stella Blue. So seriously, thanks for the company today. We will sink the ship of fools that is the corruption in Massachusetts. Oh, yes, Kelly. Kelly Lisa, we went over much of the Salem Witch Trials before. In fact, all of the Salem Witch, the people that were accused of witchery, witchcraft in the Salem Witch Trials, the 19 of them that were hanged at a place called Proctor's Ledge. Proctor's Ledge. It's true. We went over that earlier. We did a whole little thing. I wanted to do a much longer thing, hence the thumbnail about the Salem Witch Trials. But then this stuff started popping off. And then Loophole and his trolls came in the beginning and made me go on a rant because they're trying to control my emotions. And I guess it worked for a little while earlier. My whole computer is like glitching right now. Well, let me close some of these windows. Hold on. Where can I find this like anonymous email? I mean, there's a Matt McCabe email about Trooper Proctor's messages, but I don't think that's what you're talking about, right? Long Island Audit posted something called Mama's Lemon Pound Cake, which I can't play for you because Afro Man likes to strike people. It's a handwritten note. All right. I heard Kyle Sharkey posted it, but he's posting all kinds of things today. Oh, here he is. Anonymous letters. Okay. Thank you. Got it. Thank you, Kyle Sharkey, for posting these anonymous handwritten letters. He said, does anybody recognize his handwriting? Kyle Sharkey is spending his holiday going through the latest FOIA dump involving all of Michael Morrissey's emails. I guess there was an email dump in Michael Morrissey. Holy crap. Here we go. Buckle up, buttercups. Allie in Texas says, I'd seriously get a dopamine hit when Melanie rants and starts throwing F-bombs around. Is there something wrong with me? Very likely. Do I care? Not at all. It's just, I don't know. I've got plenty of wrinkles. You just can't see them with this amazing ring light that I have. See, look. Especially if I smile. All right, here we go. Let's take a look at some anonymous handwritten emails that showed up in the inbox of Laura McLaughlin as posted by Kyle Sharkey. Thank you, Kyle, for this. Dear Ms. McLaughlin. I don't know, it's not dated. Thank you for all your hard work, dedication, and time during this case of Karen Reed. Notice how this person their handwriting is all caps. I think a lot of Catholic school men write like this in all caps, right? Due to Turtle Boy having his riders hiding all over, I have not included my true name and address, or even my handwriting. Oh, so it's not your real handwriting? You had someone else write this for you, like a ransom note. Wow. Okay. I apologize for that. But please know I hold you and Mr. Lally in the highest regard. I only have a few ideas for your team after following the case. Oh, a few ideas. Here are the ideas. Lay some ideas on us, fake person. I'm surprised they didn't cut out like letters from like a magazine and like make words with the letters from the magazine, like in the 80s, the 80s hostage notes. Ms. Reed, do you usually, as a 40-year-old plus adult, call your father twice overnight if your boyfriend doesn't come home 25 to 45 minutes after you drop him off? Why, father? Oh my God, didn't Hank Brennan talk about that once in like open court? Some people have a good relationship with their parents. I don't know. Some people do. It's just crazy, isn't it? Tells a lot about the person who's writing this and their fake handwriting. Officer O'Keefe was malicious, meticulous. It's spelled wrong, so it looks like malicious. Meticulous. MATICOULOUS. Like, really, you couldn't even look up the word before you sent in this rando handwritten hostage letter to to who? Ms. McLaughlin. Oh, why is it that you wrote it to Ms. McLaughlin? Because you knew she was the keeper of all things secret? Officer O'Keefe was meticulous with his home, floors, security system, and especially his classic car. Oh, tell us more about the classic car. Hold, please. Pull up page 2. Especially his classic car. Okay, tell us more. Do you believe this rando giving advice to Ms. McLaughlin on how to try the case? And let's see how many of these things they actually used, okay? Why was the garage door wide open and even forced open during a blizzard? Perhaps broken by Karen? Oh my God, remember? Remember? Oh, I don't care if Vince thinks I'm ugly. I don't care if Vince thinks I'm ugly. But what I care about is Vince publishing my personal information on the internet. Oh, hi, Samantha. It's you. I don't care if he thinks I'm ugly. I mean, that guy needs to look in the mirror. But when he publishes my children's last name, my home address, posts pictures of my house showing my address, pictures of my garbage, and pictures of my children on the cesspool and Reddit or wherever the fuck he lives, then I got a problem. Okay? I got a problem with that. That's what I have a problem with. But thank you. I love you back, Samantha. May you never platform that monster again. Because he's not just done it to me, he's done it to a lot of other people too that don't want to talk about it. And he has a female law partner, which is wild to me. And the fact that he's a New York State barred attorney pulling this shit on the internet and thinks nobody knows that it's him is wild to me also. Like, you want to talk about ethics? Karen calls Kerry Roberts, and after all worries out of nowhere says John is dead. Why would she even think that? The freak out. Well, first of all, that's what Kerry Roberts said, she said. And then this person writes, and these are all asterisks, handwritten asterisks. Kerry is the case. Play all her calls to PD, hospital, etc. She wins. The last phone message is quick from Karen to John. I believe she says, "Oh, John, is that you?" When you get the full GPS Lexus data, it will show that she returned to the house, saw the body, made that call and message, proves she left him to suffer and lie there. That ends it. This person's got some really good advice, huh, to Laura McLaughlin. Match up the call, message, Lexus data, and it will show she was there. Then the car, SVU, I think it's supposed to say SUV, I don't know what the hell it says, that the plow driver saw was actually Karen's. She was there, then freaked, and wait, there's more. Yeah, Melanie After Dark started early today. I know. It's all day. It's Melanie all day, all the time. It's all Melanie all the time. I didn't think it was going to be this long, but a lot of things happened. Called Kerry, etc. Kerry is the key to this. Why Jackson didn't ask her a word. Oh, yeah. Remember, she wasn't cross-examined in trial number 1. Remember? Are you smarter than a 5th grader? Are you smarter than a 5th grader? Proved she returned to the house and all the other theories end. Look how theories is spelled. Teories. Oh, is it Buchanan sending this letter? Get her father on the stand. His phone or brother's will have a photo of the taillight. Question mark. Ask the Alberts. During a blizzard, winter season in Massachusetts, older home with older windows changed to heavy drapes. Darker material to keep out the cold and early sun. Ask her about her winter drapes. That isolates all sound. Who? Her who? Karen's not taking the stand. What are you talking about? Another unhinged lunatic. Oh, but here comes. The regular, larger courtroom is your gold standard space. Please, please don't let Hollywood influence the judge and allow the case to be in the small room again. Too bad. Wait, there's more. Wait, so, but this says that they're telling them to put it in the bigger courtroom. Hold on. Too bad. Is our courthouse, and it has all the modern aspects. Don't let the one who is up on charges decide. So it's our courthouse. We know this person lives in Norfolk County. We can use context clues. You might have tried to hide your handwriting or disguise your handwriting and not tell anyone your name in your letter to Laura McLaughlin. But we know it's your courthouse, so you live in Norfolk County. Finally, take a photo at night from the front door or driveway to show how far the body was and how dark that corner is. Thank you for all your service. You and Adam Lally are what we should all strive to be in life. P.S. Why did she think snowplow? Why not that a car? What changed from thinking he was sleeping with the dance teacher to dead? Oh, wait a second. How does this person know that Bella's mom is a dance teacher? Hold on. This person knows Bella's mom. Has it ever even come out that Bella's mom was a dance teacher? Oh, you're giving yourself away. You're giving yourself away. What changed from thinking he was sleeping with the dance teacher to dead? And if she claims to leave him at Albert's door, why 10 minutes later she's calling him a pervert? I mean, hold on, because I don't know if there's another page to this, but if I wonder if it says XOXO. No, I think that's the final page. Well done to you. Well done to you. But it doesn't matter because you know what? Judge Gildea is believing random stuff that he gets off the internet too, that people send him. So I don't know. Is it the same person? Did they write Judge Gildea an email also and in their not real handwriting? Seems that way. Fishtastic. Fish fits. Melanie, when I first got here and you said you've been a lawyer for 30 years, I must spit on my drink because I thought you were in your 30s. Nah, it's a good ring light. And like side lighting, backlighting, it's all the thing. Thank you very much, Susan, for your compliments, for tuning in from Canada, and for your super chat. I love you with all of my heart. Thank you to 2 minutes for becoming a member. And Sassy Dust Diary says, appreciate you for all you do. You work hard for your chat. I know. We try. Notice how the trolls backed off after Loopy was called out? Notice? I did. All right, guys, I think it's time for me to wrap it up in a bow. Tell me, please comment below. Please hype the stream if you can. Please share it out. This has been 6 hours and 15 minutes of glory. Now I got to go back and timestamp everything. Give me a few minutes on that because it takes a minute for me to do that. But I will do it for you. I promise. Stop the insanity. The insanity continues. We're here for it. There's going to be a season 4. I'm pretty sure. I'm sorry, honeys, but it's been over 6 hours, and I'm getting hungry. Hold on. You know, my mother always told me to write thank you notes to everyone, so I have to make sure that I properly thank every single person. And I think I did. If I missed your super chat, accept my heartfelt apologies. But it's been a very long one today. It's been a very long one, Lisa. I think I thanked you for your Venmo. And also, I think I got all the matchas. But, you know, I'm here all weekend, so no worries. No big whoops, no worries. Oh, wait, there is one other thing that I wanted to point out to you. One of my amazing mods found this. Hang on a second. Because this is crazy. Maybe not so coincidental. Because, you know, we're all conspiracy theorists here, and we're all wearing tinfoil hats and shit. But there was a fire. Did anybody see this? There was a fire at a Massachusetts auction site. 60 vehicles. Let me see if I can open this somehow. I haven't had a chance to look into this more deeply, but I know that you guys will. So hang on a second. It'll be interesting to see if there's a log somewhere of all the vehicles that were destroyed. But NBC 10 reported on Facebook, I think yesterday, dozens of cars were destroyed by a large fire at a Massachusetts auction site. 60 vehicles were burned in this fire. Do you think there might have been a Ford Edge in there? I don't know. I'm just tossing it out. They're just spitballing with you. Think there might have been a Ford Edge in this fire? I don't know. It's crazy, right? I'll have to look into that a little bit more, but maybe you guys will, because, you know, you guys do the Lord's work. Always. Rhonda says, please keep your animals safe with all the fireworks going off when you take them outside. Yes, please do. Please do. The puppies don't like it. Swift Kelsey wedding update. Page 6 showed Mike Vrabel and his wife Jen headed to their wedding at MSG. Oh, that's interesting. I heard there's some body cam of Diana Rossini. I have to get into that too. Oh yeah, I gotta go stalk the tubes of you live cams for the Swift Kelsey wedding update. I'm gonna see you this weekend, so don't worry. But Baze Mom, thank you for your super sticker and thanks Music to My Soul. I will be on, just to remind you, if you don't catch me again this weekend, because you know you got better things to do like barbecue or whatever, parties. I will be on Billy Bush on Monday at noon Eastern to debrief Taylor Swift's wedding and all things Karen Reed. Okay. All right. Wait, what? Wait, hold on. Somebody sent me an article of it looks like Vince, loophole lawyer Vincent Mbisi with their children on a cruise. I don't even know when this is from. They lost their backpacks and their passports one time and were able to get back on a cruise. And this was like news somewhere at some point. Oh my God, I got to look into this. Wow. Just wow. Megan loves when I'm on Billy Bush. Did you see the prom picture that somebody made? It's hilarious. Chewy says, it's likely a setup, like the email sent to Turtle Boy. We know they like to try that trap. So Proctor's buds know the information in the filing. Email the judge to alert him and sit back. I mean, a lot of people think that. We're allowed to have our thoughts and opinions, aren't we? I mean, it's not 100% Gilead yet, is it? Maybe, just maybe. All right, you guys, I love you all with all of my heart. If I don't see you soon, am I going to die? I got a lot of like homework to do in addition to all the time stamping, etc. But please do all of the things that YouTube likes. You know what they are. Like, subscribe, share the video, comment respectfully afterwards. Have your notifications set so that you can be here next time I go live, which will be over the weekend because you know I can't stay away from you for too long. And I said, stay cool, stay kind, stay classy. Have an amazing 4th of July. God bless America. We forgot our affirmation for a badass today, didn't we? I think we did. Hold on. Well, let's pull one. God bless America. I did watch Kelsey's podcast. I think I watched the whole thing. It was good. I liked it a lot. Her and Courtney did a thing. All right, ready? Here's your badass affirmation of the day. It comes from this deck, Affirmations for a Badass. Start where you are, use what you have, do what you can. Start where you are, use what you have, do what you can. There it is. God bless America. Thank you, moderators, for hanging in there today. I know it's a long one, and I know you're doing the Lord's work by getting rid of all the trolls, even though we think it's just one person. You never know what's going to happen. There could be so much more news that I need to share with you because some people need to be put on blast. I love you so much. Thank you for sharing your day with me. All 6 hours and 21 minutes of it. And it wasn't even a trial day today. It was a holiday. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. And I can't wait to see which portions of this stream they clip today and try and post all over the interwebs. But, you know, who cares? Who cares? I'm 60. Own it. 60 is the new 40. And there's a lot of people out there who are disparaging my looks, who apparently have not looked in the mirror in a very, very long time. And it shows. It shows. I don't know if maybe I should do a members only petty. I don't know. We're going to have to see. I love you guys. I'm going to see you real soon. There's a barbecue happening in my backyard. So I will talk to you soon. Peace out. Hold on. Let's let the SS Cupcake play us out today. All right. Thank you to Toy Box Media. TOI Box Media made this special troll video. A lot of Easter eggs in here, including Grateful Dead stuff and Block Island stuff and the trolls. And I think it's particularly relevant today. So go give Toy Box Media, TOI Box Media, here's her channel right there, a like and a sub. And this is the Attorney Melanie Little SS Cupcake Yacht Club, because another troll out there attributed some quotes to another YouTuber who's a friend of mine about me bragging about having some yacht. I don't know. We make merch. That's what we do. There's some cool merch that I'm going to link. That is not my merch, but there's an anthropology cap that says Cape Cod Yacht Society is one of them. And then there's another one that says, I'll meet you on the yacht, from Anthropology. They're adorable. I'll link them to the stream along with some other things. Thank you, Toy, for making this for me. You're amazing. You guys are all amazing. I love you all. And I'll see you.
Ahoy! Welcome to the SS Cupcake Yacht Club. All aboard! SS Cupcake, steady vibes on love already. Floating honest on sea so sweet. Smooth and clean, I don't know what I mean. We're cruising. Gotta trust. Yeah. Say it loud. Make it chatty, yeah. Galley crew, we I love you. Today Satan, oh no, yeah. No. Overruled. Keep it moving. If not, there's a special spot for you. Block Island. Already got a speedy ride for you on the SS ship of fools. Bye-bye. Yada, 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 yada.